Good morning and welcome to the Senate Judiciary Committee meeting of April 7th, 2022. We're going to start the day by opening the public hearing on House Bill 629 FN and recognizing the prime sponsor, Representative McGuire. Thank you. Good morning, Representative.
Good morning, Madam Chair, Senators. I'm Carol McGuire, representing Merrimack District 29, which is the towns of Allenstown, Epsom, and Pittsfield. And House Bill 629 is a very simple bill to legalize the personal use and ownership of cannabis. It also allows a limited amount of home grow, but it does not allow for any commercial sales of any sort. It maintains the existing crimes of driving under the influence, possession with the intent to sell, and providing cannabis to children. Those are the things that most people were concerned with about it, about the legalization of cannabis, and this does not affect that status in any way. There is also no taxes or fees involved because there is no state regulation. There are no retail sales specified or allowed, and therefore the state doesn't need to get involved. The only costs that I can see are probably some light rulemaking here and there, and a probable decrease in police efforts and court efforts to penalize simple possession. And that's all I want to say.
Okay, thank you very much for your testimony. Are there questions from the committee? Senator French.
Good morning.
Senator French. But okay, thanks. Does this, so it's 3/4 of an ounce. How many plants?
6.
6 plants, which could be, so that those aren't 6 plants. So 6 mature plants, would that come to more than?
6 plants with 3 or fewer being mature.
Okay. And that would come under this restriction of 3/4 of an ounce?
Yes, it's under the personal use, yes.
Okay,
The 3/4 of an ounce excludes growing plants.
okay.
But once
Thank
you harvest, it's in the allowance.
Thank you very much.
Are there any further questions? Seeing none, thank you very much,
Okay, thank you.
Representative. Representative Gallagher, you had written down here, if time, do you have the time it's today?
Yeah, I do. I was just at my own hearing at 10 a.m. So I didn't know how long this would go. Just there were a lot of people before me. So yeah, I'm Representative Eric Gallagher. I represent Merrimack County District 15. That's Concord Ward 6. I'm here to testify in support of this bill. I've received contact from constituents indicating that this is an important bill to them, and I want to do right by them and represent their will. So I'm just here to relay the level of support I've been seeing for it from my own district, and that's pretty much it.
Thank you very much for your testimony, Representative. Are there any questions from the committee? Seeing none, thank you very much.
All right, thanks.
Okay, let's see. I want to make sure. Okay. I have Sheriff Myers and from AFP as well as Ross Connolly. Would you two like to come up together?
We were going to be separate.
You're separate. Okay, that's fine. Good morning.
Good morning. Pleasure to be here.
My name's Curry Myers. I'm a retired sheriff from Johnson County, Kansas. So came out to visit with you. I serve as a criminal justice public policy advisor for Americans for Prosperity, and have done so for approximately a year. I'm also a college professor. I teach criminology at Benedictine College. Johnson County is one of the largest sheriff's offices in the Midwest. The sheriff here might be a little different than in the Midwest. The sheriff's office there, I had 750 sworn deputies, pretty large organization, one of the largest ones in the Midwest, serving a population of about 650,000 folks. So we're the largest populated county in the Kansas City metropolitan area. I started my career and spent most of my law enforcement as a Kansas Bureau of Investigation special agent, investigating drug cases, major drug cases, homicides, public corruption, police corruption, and started my career as a state trooper stationed in Kansas City, so very familiar with car stops and arrests that are done by law enforcement every day out on the street. One of the reasons I'm here is I really want to try to focus law enforcement's efforts on violent crime and away from smaller criminal actions such as fines and small misdemeanors. Right now we're seeing clearance rates in the United States for murder is only 54%. For things like rape is only 30%. Burglaries and theft are even down around 15 to 12%. These are major offenses. I don't know if any of you have ever been a victim of any of these crimes. Many of us have been a victim of burglaries or theft. And it's very frustrating when we're not able to have clearances of those cases with respect to law enforcement resources, because we're getting thinner and thinner in our resources. As a matter of fact, law enforcement today is suffering from recruitment issues and problems, which makes us dedicate and have to be really careful with our resources the way they are. Ultimately, it takes resources away when we're dedicating resources to minor cannabis violations. And in fact, New Hampshire already has cannabis law on its books, and you're surrounded by states that have it. And so the correlation between crime as a result of the states that are around that have cannabis and already have cannabis in this area, we really haven't seen, or the data suggests that we haven't seen an increase in crime that is directly causal related to marijuana use. In fact, recently in Manchester, I believe it was last year, and it just came out, I believe in March of this year, where Manchester police chief said that they've had a reduction in violent crime. So when you have marijuana that's already on the books here in New Hampshire, and you have other states that have marijuana, we're just not seeing the kind of causal increase in crime that would be associated specifically to cannabis. There are other reasons why you have crime occurring, and it's not everything, correlation does not necessarily mean causation when you're trying to put statistics together in these particular areas. Impaired driving is another issue that law enforcement has concerns with. I do too. The big issue on driving is that law enforcement, when they see somebody out on the street, is going to stop somebody because they see somebody doing something that is illegal, some sort of probable cause stop. So it could be a speeding, it could be a failure to maintain a single lane of traffic. Those are the reasons why law enforcement stop people. It's not because they may be under the influence of a drug, because you don't know that yet. So the reason you're stopping someone is because you think that they may be under the influence based on the traffic patterns that they're doing. Once you make that stop, the officer is going to do an assessment to make sure that person isn't under the influence of alcohol or drugs. Marijuana is not any different than alcohol when it comes to motor skills. If someone's under the influence, severely under the influence of marijuana, they're going to fail a gaze nystagmus test, which is a test that's done by law enforcement out in the field. They're going to fail walk and turn. They're going to have speech impediments. They're going to have route planning issues. There's going to be many issues that is going to be noted in the field sobriety test that would be noted with alcohol. Now, it's true that you're not going to get a BAC, and I'm somewhat dating myself because I started out as a state trooper before we had immediate BAC. So we had to make our arrest determination based on probable cause that was done out in the field, and later on the arrest was confirmed by someone who might be under the influence of a particular drug. We have to remember that marijuana can stay in the system for up to 30 days. One of the solutions that could be done is that we need more officers that are trained in drug recognition. That can be done by officers to make sure that they understand the growing use of marijuana across this country. We have many, many states now that have developed some sort of regulation when it comes to cannabis legislation. Even in my own state right now, like you all, they're considering medical cannabis in the state of Kansas right now. Next door to us is the state of Missouri, where they pass medical marijuana, and they have not seen any significant issues associated with rise in crime associated with the implementation of medical marijuana in the state of Missouri. In fact, Missouri regulates that, and in order to keep the black market out, which is something that I believe all of us want to do, you have to be careful about how you regulate cannabis. You can over-regulate it and overtax it, which causes a black market to occur, like California has done. And conversely, in states like Oklahoma that has medical cannabis, you can under-regulate it. And where it could drive the black market. So being very careful from a legislative position on how you handle those things and make sure that you watch excise taxes, watch regulations to make sure they can be kept in tow. Most law enforcement, I would agree with that. We want standards and practices. We want quality control associated with what is sold, because it's not being done right now. When you buy it illegally out on the street, you have no idea what you're buying. So those are the concerns that a lot of law enforcement is going to have. Also, more and more law enforcement across the country. Some recent data shows that about 2/3 of law enforcement officers are okay with some sort of marijuana reform. And in many cases, medical marijuana or recreational marijuana, more and more officers are supportive of. There's over 70% of the population, I believe that's even the same way in this state, are supportive of medical or of marijuana at some point. And law enforcement is a mirror reflection of the society in which we serve. That's what I tell people every day. So law enforcement's in a position to help advise and counsel the legislature and tell them the things that they need if legislation passes. But we just have to be careful about conflating data to make sure it doesn't support any particular agendas. And that's the way it should be on both sides. Privileged to be here today.
Thank you very much, and welcome to New Hampshire.
Thank you.
Are there any questions from the committee? Seeing none, thank you very much.
Thank you.
The chair will call Ross Connolly.
Thank you, Madam Chair, members of the committee, for holding this hearing today. Just for the record, my name is Ross Connolly. I'm the Deputy State Director for Americans for Prosperity in New Hampshire. I'm here today to voice our support for HB 629. As we know, New Hampshire is surrounded currently by 3 states and 1 nation that has decided to legalize recreational use of cannabis. By the end of this year, there will be a cannabis recreational store on every border of New Hampshire. This bill avoids much of the controversy and debate by excluding the creation of a regulatory market and retail sales. Instead, this bill simply recognizes the reality that we're living in, where over 100,000 Granite Staters currently, as we are in a decriminalized quasi-illegal market, that they're currently using cannabis. HB 629, in our view, completes the work that decriminalization began, which is to stop treating cannabis users as criminals and avoiding the consequences that comes with prohibition. Some of those collateral consequences that come from cannabis prohibition have resulted in massive damage to New Hampshire families, communities, the economy, and probably most importantly, the public trust in our justice system. We view this bill would go a long way towards improving public trust with law enforcement, since over 70% of Granite Staters support having recreational cannabis legalized for adults, according to multiple polls. Such a divide between law enforcement and public opinion is a recipe for the distrust that we see today, and we view that this must be corrected to ensure our justice system has that trust to carry out what we view as the absolute critical business of keeping Granite Staters safe and upholding the law. And I just want to be very clear, we are not saying that cannabis is good for you, that everyone should go out and do it. All we're saying is that the consequences of prohibition are far worse than having a legal cannabis market or legalizing cannabis for adult possession. This bill is a compromise. It does not set up, once again, it does not set up a commercial market. It instead takes the sensible step to remove penalties so that we end Granite Staters being arrested for going sometimes just a couple miles over a border to a store in Massachusetts, Maine, or Vermont, and coming back home and possibly facing consequences because they might be over an arbitrary 3/4 of an ounce decriminalized limit. It also, as has been mentioned, allows for home cultivation of 3 mature plants and 3 seedlings. We understand that this part of the bill is a bit controversial for this body, and we suggest and we hope that it's considered to at least legalize possession for adults in New Hampshire. That we can tackle home grow or retail market at some other point, but the most immediate problem is that there are over almost 1,500 individuals have been arrested and prosecuted for cannabis possession in New Hampshire in 2020, the most recent data that we have. And this has massive consequences. You can lose student loan funding, you can lose housing, you can lose employment. And this is something that we view as being just incredibly burdensome and onerous in this current situation where we're surrounded by these legal states. So legalizing possession, I would suggest for up to 2 ounces. That's what the sales in Massachusetts are. Just so we end that consequence and that punishment for these people who are members of our communities, your constituents, and people who are just trying to contribute to the state and not break the law intentionally. So for those reasons, we urge the committee to move this bill ought to pass, but also to consider our proposal of at least legalizing the just possession of cannabis for adults.
Thank you very much for your testimony, Mr. Connolly. Are there any questions from the committee? Senator French, then Senator Gannon.
Thank you, Madam Chair. And thank you for testifying today. So I was curious, did you say there were 1,500 arrests for possession of marijuana in 2020? And was that for over 3/4 of an ounce?
Thank you for the question, Senator. Yes, it would be 1,500 in excess of the decriminalized limit is my understanding.
And and what were the charges? Were they Class A misdemeanors? Were they felony charges brought? What were they?
So if you are over the decriminalized limit, it would be a Class A misdemeanor. I can't comment on every single case, obviously. There might be other factors, but.
And just one more.
Follow-up?
Thank you. And I'm under the understanding that if you are convicted of a misdemeanor in the States, are you still prohibited from ever visiting Canada? Do you know?
Thank you for the question, Senator. I do not know.
I know with DWIs, you cannot go to Canada, I understand. I didn't know if it was the same with misdemeanors for possession.
I'm not sure. I'd be happy to follow up with you and get that
Thank you.
information for you.
Okay. Oh, we're all set. Are there any further questions? Okay, seeing none, thank you very much.
Thank you.
Next, we'll call Matt Simon.
Good morning, Madam Chair, Senators. Good to see you. For the record, my name is Matt Simon. I live in Manchester. I currently represent Prime Alternative Treatment Center. We are a New Hampshire not-for-profit therapeutic cannabis alternative treatment center with a production facility in Peterborough and dispensaries in Merrimack and Chichester. And as you know, I'm also a longtime advocate for cannabis legalization. So, as I've said many times in the past, there are two. When we're talking about cannabis legalization, we're actually talking about two different issues. One is criminal justice reform, legalizing possession for adults, and the other is setting up a regulated market. The first of those two is very simple. The second is very complicated. This bill only deals with the first of those two issues, leaving the other issues for other legislation. So as you've already heard, cannabis is legal in all neighboring jurisdictions. So I see this as a bill that simply intends to put New Hampshire cannabis possession and cultivation policies more nearly into line with neighboring jurisdictions. So this has been the first step in the legalization process in all three neighboring states. And I think it's the least that we should be doing in New Hampshire in reflection of public opinion and all the other reasons to do this. So three simple reasons that I believe this should be supported. One is that many granite staters and visitors to New Hampshire bring cannabis that they purchased in other states or that they obtain from other sources. And it's simply inhospitable to fine or arrest people who are visiting our state or who live here for using a substance that we ought to know by now is less harmful than alcohol. Home cultivation is currently a felony in New Hampshire. We feel strongly that this should be a legal option for adults and especially for the patients that we serve, many of whom have difficulty being able to afford a consistent supply of therapeutic cannabis. And the third point, in light of public opinion, it seems clear that fining and arresting adults for cannabis is not a legitimate function of government and should not be done. Thank you. I'd be happy to answer any questions.
Thank you very much for your testimony this morning. Are there any questions from the committee? Seeing none, thank you.
Thank you.
Mr. Ames and Mr. Clarkson, you're both from the New Hampshire Cannabis Association. Would you like to come up together? You'll be separate, okay. So since you both represent the same organization, I'm going to give you 3 minutes each, okay?
I don't even think I'll need that much time, so thank you.
Thank you.
For the record, my name is Daryl Eames. I'm the founder of the New Hampshire Cannabis Association, and although our focus is around jobs and investment and entrepreneurship, we understand this bill addresses none of that, and yet we are still here in support of it. I'm also a Granite Stater born and raised, and it occurs to me that nobody cares how much beer that you have in your house. You could order a truck full of kegs delivered. Nobody cares how much hard alcohol you have at your bar at home. And you could go online right now and order as many cases of wine delivered to your door as you like. We see this bill as a minimum that should be done this year. We'd like to see this come out with an ought to pass recommendation. In our opinion, in my opinion as a resident, it's very conservative, almost inconsequential. It does allow for, I think, a minimum amount of possession so that we can stop arresting people, we can be more hospitable to those that come in. And I would also say that it's not as easy to grow a cannabis plant as people think and get the actual usable flower as the end result. You can't just throw it in dirt and put it next to a window and 4 months later you have a usable product. So the people who tend to grow it are either enthusiasts who want to prove that they can, people who are conscious about what they're ingesting and they want to make sure they know everything that goes into it, or perhaps they're a medical patient who does have some financial difficulties. So we would really encourage the committee to hear the 70–80% of people who want legalization in the state of New Hampshire, and we certainly would encourage the full Senate to pass it with a veto-proof majority. Thank you.
Thank you very much for your testimony, Mr. Ames. Are there any questions from the committee? Seeing none, thank you.
Thank you.
The chair will call Clarkson. Good morning, Mr. Clarkson.
Good morning, y'all. My name is Clay Clarkson, and I'm a founder of Cannabis and Honey. It's a company that's indigenous and Black owned. I support the passing of HB 629. This bill allows cannabis consumers and supporters to be a part of New Hampshire's workforce. One reason is I'm a young entrepreneur who harbors technology that advances the cannabis culinary market. My technology supports the ideology of stay, work, play, and helps create more high-end tech jobs in New Hampshire. In short, I invented thermally stable cannabis products. This technology enables a way to cook with cannabis without the worry of blowing off its active components. My company's products include everything from cooking oils, flours, seasonings, and more. And one day I hope to see the restaurants and grocery stores selling these products. But first, we need to loosen the laws regarding cannabis. Cannabis culinary ingredients should be treated just like alcohol and be available at your local convenience. And just like alcoholic products and any other regulated product, cannabis businesses need to follow high quality and strict scientific standards to ensure accurate labeling and high quality control. These standards need to be equivalent to those of FDA and international standards. This is ultimately the direction that I'm advocating for.
Thank you very much for your testimony, Mr. Clarkson. Are there any questions from the committee? Seeing none, thank you. The chair will call Heather Marie Brown.
Good morning. Thank you so much for being here for this hearing. I really appreciate it. For the record, my name is Heather Marie Brown. I am the co-chairman for the New Hampshire Therapeutic Cannabis Medical Oversight Board. I actually am the one member of the board that was placed legislatively in response to representing every patient within the state of New Hampshire. I am here on my own to support this bill in its entirety. I believe that the passage of this bill will allow for the necessary changes that need to be made to the therapeutic cannabis program that would open up accessibility and affordability, which are two major issues that the Medical Oversight Board has been working on for quite some time. We all know that therapeutic cannabis patients, they unfortunately, because of dispensary costs associated with production, manufacturing, and so forth, regulations put on them by the state currently, that the cannabis produced is not affordable for all patients. Therefore, it creates a blockage to accessibility. By allowing this bill to pass and allowing home grow to happen, it will create the avenue needed in order to allow home grow to include medical patients as well. And again, not every medical patient, just like not every resident in the state of New Hampshire, is going to take the leap and attempt to grow cannabis. There actually would be a rather small number of patients that would attempt this feat. But that small number of patients, it would increase that accessibility, it would increase that affordability, it would increase their ability to treat their ailments and so forth in a much better capacity than what the dispensaries currently do. The dispensaries do an absolutely wonderful job, and I commend them for their attempts, but honestly, their hands are tied in a lot of situations when it comes to one's choice in personal health care. This bill is an important first step forward, not only for every citizen in the state of New Hampshire, but also for the medical cannabis program. I think that this bill is, I will agree, it is very conservative in nature. It's very easygoing. These are simple requests. These are minor changes, but these minor changes can have such a meaningful impact on the citizens of New Hampshire, plus relieve the stress and pressure put on at the state level and at law enforcement level as well. One of the things I'm hoping to be able to accomplish with the Medical Oversight Board is that I had discovered that police standards and training does not train their officers in regards to therapeutic cannabis or the laws or anything else associated with it. So there is a disconnect sometimes that goes on between law enforcement and cannabis users. I think that with the passage of this bill, that it would alleviate a lot of those issues and a lot of that disconnect caused between law enforcement and the common citizen, along with therapeutic cannabis patients. I had heard earlier there were still 1,500 arrests, even though decriminalization happened. I would say that if there was something I would change in this bill, it would be the amount of cannabis one is allowed to possess. Because even with decriminalization, I had spoken about the impact of 3/4 of an ounce being the allowance. Because unfortunately, I know a few of those people that were arrested, and they were arrested because they had an ounce. Because nobody goes out and gets 3/4 of an ounce. You get an ounce. I had always felt that with decrim, that was intentionally put in there has a kind of catch you, has kind of like an entrapment feature, and I was never for that. So I do believe that the amounts should be increased, and I think that we should fall in line more with the states around us. I will also say that a few weeks ago, a recreational dispensary opened up in Lebanon, Maine. I went to see this dispensary. I literally stood on the bridge in Rochester, New Hampshire, and threw a rock and hit the building. And I will tell you, out of the 25 cars that were in that parking lot, 22 of them were New Hampshire plates. We should not be encouraging New Hampshire residents to seek and risk interstate travel restrictions and problems. We should be encouraging them to stay here, to be able to use their cannabis, to be able to grow their own cannabis, and to keep them ultimately safer at the end of the day. I do hope that you will vote this bill out to pass. I am willing to accept it as it is. Again, if I had to make any changes, I would say I would increase the amount of possession allowed. But other than that, I think this is an absolutely wonderful attempt. I think that it is time for New Hampshire to actually see this happen. And I think that you all are in a wonderful position to help promote and move this particular bill forward. This would allow the state the necessary time needed after the passage of this bill and the implementation of it into law to be able to really sit down and tackle the issue on sales and distribution throughout the state. Because currently, there is nothing that has been presented that offers a good, viable option that would promote positive economic growth for New Hampshire citizens within the state. We need the time to sit back and figure that structure out. But legalizing this cannabis and home grow now will allow the state the necessary time to investigate and come up with a much more reasonable plan as to how we are going to implement those systems. So I thank you. I appreciate your time. And if there are any questions, I would be more than willing to answer them.
Thank you very much for your testimony. Are there any questions? Senator Gannon, Senator French?
Go ahead,
Thank you,
Senator French.
thank you, Madam Chair. And just a couple of questions. Patients can, therapeutic cannabis patients buy an ounce or more at a time?
Yes, we are currently allowed to purchase up to 2 ounces of cannabis every 10 days. So in a month period, we could, in theory, purchase 6 ounces of cannabis. We are not allowed to possess any more than 2 ounces of cannabis.
And do you think passing this would end the need for therapeutic cannabis?
I do not think that passing this would end the need for it. I truly have always believed that the therapeutic cannabis program is needed because there are individuals that access this program that are going to need the education, the information, and the protections provided by the therapeutic cannabis program. It really is a very small number of people that would quote unquote possibly jump ship. The thousands and thousands of individuals that need the counseling, that need the education, that need to be able to go into a medical facility and sit down with someone and say, okay, this is what I'm dealing with. What is it do you think we could do to try and make this better for myself? That is not knowledge that is common to everyone. That is, comes from years of education and research and so forth. Patients need that. Patients want that, but they also want to increase accessibility and affordability. One of the things I had brought up last night in our oversight board meeting is that doing something like this would also open the possibility of allowing patients to use, or even common citizens, to be able to use our labs that we have that are currently testing therapeutic cannabis so that they can test their own cannabis that they are growing and producing so that they can have the safety and the peace of mind to know that what they are producing is going to be safe and effective for them. Currently, no one's allowed to use that lab other than the dispensaries. That's a big disservice. This bill would allow so many other options to happen within the world of cannabis for the state of New Hampshire, both adult use and therapeutically. It's time that New Hampshire, that we start working together in a collaborative fashion and doing the best that we can for all of our citizens, not just one particular group, not just picking and choosing.
Great, thank you.
Senator Gannon?
Just two quick questions, and I was late, so I missed the first few speakers. But the few I've heard have mentioned that 1,500 number arrested within a time frame. Does that include impaired drivers, or is that just possession?
Honestly, I am not 100% sure about
That would
that.
be a huge difference for me if you have a lot of impaired drivers then.
No, I completely understand. Unfortunately, me being the common citizen, it is a little
okay.
more difficult
Sure.
trying to get specific information on that.
I have a question, then you can answer.
Yeah.
I think you can. So if I got cancer, God forbid, or someone I know, I'm going to be really happy sending them to Matt Simon's therapeutic place if that's what they want to use, because I know he's going to treat it like a medicine. He'll know the strength and what he's prescribing. So I'm very confident in that for medical purposes. I'm not so. Are you worried then that people are going to use it as a medication, what they grow or what their neighbor gives them, and they're not really getting a product that's there to help them? Water down the therapeutic industry?
No, I actually do not, because I believe that this would open the doors to be able to create a collaborative relationship between, a larger collaborative relationship between cannabis patients and the dispensaries, and honestly, common citizens. I believe that there could be changes made to the system that would allow dispensaries to go into a sort of retail system where they could provide seeds, they could create educational classes, they could provide clones, they could do so much to help with this particular situation. And I believe that people would definitely take advantage of that. And again, like I said, I believe that by implementing something like this and getting the ball rolling, that it would also allow for changes made to who can and cannot access the labs for testing capabilities of their cannabis. I think if you give people the tools, that they will use them.
Thank you.
Are there any further questions? I just have a couple of questions because one question really, because when I read the bill, I didn't see anything that dealt with how a person is going to get a plant, whether it's a seedling or get seeds. So how do you envision someone actually getting this material?
Well, if I could be frank,
No, please, please.
seeds are available everywhere. You can order seeds online. You can travel just 5 minutes across the border and pick up genetics. Seeds are not difficult to come by. On a previous home grow bill, I had actually done some of the math, and it literally would have cost me $150 to buy the supplies needed to produce enough cannabis in a season to support my medical needs for 6 months, which to me would have been a savings of over $8,000. So again, allowing something like this would allow for changes at the therapeutic level as well. I would be more than comfortable being able to work with my dispensaries in regards to using their valuable knowledge on how to pick out appropriate strains and genetics that would be most beneficial to me. I know for a fact that all 3 dispensaries have supported home grow in the past medically. I would be surprised if they weren't willing to, all 3 of them, stand up and support this for adult use as well, because the possibilities are really endless at the collaborative relationship that we can build, that it would make the program and make the presence of cannabis a better, safer, more affordable, accessible option within the state, while alleviating a lot of the crime associated with it still to this day.
Thank you. Are there any further questions? Senator Gannon.
Do you have any concerns if you have marijuana in the house with children's access to it, children seeing it used by their parents, knowing it's there? Do you think it's going to increase to childhood use, having it in the homes so available and so seen as widely accepted?
Well, again, if I can be blunt and frank,
Be blunt.
I am a mother of 3. I have never hid the fact that I am a cannabis user from them, because I did not want my children to be ashamed of the choices that I made that actually allowed me to participate in their lives as a functioning member of society. I have educated my children. I have a young one. My children currently range from 25 to age 9. My 9-year-old, I have brought him up on a system. Even though everything I have ever had in my home, I do not sit down and use in front of my children, and everything I have in my home is kept under lock and key and secure. Children are children. They will ultimately find things. They will ultimately stumble upon something. The more you keep it taboo and the more you say no, 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 without an explanation or an education behind it, I believe that's where the problems arise and created. I think that by passing this bill, it will decrease the stigma associated with cannabis use in the state. It will allow parents to have those open conversations and communications with their children, ultimately providing them with better education. My 25-year-old daughter to this day still does not use any form of substance whatsoever. I truly believe that had I hid what I was doing and just tried to keep it secret, it would have created more of an allure behind it. And it's the same with my middle child. And my son, we have a I have actually developed a picture system with him. So, you know, one of the things I hate is that we're not allowed to use cannabis leaves for advertising and so forth. That has been the biggest ally for me in educating my child, because every time I bring a product into my home, I have a cannabis leaf sticker. I put that sticker on that product. I sit down with my son. I show it to him. I say, "What is this?" And he says, "That is adult medicine." I said, "Are you supposed to touch it?" "No, I'm not, Mummy. That's for big people. That's for adults." "You're absolutely right, darling." But if it didn't have that sticker on it, he may become confused, and then there could be some sort of risk or potential. So, you know, that's a system I've developed. I know several other parents that are cannabis users that have other similar systems. I believe, again, once you open it up and you're able to decrease the stigma, you're able to create more educational opportunities, which in turn will deter children from following down the wrong path.
Last follow-up, I'll be
Last
really
follow-up.
quick. So now, let's say this goes through, we legalize. Now they're gonna be selling it at every grocery store. So every little 5, 6, 7, and 8-year-old is gonna see it on the shelves. And you think it's an educational tool as opposed to, you know, putting in front of them and so exposing them to another thing that other parents wouldn't rather shown. So would you mind it being not in front of my kids? Or do you think it has a place on the shelf right there?
Well, I think that this bill doesn't allow for that currently.
Okay.
So I think that that is not a situation that would apply to this.
Okay.
But I will tell you that with the numbers of deaths and injuries associated and misuse and abuse of alcohol, we still have alcohol on the shelves in visual proximity to our children. I don't think that there is enough education provided around alcohol. I think that if you're going to, even though I hate comparing cannabis and alcohol to one another, I think that in this particular situation, if one is acceptable and we know that there is harm and that there is harm associated around that particular substance, then I don't see why it would be any different for cannabis, which currently to this day does not have deaths associated with its use. Strictly cannabis. I'm not talking about situationals around it. I'm saying that smoking a joint of cannabis has never killed anybody to this day. We have more deaths affiliated with romaine lettuce. So,
Last follow-up. So you'd exclude, though, you'd give me that it does include, there have been deaths from DUIs all across the country on the roads.
I think that there are particular situations where that may have occurred with overuse and abuse. Yes.
Okay.
I think so.
Okay, are there any further questions? Seeing none, thank you. Thank you very much for your testimony.
Thank you.
At this point, we are outside of our time, so what I'm going to do is ask everyone 3 minutes to testify. Please do not repeat things we've already heard. Please do not read. If you have written testimony, turn that testimony into the committee. We are not executing this bill today, so we will have plenty of an opportunity to read whatever you give us. So that being said, I'm going to call Frank Knack.
Madam Chair, members of the committee, thank you so much for the opportunity to testify today. My name is Frank Knack. I'm the policy director with the ACLU of New Hampshire. Senator Gannon, to your concern, which I completely, as a parent of 2 young children, completely agree with, just want to point you to some research that we cite in our fact sheet, as multiple studies have found no increase in youth use in states that have legalized, and also point you to one of the sites in our fact sheet, a study in the Journal of the American Medical Association back in 2019 found that recreational marijuana laws were associated with an 8% decrease in the odds of marijuana use, and a 9% decrease in the odds of frequent marijuana use by youth. Just want to talk about a few things that I think haven't been covered so far today. One is, we often talk about marijuana laws and the fact that people aren't going to jail anymore, which is, for the vast majority of people, true. But we don't often talk about the collateral harms of a marijuana conviction. If you're on student financial aid, when you get a marijuana conviction, you lose student financial aid. So all the kids on, UNH campus, if you get picked up for a marijuana arrest and you're convicted and you're on FAFSA loans, you lose that. You have to check the box on employment, check the box on housing. It can impact child custody decisions. And we also did an economic analysis back in 2013 that looked at all the costs that are associated with a marijuana arrest. So, a clerk, a judge, law enforcement, et cetera. And we found at the time that the 2,769 marijuana arrests in 2010 in New Hampshire were costing New Hampshire taxpayers about $6.5 million annually. And so we're about half that number of arrests right now. So we're spending about $3.25 million every year enforcing the mere possession. And I think the question around where the 1,500 possession number comes from, that's from FBI, UCR data. So that's what state agencies in New Hampshire are reporting to the FBI in terms of the number of marijuana possession arrests. And so that's just marijuana possession, not associated with DUI or anything like that. And also, we haven't really talked about the fact that there's a staggering racial, that marijuana laws are enforced with a staggering racial bias in New Hampshire. So marijuana is that perfect example of apples to apples comparisons because we know that Black people and white people use marijuana at roughly the same rate. Yet in New Hampshire, Black people are 4.8 times more likely to be arrested for marijuana possession. And that is up from 2.6 times more likely in 2010, so a 46% increase. And in cities like Manchester, they're 13.9 times more likely in 2020 data, or in Concord, 5.8 times more likely to be arrested. And finally, I think one of the concerns that we've heard from folks, legitimate concerns, is, will this have a negative impact on opioid-related deaths? We are in a crisis in our state and in our country. And again, evidence suggests that marijuana legalization is connected with a reduction, not an increase, a reduction in opioid-related deaths. So thank you for the opportunity to testify.
Thank you very much for your testimony. Are there questions from the committee? Senator Gannon.
10-second question, just on causality and minorities. Causality is a tough thing, you know that, right? Because there could be another factor that is, you're looking this way, but it's really coming from somewhere else. Yeah. Aren't the arrests way higher in cities because people are just more seen? They're out on their stoops, they're at the playground, they don't have big backyards to hide in, which we do in the suburbs. So do you not see that your causality argument may be wrong with minorities because the arrests are in cities proportionally way higher for everyone, and we have a higher proportional, the minority rate of living in cities is far higher?
I would think that would possibly be true if we didn't have such consistency everywhere on that issue. So the ACLU did a national report on this issue. There was disproportionality everywhere. And I think we had talked about this a little while back in this committee. When DC, they had actually plotted out all of the marijuana arrests. And so they were all on, 14th Street. They were all on the east side of 14th Street, not on the west side. So GW, Georgetown, American University, where people are smoking marijuana. And if you go there, you can smell it. There's no dots. All the dots were on the east side. So I think we do know that, there could be issues around, deployment issues, but I think the consistency of that is clear.
Are there any further questions? Okay, seeing none, thank you very much.
Thank you so much.
The chair will call Joe Hannon. Good morning, Mr. Hannon.
Good morning, Madam
We have
Chair.
3 minutes.
I'll go as quickly as I can.
Thank you.
Thank you all for being here this morning. There's a few things. One, my name is Joseph Hannon. I'm a former state rep, and I was also a public member of the New Hampshire Commission to Study the Legalization and Taxation of they call it marijuana, but cannabis. We spent a year studying it, and I'd be happy to answer any questions that you have about this issue, but I'd just like to talk about a few things about prohibition and some of its effects. The 18th Amendment was necessary to make alcohol illegal for the manufacture, sale, and transport. It did not prohibit possession or consumption of alcohol, as in comparison to the laws we have now for cannabis. That was repealed. It was the only amendment to the Constitution that has been successfully repealed in the 21st Amendment, 14 years later. We know there were a lot of negative consequences that happened. Prohibition brought us many things, from Al Capone to the Kennedys. One of my favorite quotes from Prohibition is, "Prohibition has brought nothing but trouble." And the funniest part about that quote is the person who said it. It was Al Capone. So if we want more illicit substances to be in the hands of criminal gangs, and whoever you may think is causing more crime or problems in society, we should leave it in their hands. But if we want people to be able to grow things at home, like a medicine, imagine being able to grow medicine at home and not have to pay some insurance company or some big pharmacy or corporation for it. That's possible. And you can do that in this legislation. Another thing that is kind of disturbing is our state constitution, I'm sure you're all aware, Article 18 says that all penalties ought to be proportioned to the nature of the offense. For possession for over 5 grams to a pound, the first offense is a felony. That can be punished by up to 7 years and a $100,000 fine. The second offense is up to 15 years and a $200,000 fine. According to 632A3 and 651-2 in New Hampshire state statute, felonious sexual assault is a Class B felony with up to 7 years in prison and a $4,000 fine. So if someone has over 5 grams to a pound, that's the same amount of time in prison and 20 times more money the fine for the first offense. I don't think that's just. I don't think that's proportioned. And I think that needs to change. And lastly, I'd like to say that, we already have, and you've heard this, we have home brew for alcohol and wine, 100 gallons a year for an individual, 200 gallons for 2 people of age in one household or more. That statute is actually called 175-5B for the production of beer and wine for personal or family use. That's 100 gallons a year for family use. So we're talking about just a few plants for personal use of cannabis consumption versus 100 gallons a year, almost 2 gallons a week for family use. So please, I implore you, this is a necessary piece of legislation to pass. It is the very least we can do. It is not commercialization, and it will make us a safer and more free state. Thank you.
Thank you very much for your testimony. Are there any questions? Okay, seeing none. Thank you very much.
Sure.
The chair will call Heather Stockwell. Okay, let me know when you're ready.
Ooh. Get here. Hi, can you hear me?
We can hear you
And you
fine.
can understand me?
Yep.
Awesome. I've been told I have a pretty loud voice sometimes. So I'm Heather Stockwell. I'm from Dublin, New Hampshire, and I work at Rights and Democracy and as the healthcare justice organizer as well as overdose crisis campaigns. I'd like to just start by saying that humans have used substances since the beginning of time and for various reasons, and some are medicinal, religious, spiritual, ritual, and some are even transformational. And knowing this, I'd like to think that we as a society could be more accepting and forgiving of people who use drugs instead of condemning and persecuting people, as this has shown that it does not work and actually is harmful to those struggling with chaotic drug use. I prefer this legislation over 1598 for legalization. And I believe that those two things should not, the sale and the legalization should not actually be tied together. I prefer this bill because I believe that it brings freedom, liberty, and equity, as well as the pursuit of happiness. And this should include the right not only to possess, but grow your own cannabis for personal adult use and processing that plant into flour, edibles, and other forms of ingestion. This legislation has reasonable requirements and limitations for adult use, and the bill is well thought out. It takes into consideration other New Hampshire state laws and licensure with the federal government. We've already heard about racial equity, and I do agree with what's been said here today and with the war on drugs that Joe just laid out. I also believe that this brings financial equity to people in lower income brackets who could benefit from using cannabis, and they may not want to get a medical card for multiple reasons. Retail and medicinal shops can be very expensive and out of reach financially for many people. So coming at this from a harm reduction perspective in terms of people who are struggling with substance use disorders, and in terms of our overdose crisis in New Hampshire, because I've heard a lot of relationship between those two things. And in working and having conversations with people who are struggling with this issue, this is a form, using cannabis is a form of harm reduction. Because we know that cannabis is less harmful, cannabis can be used in replacement of more harmful or even deadly substances. And many people struggling with SUDs report that they have reduced harm for themselves by using cannabis to overcome their addictions to those more harmful substances, such as opioids and alcohol, which could result in death. And while there are still some risks with using cannabis, we know that no one has ever overdosed, and therefore a reduction of harm. I'll stop there. If you have any questions, please.
Thank you very much for your testimony. I saw you reading from something. Would you like to submit that to our clerk, and that way we'll get.
It's not all full sentences, but sure. It's more of an outline, but.
We'll have everything.
Great, and then you can read about chronic pain.
That's okay, that's good.
Great.
Senator Gannon
Yeah.
has a
Second
question.
question, just
Please.
because I don't know.
Sure.
In the bill, it said you can have 6 plants, 3 that are mature. I don't know how long it takes for a plant to get mature would be one question. My second question would be a full plant. I've seen them on TV, but I don't know. How much can I produce? How many ounces of cannabis out of a plant?
That's a tricky question.
Give me a ballpark.
Depends on how good you are at
Sure.
it and how long you may have practiced horticulture.
Okay.
I come from a little bit of a plant background.
How much do you grow in one plant?
It really is very dependent on a lot of things, whether it's outdoors or indoors.
We'll say indoors because we're going to keep them away from kids, so we're not going to have much.
I believe that what people have said is around is I'm not actually sure. I don't feel comfortable really
That's fine.
answering that question.
Thank you. Thank
But
you.
I do feel like that is more reasonable than what is in 1598.
Sure. I was just curious. Thank you.
Yeah.
Thank you very much for your
Yes.
testimony.
Sure.
The chair will call Jody, is it Newer? Okay, please remember, we've had a lot of testimony this morning, and if you've got something, please don't read it, and please don't repeat. So we're gonna go ahead and start.
Okay, I did write it out to be prepared. It's only 2 minutes. Is it okay if I read it?
Okay, no,
Thank you.
that's fine.
Okay. My name is Jody Newell and I live in Keene. I'm here today to support the passage of HB 629. It is not only the will of the vast majority of the people, it's the most logical thing in the world to legalize cannabis use, including compassionate care for others and provide for personal cultivation. For far too long, cannabis has been vilified and criminalized in spite of its proven physical and mental health benefits and a notable lack of potential for harm. One of the most personally significant benefits for me is reflected in the mounting evidence showing that cannabis can be used in substance use recovery. In 2008, I lost my fiance, father of our 2 boys, to opiate overdose, and I've spent the intervening years studying the issue, our societal approach to treatment, and evidence-based practices that could be implemented in order to save lives. In that effort, I've spoken to many affected individuals who have successfully used cannabis to maintain sobriety, and the research has backed that up. This is not trading one addiction for another because these are not comparable substances. One pulls you down a perilous path of often ending in early and tragic death, while the other carries no risk of addiction and has claimed literally 0 lives. Conflating the two is not only misleading, it's dangerous, in that, given the inevitability of experimentation with cannabis and realizing its mildness, our children are left to wonder if other, seriously harmful substances are really as bad as we said. So yes, cannabis should be legalized, but further it should be normalized, destigmatized, and treated like any other harmless plant, growing right in our backyard alongside tomatoes and broccoli. And if the harvest is plentiful, it's nothing but kindness to share that surplus with your neighbors, just like the zucchini and squash I received on my doorstep when I moved into my home. Thank you.
Thank you very much for your testimony. Are there any questions? No? Seeing none, thank you. The chair will call Frank Douglas. Good morning, Mr. Douglas.
Good morning. Thank you for having me.
Are you ready?
I'm ready.
Great.
In New Hampshire, we pride ourselves with freedom. I mean, I've heard frequently about the New Hampshire advantage, but without the legalization of marijuana, this puts New Hampshire at a disadvantage. With this freedom, we'll actually bring people who are in middle class and property owners to New Hampshire because they can feel comfortable growing marijuana. And that's something that, to me, that's very important. I'm from Massachusetts, and I moved to New Hampshire because I liked the feeling of freedom. I liked the feeling of being able to have a gun. I liked the laid-back atmosphere of New Hampshire as opposed to Massachusetts. Now, another thing about this with just decriminalization, this actually targets the poor because fines accumulate, and people who don't have the money to pay those fines or even have the money to get therapeutic use, they're behind the eight ball. If they're able to go to the dispensary and actually be able to purchase marijuana for pain, mental health, and other issues, that's going to save lives, especially due to like the opioid pandemic, and also people who are suffering from mental health. I have a friend, his name's JD. He's suffered from mental health. And instead of being able to get marijuana, he ended up turning to meth because that helped him with his problems. That helped him with his pain. He was treated like a criminal. He's actually doing time in jail. I do believe that if marijuana was legal, I think JD would be able to actually help himself, be safe, not be doing meth. And pretty much that's all I have. I mean, again, this is a war against the poor when you're finding people. And we want people to thrive. We don't want people to fall behind the eight ball.
Okay, thank you very much for your testimony, Mr. Douglas. Are there any questions from the committee? Senator Gannon.
I want you to thrive. So if you go to a lot of industries I'm in District 23, sort of near the coast. Foss Industries is out there. There's a lot of manufacturers. Foss does a lot of stuff. They make in your car, the dashboard and stuff, and they make the stuff in planes, those overhead, all the plastic bins, and they do a ton of stuff. They're dealing with hot, molten stuff that's at like 4,000 degrees. If you can't pass a drug test, you can't work there. So if you're a user, they're very concerned you using this machinery that could harm, everybody on that factory floor. They don't allow people, so if you can't pass the drug test, are you not afraid that you're going to be limiting people's futures now because they won't be able to get these jobs?
That's a choice of the company in itself. And people have to know, like now marijuana is illegal. My job, I work for Verizon, they drug test. That's something people need to know when they apply. That's their responsibility. I don't think, I mean, you think about it. Would someone go and show up to a drug test drunk?
Or they can tell, though, if it's in your system for a long, long period.
Yeah, but again, that's the risk that the person takes. They should have knowledge about that. That has nothing to do with the law.
Thank you.
Thank you very much, Mr. Douglas.
Thank you.
Seeing that everyone who has signed up to speak has spoken, I see you sitting there, Mr. McGuire. Did you want to speak? Okay, all right. We're going to go ahead and close the public hearing on House Bill 629. I have to put it again. So here, oh, I don't need chocolate. No. Oh. Yeah, crunchy.
Lucas, I just got this for Senator Clarkson. I don't know if it's for the bill coming up, so I don't know. The treasurer, yeah.
Yeah.
Okay, you got it? Yeah, that's what we need.
Yeah, I can't have it though. I can't. Not if I want my feet to stand.
And when I say we worked on it with the AG, with people that are possibly or are representing some of the victims, as well as victim witness, and anyone else that wanted a say in how this bill was framed. But I think you all know that the Attorney General has been conducting an investigation into abuse at YDC. And when I say YDC, that's kind of an overall term, and it includes any number of names that the Youth Detention Center has gone through. And it's not limited to just what one would think of as YDC. So it's a long-going process. This bill provides a trauma-informed, victim-centered alternative to litigation through the court system. And we expect that this alternative will provide for efficient and fair resolutions of those claims. The process starts with the Attorney General in conjunction with the claimant's counsel, with input from victim witnesses, developing a claims process, including claim forms. This has not occurred at this time and will only occur once the bill passes. The goal, and they will also identify guidelines for valuing claims for settlement purposes. The goal of the guidelines is to ensure fair and uniform valuation of claims. And the guidelines are on a very, very tight schedule. Claims can be filed starting 1 January 2023. And obviously, the guidelines, the claim forms, and everything else that's in this process needs to be completed by then. The other thing I want folks to understand is that participation in this process is entirely voluntary. They don't have to come through this alternative claims process, but it's an option for them. And I think we believe that this process will work a lot faster than trying to take each of these cases through the court system. One of the things that we did do is that we placed a cap of 1.5 million for abuse claims, sexual abuse claims, and we established a $150,000 cap for physical abuse. And if a person is both sexually and physically abused, that cap remains at the 1.5 million. And the way the system is going to work is the claimant will come in first with the Attorney General designee, and the Attorney General designee, based on the guidelines, will provide an award amount. If the claimant doesn't agree with that, they have two options. They can drop out and go to court, or they can go to the administrator that will be appointed by the Supreme Court. And so we're not forcing them into the system all the way. They have their choices and how they want to go about it. I think that finally we have established a $100 million fund that will be used to pay for this. We've also given the Attorney General and the Administrator the authority to come back to the legislature if the $100 million doesn't cover the cost of the claims. Hopefully it will. But when we are looking at paying claims, the claimant can take whatever money it is at that point, or they can have 10 years with the state paying out in annual installments, or they can choose a structured settlement option. And so we think that these three opportunities for how the claimants will be paid is an effective way to make sure that we pay the claimants. Because one of the concerns that claimants have is the state will run out of money and we won't pay them. And we really don't want to have that concept in their minds. So hopefully we have developed a fair and equitable process for the children who are sexually and physically abused. And I certainly ask that you will support OTPA. Thank you.
Thank you very much, Representative. Are there any questions from the committee? Senator Whitley.
Thank you, Madam Chair, and thank you for bringing forth this bill. This issue has been something that I think has haunted so many for a long time, and in fact, this is not something that is new. We have known that there have been horrific things that have happened at this facility with children who are most vulnerable in state custody. Many of these children, as you might know, have already experienced significant trauma even before they enter the doors. So, I think it's important while we're having this conversation to just continue to ground ourselves in the atrocities that did happen against children. So in that vein, this, do you think that the amount that we're considering here is enough? And, is the process for, if it's not enough, is it, will victims be able to, get what they need and in a way that doesn't re-traumatize them by having to wait further if it's not enough?
Okay. If a victim doesn't feel what the AG designee or the administrator, or the AG designee is providing, they can always opt out and go to court. And that's the option that they have. So if they don't think the 1.5 cap is sufficient to take care of their trauma, then they go to court. That's their option.
Follow up? Thank you. And do you think that the $100 million is enough to cover all the claims?
We are, yeah. Do I think the answer to that is yes? I don't know. I don't know. And as I said, that's why we will allow them to come back, the AG and the administrator to come back and ask for additional dollars. Obviously, we expect that the 100 million, by the time we get everything going, will be sufficient for several years. But not, I don't know how to answer that question otherwise.
Thank you.
Are there any further questions? Senator Khan?
Thank you, Madam Chair. And I agree. Thank you for bringing it forward, Representative. As Chair of House Finance, I wanted to ask you about Revenue Stabilization Fund as the source for funding the claim settlement. What is the balance in that fund currently, or at the end of the last fiscal year?
I believe it was 276.
So this is what we commonly refer to as a rainy day fund.
Rainy day fund, yes. That figure may be off, but it's close to that. And we felt that by I don't know what to say. It's we're not taking the money out of the rainy day fund. It's staying in there and will only come out as cases are settled. Okay, and I think we all know where revenues are going this year and anticipated for next year, that there'll probably be a lot more than 100 million that lapses into the rainy day, I shouldn't call it that, into the rainy day fund at the end of 23.
May I follow?
Follow up?
We have not set aside dollars for this type of settlement previously.
Not that I'm aware of, no. Not for this YDC settlement, no.
And I just follow up that. So I'm trying to not lose a word you say, but was also trying to look at some of the changes that were made on March 30th. Version, and I see on page 5 that for claims that there will be no settlement, or that we shall not pay more than $4.5 million towards any settlement. 4.5 million, it says on page 5, line 22. Did I jump to that?
That's not the current amendment.
I'm sorry?
No, you're all fine. You're all set. You're fine, Representative.
Okay.
1.5.
I'm sorry. I'm getting signals that somebody in the audience wants to talk to that question, but they haven't come forward. They haven't been recognized. So at the time that you decide if you have signed up to speak, you can address the question.
would you like me to wait on that question, Representative?
Yes, because our cap is 1.5 million. That's where we are. And I don't,
We'll need.
I don't know if you're looking at a proposed amendment by the Defense Council, if it's got red all over it and blue, but that's not the amendment
Okay,
that passed the House. The amendment that passed the House is 223122. I'm sorry, that's wrong.
956?
956.
Thank you. Thank you.
You're
That
welcome.
clarifies.
Okay.
What,
Are there any
And-
further
and-
questions? Seeing none, thank you very much.
Thank you. Appreciate it, Miss Chairman.
The chair will call Representative Pat Long.
Good morning. Thank you, Madam Chair, honorable members of the committee, Representative Pat Long, Representative Hillsborough 10 in the city of Manchester. I first want to reiterate what the former speaker said with respect to the due diligence that went into this bill has amended, delivered to the Senate. I commend them on their compromising and hard work. My main reason here is with respect to adding emotional abuse. I think it's important for the public or the victims to see the general court recognizing all those that suffered under the hands of the state. And I believe that that helps in the healing process more than the financial does. So I'd ask that you would consider adding emotional abuse to the abuses that were perpetrated. And I thank you for allowing me to speak.
Thank you very much for your testimony, Representative. Are there any questions from the committee? Senator Whitley.
Thank you, Madam Chair. Thank you for taking my question. So you indicated you believe we should add emotional abuse to this. And were there conversations about that in the House? Can you share those?
Yeah, there were. There was an amendment brought forward that lost in the House that got voted down in the House.
Follow-up?
Follow-up?
And why was it voted down? Do you know what the arguments were against it?
I voted for it, so I'm not sure why it was voted down. Yeah, I'm not sure. Frankly, I think the attorneys may know best on it.
Last follow-up? Yeah. Was it just a matter of cost?
I'm not sure of the cost because this, the idea is to get everybody to go through this process. I think it would save the state more money with respect to going to the court. That's why I think expanding that. So I think the cost would be beneficial, adding that and having them going through this process.
Thank you.
Senator Khan.
thank you, Madam Chair. Representative, nice to see you. So you believe that the term other abuse is not sufficient to cover your concern?
That's correct. That's correct. Oh, well, I believe it's sexual and physical only.
And other abuse?
Yeah, I believe it should specify, emotional. Yep.
Are there any further questions? Okay, seeing none. Thank you very much, Representative. The chair will call John Formella. Good morning, General.
Good morning, Senator, members of the committee. Just gather my papers here. So thank you, Madam Chair. Good morning, members of the committee. For the record, John Formella, Attorney General. Before I get to my sort of specific comments on the bill, I just want to make 2 points that I think are important overall. The first is I want to acknowledge just the incredibly difficult, emotional, complex issue we're here to discuss. It's difficult to really comprehend what some of these victims went through. And my team and I at the Department of Justice certainly applaud their courage in coming forward to tell their stories and to seek justice. And we sincerely hope that this bill can be at least a way for these victims to either begin or continue the healing process. I think each victim goes through that process in their own time and in their own way, but we hope this bill can be a part of that. Second, I just want to remind the committee that as Attorney General, I play a dual role, which can be very difficult to balance. I'm both the state's chief prosecutor, who is responsible for prosecuting those who have been responsible for this abuse and bringing those individuals to justice. I also am the state's chief legal officer, so I at the end of the day, am responsible for defending the state against civil claims that may result from the same abuse. I work hard to balance those roles every day. It can be a difficult balance, but because I appear here in that capacity, there may be certain questions that I can't answer or that I need to limit my answers to, but if I get those questions, I'll do my best to say as much as I can, and I'll explain why I can't say anything further if that's the case. Chairman Umberger addressed this, but as you know, since 2019, the Department of Justice has been conducting a comprehensive criminal investigation into allegations of abuse at the Youth Development Center, or former Youth Development Center, and that facility has had different names throughout the years. To date, we have indicted 11 individuals for acts of abuse against 20 victims. The investigation remains active and ongoing. So over 400 individuals have come forward, and we continue to staff up for the investigation. We expect that it will continue for years at this point, or at least the investigation and the prosecution of individuals responsible will continue for years. At this time, it's hard to say what the sort of the total impact of these various events of abuse have had and what the full scope is. I think we won't know that for some time as our investigation continues. Many of these individuals are also pursuing civil claims against the state. To this date, we've received close to 450 individual lawsuits against the state. These lawsuits allege that these victims suffered abuse that took various forms: physical assault, sexual assault, solitary confinement under extreme conditions, and more. With all of this in mind, I and my team at the Department of Justice, and this began with former Attorney General Gordon MacDonald, we felt that we needed to think about and ultimately propose designing an alternative process to traditional litigation. We recognize that the traditional litigation process can be very difficult for victims of physical and sexual abuse, especially those who suffered this abuse as children. So we really wanted to put some time and some thought into how to design that process. For the sake of clarity, I want to make a couple of comments about what this bill is not designed to do, at least from the perspective of the Department of Justice and how this bill was proposed. The first and most important piece is that this bill is not designed to be an exclusive option. So this bill is not designed to cut someone off from pursuing traditional litigation if that's what they decide to do. This bill is intended to be an alternative to traditional litigation, a victim-centered, trauma-informed, gentler alternative. So it's not designed to be exclusive. I think most understand that, but I think it's an important point to continue to reiterate. This is not our attempt to cut someone off from other options they may have. Second, this bill is not designed, at least from the perspective of the Department of Justice, to cover every potential class of victim who may have been a resident at YDC. So what do I mean by that? As the bill reads now, it covers physical abuse and sexual abuse. There are categories of of incidents that it doesn't cover. Senator Whitley raised the question as to why this bill, at least as it's drafted now, doesn't cover emotional abuse. And this really goes to the balance that I think we're trying to maintain here, which is providing a process that's very victim-centered and trauma-informed and gentle and not overly invasive, not unnecessary scrutiny. I think that involves some level of trade-off with certain categories of abuse, and emotional abuse is it's very difficult to go back many years and distinguish between what might have been emotional abuse and what might have been just the type of speech or conduct or communication towards a resident that, while not nice, is not something you wouldn't expect to see while it's a youth detention center, it's an incarceration facility. So that is the reason, at least as it stands today, that the draft doesn't include emotional abuse, because we're trying to design a process where we do want to have some verification of claims. We want to ensure that there isn't any obvious red flags that claims are false. For instance, we'd want to make sure that someone was actually a resident at YDC. We'd want to make sure that whoever the allegations were made against, that individual was actually a staff member at YDC at the time. That's the type of verification we'd be looking at. If we were going to go back and try to determine whether something was emotional abuse or whether something was just yelling at a resident, that would require a lot, I think, deeper factual analysis. So that's the balance we're trying to strike. That is ultimately a policy decision for the legislature, but that's why the bill reads as it does now. So I feel it's important to answer that question, at least explain the reasoning. I'm happy to respond more to that in questions. Chairman Umberger went through, I think, pretty well an overview of the bill. So I was planning to potentially do that, but I'll skip that for now. I can answer questions. What I would like to do, just to give the committee some context, is talk about some of the changes that were made in the House phase. At the beginning of the process in the House, I made clear that I and my team were ready and willing to engage in conversations with plaintiffs' counsel, which we had done prior to the bill being introduced, and we've done since then. We were ready and willing to engage and discuss areas that we might amend to try to bring us closer together, to try to design a process that strikes the balance we're trying to strike, which is bringing justice and compensation to victims, but also with at least enough verification and enough stewardship of public dollars that we can make clear to the public that we are balancing our obligation both to do right by victims and be good stewards of public dollars. So we had a lot of discussions in the House phase, a lot of discussions with plaintiffs' counsel, stakeholders, with legislators, and some of the we made some major changes to the bill through the House process. That included expanding the scope of the bill to cover not just sexual abuse claims, but also physical abuse claims, and to have it so that solitary confinement is at least an aggravating factor. As the bill reads now, if your only claim is solitary confinement, it's not covered by the bill, but that can be an aggregating factor if you've also suffered other types of abuse. We tried to enhance the independence of the administrator by making that person an appointee and employee of the judicial branch. As the bill previously read, the administrator was going to be the attorney general or their designee. As the bill reads now, the administrator would be jointly selected, either jointly selected by plaintiffs' counsel and the AG, or if we can't agree, the person would be selected from a list that's submitted to the Supreme Court, and then the administrator would be an appointee and employee of the judicial branch. We tried to expand the role of plaintiffs' counsel in the development of the claims process and guidelines. So in the original version of the bill, the language provided that the attorney general would just design the claims process and guidelines. There'd be no presentation to the fiscal committee. The attorney general would just design the guidelines. As the language reads now, the attorney general is obligated to make good faith efforts to really come to agreement, I think, with plaintiffs' counsel and with stakeholders, with input from the attorney general's victim witness advocates. the House made the decision to have the Attorney General ultimately be responsible for presenting something to the Fiscal Committee because of a concern that if there wasn't 100% agreement on every component of the guidelines, then the process wouldn't move forward. So I can tell you from my perspective, we would absolutely make every effort to design a process that had agreement on all components. We'd have a very powerful incentive to do that because we don't have an incentive to design guidelines and design the claims process in a way that nobody would participate. But that's why the language reads as it does now, because at the end of the day, the House felt that it needed to be the Attorney General at the end of the day that would move the process forward to the Fiscal Committee. And even if the version of the claim process and guidelines that went before the Fiscal Committee didn't have 100% agreement, either plaintiff's counsel or the stakeholder would have opportunities to make that case, but before the Fiscal Committee. The original version, I should just note, didn't have, as I said, the provision that the Fiscal Committee would approve. That was added in order to just increase transparency and increase that opportunity for public discussion around what the guidelines look like. This version expands the window to file claims from 1 year to 2 years. The original version only had 1 year. There was a lot of discussion during the House process that we needed a longer claims window. We ultimately landed on 2 years. This version increases significantly the transparency of the records that would be available to the public. Essentially, what this version provides is that the records of this process would be made public with appropriate redactions to protect the identity of victims and appropriate redactions or withholding to comply with any existing laws regarding confidentiality of records related to minors, of which I could envision there would be some records that would come into this process that would need to remain confidential. That does not prevent any individual victim from making records related to their case public if they wish to do so as part of telling their story. But we tried to have a better balance between the need for transparency and the need to protect the privacy of victims. The original bill also provided that the administrator could decide to pay out claims over a period of years. We changed that so that that only occurs if a claimant elects that option. And then we tried to make revisions throughout the language just to make the bill more victim friendly. That doesn't cover all of the changes, but I just wanted to note some of the major ones just to make the point that we have had a lot of discussion about this bill, and we have really tried, and we will continue to try to identify areas of compromise to get everyone as close to consensus on this bill as possible. So that's my high-level overview. I'm happy to take questions. Before I do, I just want to make a couple of additional points. And the most important is this. Aside from everything else, I really do believe that passing this bill in some form is the right thing to do. And I said this in the first hearing, but it's the right thing for the victims. I think it's the right thing for the state. This bill reflects, I think, what should be the state's policy position, which is that it's better to direct resources towards healing and compensation than towards expensive litigation if we can avoid it. It's also just the right thing to do right by the victims. Second, if this bill is enacted, I can assure the committee and assure the public and assure everyone in the state that my office will make every effort to design this process in a way that is fair and in a way that addresses as many concerns as possible to bring some compensation to the victims of these crimes while balancing, I think, our obligation to be good stewards of public dollars. And the final thing I just want to say before taking questions is I want to thank all of the legislators and everyone who's been involved in both presenting this bill, bringing it forward, and who's been involved in the work to continue to amend the bill and get it closer to a consensus product. It really makes me proud to be part of that effort, and I think it reflects really well on the state. I know not everybody agrees with every part of this bill, but I think just the fact that this bill has come as far as it has in the form that it's in, it really is it's a historic, I think it's a historic event for the state. I don't think we've ever tried to do anything like this, and I think acknowledging this type of harm and trying to do the right thing really reflects well on the state of New Hampshire. So with that, just say thank you. I'm prepared to take questions, and I will stay for the entire hearing. I'm happy to come back up and take questions on any comments that anyone else has, just to be a resource and to continue to help move this process forward.
Thank you very much for your testimony. Are there questions from the committee? Senator French, Senator Gannon, Senator Whitley, Senator Khan.
Thank you, Madam Chair. I have a few questions that will be quick. Thank you for coming today. I really appreciate it. At this time, how many claimants are there?
I believe there are 400, it's around 446, maybe give or take a few, who have filed lawsuits.
And this 2-year period window to file, when would that 2 years begin and end? And how many more would you expect from the 446?
So the 2 years, I believe, would begin on January 1, 2023. The window would close on December 31st, 2024. It's difficult to say how many, in addition to the 446, may come forward. We don't have a good sense of that. The 446 is not that far off of the number that have come forward in the criminal process, but I could imagine we may have some of the 446 who have filed lawsuits who would elect not to go through this process at all and to continue in court, and that we'll have some who have not come forward at all who may come forward if this process is enacted. So it's difficult to give you an estimate on that, Senator.
Okay, and one final is, of those people who committed the crimes, has everyone been arrested at this point and prosecuted, or is it in process of being prosecuted?
That investigation remains ongoing. We've arrested 11 individuals. Those are all in process. We are prosecuting them. The trials are getting scheduled. None of those cases have been resolved, so those are in process. It is very possible we may arrest and indict additional individuals, but I should note that many of the allegations that are made concern the same individuals. So it may be possible at the end of the day that we can prosecute an individual for certain allegations and not others, because at the end of the day we have to be able to make a claim, or we have to be able to prove a case beyond a reasonable doubt in the criminal process. But anyway, to answer your question, it's 11 individuals. It could be more. There's no guarantee it'll be more. It just depends on where the facts take us.
Yep. Thank you very much.
Senator Gannon?
Thanks for taking my question. I'm just a simple country lawyer, so I won't try to get over my head here. And when I was learning law, you were probably really young, and I'm feeling my age. And maybe it's a silly bell going off in my head. But as AG, you're chief prosecutor, as you said, one of your main roles is bringing the abusers to justice. And so, but when you do that, aren't you going to set up a cause of action? Because then you have to, and then you're adversely doing your role, because then you have to defend the state's interest, but you may be bringing, by what you find out, is going to bring more causes of action costing the state money. Is that a conflict of interest? Do you have Chinese walls, or should you set up in your office to maybe have a prosecutorial part and then a defending the state interest part?
It's a very good question, Senator. So the answer is, I think the most important answer to your question on walls is yes. We have very strict walls between the criminal process, so the prosecution team, and the civil side of the house. So there are really three components of this. There's the YDC task force, which is set up to investigate and prosecute these crimes. Part of the civil, part of our civil bureau is involved in helping the Department of Health and Human Services respond to the criminal investigation. And by that, I mean just helping them collect the documents that the criminal team has asked for or gotten court orders to produce. And then there's the civil defense team, I'll say, which is involved in defending any civil suits. So we have very strict walls that separate at least the civil and criminal side of the house. At the end of the day, and we've had many discussions on this internally, the Attorney General has the responsibility to supervise both of those. My teams don't talk to each other, at least anything beyond coordination, but there is case law and surrounding the idea that the rules of conflicts of interest just apply differently in certain cases to government lawyers and to the Office of Attorney General.
Okay.
And so I have an obligation to make sure those don't cross any more than they need to, but I also have the obligation to at least be the overall supervisor of both teams.
Great, thank you very much.
Okay, Senator Whitley.
Thank you, Madam Chair, and thank you for taking my question. And I certainly appreciate your starting your presentation with that sensitivity of what we're actually talking about here, because I think it can get really lost, right?
Yeah.
When we're talking about dollars and cents, when we're, talking about process. And so I think it's always important to ground every conversation, as I said before, in what we're actually talking about is, abuse against children when they were in state custody. So to that end, looking at process, we want to make sure that the process that we're setting up continue to be victim centered and trauma informed. And so, thinking through, you had mentioned, the negotiations around the approval process for the guidelines, and that, it's incredibly important, even though the AG has the ultimate authority to draft those, that there's inclusion from everyone, which I think is great. But I am sort of thinking through, and I also think that going to the fiscal to make that presentation and having that be as open and transparent and public as possible, I think that's a great idea. So what I'm thinking through is it necessary to have that additional step to have approval from the fiscal committee? Are we sort of setting up one more layer, of a sort of political layer? Is that necessary? Does that, interfere with the processes? Are we creating, yet another layer that could be potentially traumatizing or unnecessary?
Yeah, thank you for that question, Senator. And on the House side, when we had these discussions, I think the fiscal committee involvement really was for two reasons. One was the point you just hit on, just transparency and having this, having a public presentation of this so that it's out in the open. As the bill is drafted, the fiscal committee really would just give an up or down. So the fiscal committee wouldn't be able to amend the guidelines. The fiscal committee could only say no and send the Attorney General back to do more work if there was a concern with the guidelines. I think ultimately the reason to have fiscal approve is just because there's always a balance here, right, between thinking about the dollars and cents and thinking about the victims and the individuals involved. This is a lot of money. And while typically the Attorney General has the authority to settle cases up to a cap of 4-point-something million for each case, this is unique in that sort of a lot of money is being authorized all at once. And the claims process and guidelines, as has been identified by, I think, a lot of the stakeholders in this process, is going to be a very important point in the process. Appropriating $100 million is great. Establishing the caps is important, but how these claims are going to be valued within those caps is critically important. And so I think House Finance at least felt that having that the fiscal committee approval was important, given that those are the elected representatives who are elected to appropriate money, or at least that's a subset of the elected representatives who are elected to appropriate money. I see your concern on it becoming politicized. I think with this, I think that the benefits of having it out in the open, having a backstop, and also giving someone who may not agree with what's in the guidelines the ability to advocate to the fiscal committee to say no and sort of require more work. I think those benefits outweigh the concern of this being politicized. My experience so far in this process is that this bill hasn't gotten politicized. There may be disagreements here and there on what the cap should be, what the scope should be, but I haven't detected any politicizing of this bill.
Thank you. Senator Khan?
Thank you, Madam Chair, and thank you, Attorney General. Nice to see you.
You too.
So there was a suggestion about the definition about emotional abuse, and a suggestion that somebody has provided to us is that other abuse be defined. And so I'll just read, a couple. It says, Other abuse means an incident of conduct which would constitute a common law cause of action for emotional abuse, child endangerment, false imprisonment, unlawful confinement, child exploitation, or deprivation of educational rights. Some of those are more serious than others, obviously. But I'm wondering, in trying to understand the scope of this, which sounds like 446 complaints filed with the court to date. Do you have any thought about how many of those complaints don't allege sexual or physical abuse, but do claim false imprisonment, emotional abuse, and these other defined terms? And I guess what I'm wondering is, to what extent will this bill be a diversion for how many cases we anticipate? Because clearly a number of these others are going to wind up going through civil litigation because they'll extend beyond, or maybe they can get settlements for things that aren't defined in this, but are cumulative to the overall claim. So that's what I'm trying to get a sense of. Is 446 represent everything? Because everything is sexual and physical abuse to this point? Or is the total universe much greater than 446 because of the limited definitions applied?
So to your first question, Senator, thank you for those questions. It's good to see you as well. But to your first question, as to how many of these claims may be false imprisonment, emotional abuse, child endangerment versus physical abuse and sexual abuse, that's a bit difficult to answer because of how the process is played out. This was originally filed as a class action, which would have covered many of the claimants all in one complaint. So it was very broad. The court, at least the trial court, decided that this could not be brought as a class action. We'd have to have separate complaints. So then we had many complaints filed. A lot of these complaints were also very broad, and there continues to be some back and forth in the process about how these complaints need to look and how specific they need to be. And so we expect, amended complaints to be filed at some point. So we don't have, and given the number of people we're dealing with, we don't have a good sense. I couldn't tell you, we've got 70 complaints that deal with just sexual abuse, 60 that just are physical abuse, 30 that are emotional abuse and child endangerment. We don't have a good sense of that at this point. What I can tell you is this, and I don't want to put words in the mouth of plaintiff's counsel so they can correct me. My sense is that many of these claims, if not the vast majority, encompass, physical abuse, sexual abuse, various categories of abuse. So I think if this is limited to physical and sexual abuse, I think for most claimants, it's not that they're not going to have a claim. It's just that the only claims that are going to be covered are their physical abuse and sexual abuse claims. And again, the reason for that is the same as the reason for not including emotional abuse. There are just certain categories of abuse that, well, we would never condone them from at least even a soft verification effort. It's very hard to go back many years and distinguish between what may have been solitary confinement that was an accepted practice at the time, and while perhaps some might say not a good practice, it wouldn't rise to the level of abuse, at least according to the standards of the time. It's very difficult to distinguish that between something that may have been beyond the pale and not justified and would rise to the level of abuse. So it's hard to get to the number. I do think that we will cover we will cover the vast majority of individuals who would bring forward claims by including physical and sexual abuse. We may just not, what they may not be able to recover for under this process is just certain categories, but that they're not going to be excluded altogether. And at the end of the day, as I said, this is just meant to create an alternative process for a certain scope of incidents. If it's not covered by this bill, there's still the option to go to court. Does that answer your question?
It does.
Okay.
Well, it certainly gives me more insight, if I'm
Okay.
Madam Chair.
Yes.
That you mentioned the class action suit. The 446, are they all mentioned in the class action suit?
So not each individual name, but at this point, there is no, because the class action was dismissed. I was just trying to give you some context. It was originally filed that way. Yep.
Good. Thank you for clarifying that. And so those claims that might fall outside of sexual and physical abuse, they'll need to go forward in a separate process through the courts, civil litigation. Your office will be involved in the defense of those cases as well.
Yes.
Just not through the assignment of the prosecutor.
Yeah, not through, this process, which again it's meant to be it's meant to be more streamlined. I like to say gentler than the traditional litigation process, which as that goes along can get difficult.
Thank you.
Yeah, are there any further questions? You seeing none, thank you very much for your testimony this morning.
Yes, Madam Chair, just if I may, I'd just like to submit, I did have our research that kind of lands on averages for per claimant values for physical and sexual abuse. That is what the caps are based on. So if I might just submit that for the record.
Yes, please.
Okay, thank you very much.
Thank you. Okay, the chair will call David Vincenzo. Good morning.
Good morning, Chair Carson. Thank you very much, all members of the committee. My name is David Vicinanzo. It's actually phonetic, but it's intimidating to look at. I spell it 10 times a day. I'm at the law firm of Nixon Peabody, which is a national firm with an office in Manchester. And with my co-counsel Russ Riley, represent with our team about 500 child victims of abuse at YDC over several decades. I should introduce myself a little bit. I'm have a fair amount of experience in this area, although my experience has often been, I won't say on the other side, it's more of I've never viewed this as a defense plaintiff sort of situation. Historical child sexual abuse is a category all by itself, and any institution that has been afflicted by this scourge should never take an oppositional stance toward the victims, in my view. I first got into it, I was for a long time running the United States Attorney's Office as a federal prosecutor, loved every minute of it, had a big family, needed to go into the private sector to pay my bills. And, but I've also loved being in the private sector as well. Shortly after I got out, I got a call from my friend Ovid Lamontagne, who was being brought into the scandal breaking out in Manchester with the diocese. This is about 20 years ago. And Ovid said to me, you know, I want you to get involved here. And I said to him, why would I want to do that? Because it sounded so awful. And I had young children myself and was thinking, oh my gosh, well, why do I want to spend my time with that? But Ovid was right. It was important. And the diocese needed a fresh look at who was representing it and the lawyers that were advising it, and to kind of bring it into the 21st century in its attitude toward the victims of child abuse. And I brought my then partner, Gordon McDonald, into it. Actually, I don't think he was a partner yet. I think he was a partner shortly after, but Gordon was my partner for 17 years, and of course is really the reason why we're here today. But Gordon and I learned in that experience what a trauma-informed and victim-friendly process is. We helped to develop one that has become a model for institutions throughout New England in dealing with historical institutional violations of children. Since that time, I've represented many other dioceses, currently representing several in New York. I represent and have for many years Phillips Exeter, Phillips Andover, and many other schools and institutions that have had to wrestle with these horrible problems. But it's a testament to how far those institutions have come in their understanding of this terrible crime, that they are all very supportive of me in doing what I'm doing now, which is representing more than 500 victims, child victims of sexual abuse at the hands of the state of New Hampshire. I respect what the House has done with Bill 1677, and I respect John Formella and Jen Ramsey and the folks in the AG's office and their work on the bill. But I also respectfully disagree that we have come far enough with this legislation. I do not believe that it is yet a trauma-informed or victim-friendly bill. Ultimately, the measure of success for this bill will be in whether or not the victims use it and in what percentages. That's kind of standard. We have a lot of models out there now about how to do settlement processes, starting with perhaps the World Trade Center bombing, and all kinds of settlement processes used by churches, schools, institutions. The Larry Nassar situation in Michigan with the state of Michigan, and many other examples around the country. This wheel doesn't need to be reinvented. It is my position that we've submitted our edits to the bill to the committee, and that with those edits, with a couple of significant alterations, really, only a couple of words here and there, this bill could be victim-friendly, and it could be trauma-informed, but it is not yet. As it is right now, it's unlikely that we would recommend this bill to our clients, and I doubt that many of them would actually participate in the bill as currently written. On the other hand, with a few tweaks on a couple of important issues, I suggest that we would probably get a 95% participation rate from our clients. And it could truly be said that the bill was victim-friendly, trauma-informed, and within a year or two, or a year and a half, the state of New Hampshire could actually start putting this in the rearview mirror and moving forward and repair the damage to its reputation and to its integrity that this abuse represents. We've submitted our edited version. We've also submitted a summary of the changes that we would like to see and a brief explanation for why we think they're appropriate and why they reflect the best practices that we have come to see across the country. I would also point your attention to the letter filed yesterday by Child USA, which is perhaps the premier child advocacy organization nationally. They are so interested in this bill that they broke it down and analyzed it piece by piece. And they provide a very good analysis and a very good critique that I think would help guide the Senate here in making what I think are pretty few changes to the bill that would actually invite and actually entice our clients to participate in this process and begin the healing that those kids need and deserve, and in fact, the healing that the state needs to its reputation and to its integrity. One of the points, and I won't get into them since they're handled well in the written documentation, but giving up judicial rights as a price of admission to the administrative process. That is not something that any expert would recommend around the country. Trying to force victims to abandon their only leverage as a price of admission to getting in front of the administrator. That's just not done, and it shouldn't be done here. We've already heard some discussion about the issue of covering solitary confinement. I do want to address that just a little bit. The latest research, and it's not that recent, but it's been around for a while, but the more modern research suggests that emotional harm to children, emotional trauma, and often represented by things like extended periods of solitary confinement, are actually inflict greater longer-term traumatic harm on children than physical or sexual abuse. That may be counterintuitive, but that's what the experts are telling us, and it's certainly what our clients are telling us. We have instances of kids being held in a cell in their underwear for up to a year at a time. And unbelievable stories, and the damage to the emotional state, the mental state of those kids is really incalculable. And it's not so, it may be true that often the solitary is combined with physical abuse or sexual abuse. That is true, but it ought to be a category all by itself, that form of emotional harm. And to exclude them is a form of re-victimization of those folks who had to live through that. And no one should ever think that putting an 11-year-old or a 13 or a 15-year-old in a cell by themselves in their underwear for months is anything less than inhumane. I'd like to address the caps, or the so-called caps. It's our view that they're artificially low. I'm not surprised, I suppose. Saving money is always a good thing for a state, except when it's not the right thing to do. And it's not the right thing to do for the state to have allowed the abuse of these kids, to have permitted it and sponsored it for so long, and not to step up and actually do right by those kids. And do right by it. I mean, Justice Cardozo said many years ago that the state is first and foremost a moral teacher, a moral leader. And if the state does not act in a moral way, why should the citizenry be expected to do so? The state did act as a moral leader when it pursued the diocese, when it pursued St. Paul's School for allowing children to be abused. And the state should be proud for having done that. But the state really is losing a lot of its luster in the area of moral leadership because of what happened at the YDC. And also by not hastening to actually make this a trauma-informed and victim-friendly process, and to actually do a survey nationally of what the values are out there that would represent a fair and just settlement. I have seen the AG's preliminary work, and I'm going to say it's preliminary because I have commissioned a significant analysis of that work, and we have now analyzed about 5,000 claims for sexual and physical abuse of children nationally. Our work is not finished, but I can tell you that the numbers are going to be significantly larger in average settlement than what is currently represented in the Attorney General's chart. It just may be a matter of digging harder and finding more settlements, or adjusting them for inflation too, because a lot of the settlements that are on the chart are older, and the values, by virtue of just inflation, have doubled or tripled in some cases. But the idea, I was interviewing a new client yesterday, a victim at YDC. He went in at age 11 and came out at age 17 and said, I estimate that I was beaten, and by beaten I mean with fists and kicks and blows to the head, blows to the teeth, jaw, torso, hair pulled out. But he said, I estimate that happened 25 times a year. And starting when he was 11. Excuse me, I apologize. It's 25 times a year times 7 years. That is not a $150,000 case. And there's no way I would recommend to him that he enter this process when the state is trying to lowball and devalue his claim. It's another form of dehumanization. Just because it's old, just because it happened in the 70s and 80s, doesn't mean it didn't happen. Those caps have to be raised. Our suggestion is that they be raised to the level that this legislature has already established. There are already statutory caps for individual acts and overall aggregate acts to individuals. And they're already in statute. And why should we make an exception? Why shouldn't we just use those? And frankly, given the numbers that we're hearing nationally about settlements in these cases, if the state used the caps it already has, it would be getting a bargain. And I would just also point out that the state doesn't really want to litigate these things. First of all, it's a steady drumbeat of negative publicity. Every time one of these cases is filed and motions filed and the state has, aggressively tries to defend it and kick kids out of court because of various legal technicalities. And then we have to go through all the acts and have them enumerated. And it's the slow drip, drip, drip of negative publicity against the state of New Hampshire. We don't want that for the next 3, 5, 7 years. Nobody does, certainly not the victims, but the state doesn't want it either. And who knows what a jury is actually going to do. There are juries all around the country who are so repelled by child abuse. Who knows what the state would end up paying if it decides to take the hard route rather than the easy route. And I suggest this bill could be the easy button with if the edits and amendments that we're suggesting are incorporated. And it's our hope that the state sees its way to seeing the wisdom and indeed the humanity of acting as we've suggested. I apologize for the emotion, but I have a hard time separating myself from the suffering that I'm seeing every day. Thank you very much.
Thanks. I'll start with just a quick question, then to you, Senator French. Where did these go? And I probably just haven't read them, and it's my fault, and I'll catch up. In the House, you have 3 ideas: price of admission, emotional trauma not being covered like solitary, and then
Yes.
you had the artificially low cap saying we should use what's on the books.
Yes.
Where did that go in the House? I'm sure.
Representative Rogers made the amendments, and my understanding, I wasn't actually at the final bill, but my understanding is that the bill started out, didn't even cover physical, so the House did move to cover physical, but they didn't want to go to emotional. I know there were some people saying, well, how do you value PTSD and things like that? Well, courts do it all the time. It can be done, but they decided not to on a close vote, as I understand it. But I've laid it all out in the edits and in the summary chart that what we think would make this bill work.
Well, you got another swing at the bat here, so thank you.
I very much appreciate that.
I appreciate you being emotional because it's a tough subject.
Yeah, I'm very eager to hear any questions if I can be helpful.
Thank you, Mr. Chair. Thank you for testifying today. You said your firm represents a number of these claimants?
Yes, about 500.
So the majority?
Well, I'm only aware of 3 others that are represented by someone else.
Yeah. So a lot of these claims you said from the 70s and 80s, and are any prior to that or after that?
We have some as early as 1963. The bulk of them are since 1980, and I would say the decade that is most prolific is the 1990s. Surprisingly recent.
And last question would be, so the average age of your claimants are 40s, 50s, 60s?
I've not done the calculation, but that sounds like it might be a good estimate.
Okay, thank you.
Senator Khan.
Thank you, Mr. Chairman. So, I appreciate you. I appreciate your testimony. It seemed that you were going through a list that looks like this.
Yes, that's our work product, Senator.
And that we've got something else that says NP Riley draft. That's not from you.
I'm sorry, I didn't hear that.
We have another document here. I'm just trying to trace people, their testimony, and some written paper. We've got something else from NP Riley, the draft of March 30, 2020.
Oh, MP Riley. Okay, yes, that is our, MP stands for Nixon Peabody, and Riley is my co-counsel.
Thank you.
That's the markup of the bill. I think that's what it is.
So these two documents go together.
Yes.
One's the summary of the changes you recommend, the other is actual line edits that
Yes,
you recommend.
yeah, we try to make it as easy as possible. And I also referenced the letter from Child USA, which I would recommend that the committee consult. I think it's a very good letter from people who really know what they're talking about.
Thank you for your testimony today.
Thank you, Senator.
Thank you very much. You have a great day.
Thank you.
Oh, I'm sorry, I didn't see it.
Oh,
Thank you, Mr. Chair. Thank you for taking my question. So I just want to, clearly you represent the vast majority of these folks.
Yes.
And I'm wondering what your involvement was in the negotiations in the House and, with the Attorney General and with all the folks involved, sort of that negotiations process and, is it ongoing? Clearly we're not going to vote on this bill today, but I would like to know how all the parties are working together.
well, I was definitely involved in all those discussions. I testified numerous times before the House, the Finance Committee, and had a lot of conversations and met with John and Jennifer numerous times. And this is where we are. Our position is laid out in the documents that the senator referenced. And John, of course, spoke earlier today. I don't think we're that far apart. It appears to me, I think the changes are pretty minimal. I mean, they are consequential, but they wouldn't take much to make this a bill that we would actually recommend that our clients used.
I'm going to ask you one more. Do you know, and I would think you do, what you're saying is artificially low is offered by Vermel in the state.
Yes.
What's the difference going to be if we went to the cap, if we went with your numbers and went with existing caps? What's the price difference?
I think for the individual incident cap, I think by statute is, I think it's 425,000. And the aggregate cap, meaning the person who's been abused, and I have some of these where kids have been anally raped more than 100 times. I mean, that aggregate I think is about 4.5 million.
Okay, so it isn't what I'm thinking. I'm thinking it was it's 139,000 per case right now. I've seen a number floating around per.
Oh, no, well, you have to read that whole chart. That's the first entry on the chart.
Okay.
The average in that's the AG's workup that says that the average settlement value around the country is about $500,000. And I dispute that. I think it's higher, but that.
So it's more than triple what we're offering though.
Yes, at least in the case of violence, yes.
Okay, so then we need a lot more money than the 100.
We may. I mean, it's hard to say without more work for instance, on the guidelines. And one thing I didn't mention is that right now the guidelines, they're very important and they're kind of married up to the caps because the caps will dictate to some degree the guidelines. But right now the guidelines still are going to be the unilateral recommendation of the AG. And that's not how mediation settlement processes work nationwide. Usually the matrix or the guidelines are done by agreement, because otherwise people won't enter into it. They don't trust the process. We have no idea what those numbers would be. And that's a serious departure from what is a normal best practice in a settlement process.
Quick question, one more?
Yes, sure.
For me, everyone else probably.
I'm here all day.
But just for me, are you, as is, you wouldn't sign on then? You represent the 400 and.
No, I would exercise my ethical obligation to my client to explain all the options. But I think, frankly, the way I view this is a bit of a trap.
Okay.
So, and I wouldn't recommend it, and I'd like to get to 95% participation because I believe in these settlement processes, but right now, you might get 5%, 10%, and meanwhile, we're going to be in the same position next year that we're in now.
Thank you very much, David. Have a great.
Thank you, Senator.
I'm sorry.
Wait, one more.
If it's quick.
You mentioned that the settlement cap is in statute.
Yeah, there's already, the legislature's already passed caps that apply in general, not just to these folks.
Can you tell me now, or maybe our counsel will tell us, he's going to give me a statutory reference. Thank you very much.
Yeah, we're just asking for the regular caps to apply that already exist for everybody. Why treat these kids differently?
I just haven't found that reference, but
Okay.
I'll get it soon. Thank you.
Thank you, Senator.
Thank you, Attorney Vivinanzo.
Thank you.
Did I get it?
Vicinanzo.
Okay, very
Or
good. Thanks.
Vicinanzo, what it used to be.
Representative Pat Long, you here, Pat?
Yes.
Oh, you already spoke, jeez. Okay. Dan, you haven't spoken on this, have you? Awesome. Good to see you again. You're here every day, every committee.
I'm going to try to avoid that. Thank you very much, Mr. Chairman, members of the committee. For the record, my name is Dan McGuire. I'm from Epsom, but today I'm representing Granite State taxpayers, our state's oldest taxpayer organization. We reluctantly support this bill because we think it's wise to pursue settlements rather than roll the dice and going to court on 500 individual cases. I mean, that's just out of the question. But I'd like to differ a little bit with a phrase used by a couple of previous speakers where they said that this abuse occurred at the hands of the state. It did not. It occurred at the hands of those dozen or so criminal pedophiles and sadists who were trusted by the state to do a difficult job, but abused that trust. And the reason, in effect, this bill creates another 1.4 million victims, namely the residents of the state and the taxpayers of the state, who are forced to cough up money because of those dozen individuals, or however many it turns out to be. But so, you know, obviously we have to do it, but it doesn't feel very good, and I would not try to blame the residents of the state as though that they are individual criminals and pedophiles and so on. The one section of the bill that I would like to address specifically is page 9, line 8, Roman numeral 14. So this is the section that puts limits on attorneys' fees. So, and it is very simple. It says if you go through this process, attorneys' fees will be no more than a third of the total amount grant given as a compensation. So what that means in essence is that if the total amount is 100 million, and we just heard that it's more likely closer to 300 million, right? Then the amount of attorney's fees for that is 33 million, or possibly 100 million if we get to 300 million. I mean, those seem like excessive numbers to us. And I think that it would be worth at least a discussion with the Attorney General or OLS to see what's common in other similar cases, not necessarily in New Hampshire, but elsewhere. I mean, this is obviously not the first such case that's occurred nationally. And it might be possible to put a steeper restriction on attorneys' fees, not just in the case of settlement, but perhaps even in the case of non-settlement, in such a way that encourages settlement and is also fair and gets more than 2/3 of the amount the state taxpayers are going to pay into the hands of actual victims. Thank you, Mr. Chairman.
Thank you. You were good today because half of them are gone.
All right.
Have a good day, Dan. Marissa Chase. Could someone check if she's in the hall? She was, oh, there you are. Okay, you're slow on the uptake. You're usually fast. Good to see
Gathering
you.
my things.
Attorney Chase, good to see you.
Not an attorney, but I appreciate it.
Okay, I thought you were going to forget.
Good morning, still members of the committee. Thank you for taking the time to hear us all out today. My name is Marissa Chase. I'm the Executive Director for the New Hampshire Association for Justice, which is a statewide professional association of plaintiffs' attorneys. We really appreciate this bill being brought forward. This is a unique bill, but not a unique process. Aside from the 9/11 Victims Compensation Fund that was passed by Congress, every similar mass tort settlement fund that's been created has been created as a matter of case law. It's been created by both parties entering into, or all parties entering into an agreement. So this is a unique opportunity for the state of New Hampshire to set a precedent that the rest of the country can follow. A lot of responsibility riding on New Hampshire to get this right. This bill before you is very different as it was introduced. NHAJ believes that it is close to something that we could endorse. I believe we share the same concerns that Attorney Vicinanzo stated. We have a few outstanding issues. Starting at page 4, line 18, the way in which the damages matrix is set up is weighted heavily towards the state. If we're hiring an administrator, we, as you heard Attorney Vicinanzo said, we believe they should be the ones to mediate. That's how it works in civil cases all the time. We believe that the cap should be higher based on verdicts in similar cases. As Attorney Vicinanzo says, probably closer to $4.5 million is probably the norm. And I say that because if there is to be a bellwether case, for instance, if one of these cases were to be brought in federal court, where the verdicts are higher typically than in state court, and there's a large verdict that comes in favor of one of these plaintiffs, then there's going to be no incentive for victims to enter into this process. So if the goal is to, as Attorney Vicinanzo says, cover about 95% of the claimants, I believe it's in everyone's best interest to incentivize everyone to participate. The definition, we share the concern of the definition of sexual abuse should be expanded. For instance, kids who were forced to watch guards masturbate or other horrific acts, that doesn't include a physical component. And I appreciate the Attorney General's office so much for all the time that they've taken in, working with all parties and trying to find compromise. And I appreciate that they are still willing to have conversations and try to come to an agreement on some of these outstanding issues. We'd be happy to work with all stakeholders to get to a much needed resolution from these victims. And there were 2 other issues that I believe the Attorney General's office has indicated they are willing to support. And they both have to do with how the money awards, making sure that the money is going into the hands of victims. Working on the definition of recovery versus compensation, because compensation can be taxed while recovery is not, to make sure that victims aren't unknowingly taxed on their awards. And some insertion of a line like understanding the time value of money, so that if claimants opt for one of the 3 options for getting an award that is 10-year installments by the state, that the claimants get any interest generated on that money, that money is not kept on by the state. Otherwise, it would be as if the state were profiting from victims. So I really appreciate the agreement, that the Attorney General's office recognized that. Again, this isn't a new concept in civil law, tort law, but it is new in terms of putting legislation together. So this has been a hard process with a lot of agreement and a lot of deep thought. And I'm confident that, confident and hopeful that the end product will be something that we can all be happy with.
Senator Whitley? We're all set. Thank you, Marissa.
Thank you very much.
I think that is it, unless there's someone else here to testify. that I've missed? Go ahead, come down, I'm sorry. Looks like we were good. That's okay, go ahead.
The record my name is John Joy. I'm here at the director of the Captain Rogers. Representative Rogers intended to be here today. Unfortunately, she's back in the hospital and can't be here. She's received from her work in the house, received letters from victims. There's one she found particularly compelling and asking. My name is Andrew Green. I'm writing to you because I'm a survivor and victim of the YDC state-run facility abuse scandal case. I feel the state of New Hampshire is trying to take away from the fact that we are the victims and take away the severity of the abuses, in a sense, make light of a situation that I personally had to endure, years of abuse and torture, sexually, physically, mentally, and emotionally, at multiple state-run facilities, and not just at YDC. Although no amount of money can take away the lives of pain, turmoil, and damage that the abuse I suffered has caused, I'd like to think that after years of suffering silently, in secret, self-medicating myself, and becoming an addict that now I'm hiding in the dark with my secrets about my childhood, I am speaking out and voicing what happened to me, which still affects my life to this day, and that the state of New Hampshire should take responsibility for what children have to endure. My physical wounds have healed. The pain from the beatings and rapes have healed physically. But something that has never gone away is the everlasting emotional and mental scars and wounds that remain with me since I was a kid. I guess for me, all the abuse were equal and did its damage fully. But all of them have one thing in common. They all cause tremendous amounts of stress, anxiety, flashbacks, depression, shame, fear, terror, and hopelessness. Most of these things have affected my life and still do to this day. I've been diagnosed with traumatic PTSD, chronic depression, anxiety, and all of this stems from abuse. I feel it is very important for the representatives of New Hampshire to understand that this abuse is not temporary, that the effects are forever. Mentally, emotionally, physically, financially, this dramatic multitude of abuse I have suffered has taken away pieces of me I can never get back. I can never fully accept or heal from, and it has negatively impacted my ability to live a normal life. Sincerely, Andrew Green, age 31. Mr. Green is currently an inmate at the facility. Representative Ryan wanted to put a face as the Senate mentioned before. We can't allow ourselves to forget who we're talking about, through all of the machinations, what's right and what's wrong. This entire incident is wrong, and we can never fix it.
Thank you very much. We're all set, thank you, have a good day. Okay, I believe that ends testimony on the bill. Thank you. This looks like something I handed in high school. That's it. Thank you, at least.
Okay. Going to go ahead and open the public hearing on House Bill 1673 and recognize the prime sponsors, Representative Smith. And I believe you have Representative Wolper with you. Would you both like to do this together? Okay, terrific.
We call it judicial economy.
Good morning. My name is Marjorie Smith. I represent Stratford 6, which is Durham and Madbury.
And my name is Representative Kurt Welper. I represent Stratford 3, the towns of Stratford and New Durham.
And those of you who are paying attention might think it's strange to see the two of us here together. And we are here together representing or demonstrating, not that politics makes strange bedfellows, but that the process of legislating is complicated and painful. And sometimes one has to go to the lowest common denominator in order to find agreement. And the lowest common denominator is acceptable when everything else fails. I filed 1673 as part of an effort to continue to refine what is referred to as the Fetal Life Protection Act. This was a section that was added to House Bill 2, even though it had nothing at all to do with the budget. And as a former chair of finance, I know that finance never gets involved in policy, only in numbers. And sometimes there's an exception to the rule. After a great deal of work, I came up with a majority amendment. And the majority amendment had 3 different parts to it. The first is a part that you are very familiar with, having to do with the language that needed clarification concerning ultrasound in that. And my goal was to make clear that the ultrasound was to be used not for all cases where an abortion was being considered, but only when there was a question of whether you had reached the 24-week. The second part of my amendment had to do with fetal anomalies incompatible with life or a medical emergency. And the third part had to deal with eliminating the civil and criminal penalties for violation of the Act. Medical care in the reproductive or health gynecology field, including abortion, is provided by medical professionals who are licensed by the New Hampshire Board of Medicine, the New Hampshire Board of Nursing, and they oversee the education, background, training of every doctor, nurse, practitioner, and physician's assistant, and they hold them responsible to standards. There are professional requirements for licensing, and they're subject to credentialing. I believe that adding this component of criminal and civil liability was superfluous and irrelevant. So that was the bill that actually passed the Finance Committee. The Judiciary Committee. Old habits die hard. And went to the floor. It went to the floor very late at night, and the majority amendment failed by 2 votes. But recognizing the importance of each of these sections, we were able to move on to the minority amendment, and it is that minority amendment that is before you today, and I am here to make sure that you know that although I'm
would have preferred something more complete. I am completely in support of the minority amendment, which was sponsored by my colleague, Representative Welper.
Thank you, thank you, Representative, for your testimony. Representative Wolper.
Thank you. And I want to say I'm highly encouraged to see Representative Smith here with me today. We don't agree on much of this issue, but we have agreed on this, as has the House and as has the Senate, now twice. Once when the Fetal Life Protection Act was passed, and again this year with your Senate Bill 399 and our House Bill 1673. So for me, I'm in disagreement with pretty much everything that Representative Smith said. I think the parts of the Fetal Life Protection Act that she would remove or modify, with the exception of this, which isn't really an amendment of it, are necessary and good. They both were fully vetted last year in the House and in the Senate. And it's true they were passed in the budget, but they were both fully vetted in both these houses. So I'm here to say the House and the Senate have concurred in the past, and they concur right now on what the change to the Fetal Life Protection Act should be. I would recommend that you OTP this bill today, as it is the position of the Senate already, and that you exec it today so that we can make it the law of the land.
Thank you very much, Representative, for your testimony. Are there any questions from the committee? Senator Gannon.
Hi, Representative Walper. Good to see you. Just a quick question for you. And I realize that the bill that we passed previously had 24 weeks in it. But whereas viability is happened as early as 21 weeks in the United States, are you still good with the 24 weeks?
I don't believe we should be making any changes to the Fetal Life Protection Act at this time. I would prefer to see a much lower number or some other standard, but that isn't my preference. And last year I did not get my preference.
I'm all set. Thank you.
I'm happy with that.
Thank you. Any questions? Seeing none, thank you both.
Back to work.
Doing it, they're not speaking. Liz Canada. I had to look at the clock. Still good morning.
Sure is. Good morning.
Good to see you today.
Thanks for having me. Good morning, honorable members of the Senate Judiciary Committee. My name is Liz Canada, and I'm the Advocacy Manager at Planned Parenthood of Northern New England and Planned Parenthood New Hampshire Action Fund. And we're here to support House Bill 1673. Before January 1st, 2022, conducting an ultrasound prior to abortion care was up to a clinician's best medical judgment. A provider could work directly with the patient on whether an ultrasound was necessary. On January 1st, the ultrasound provision went into effect and is written in such a way that requires all patients in New Hampshire seeking abortion care to undergo an ultrasound, whether medically necessary or not. This provision is impacting patients who are seeking abortion care early on in pregnancy. Those who are prior to 11 weeks, know the date of their last menstruation, and have no risk factors. For those patients, an ultrasound is not always medically necessary, and yet they are now required to have one. To be clear, the ultrasound requirement affects PP&E's ability to center patient autonomy, deliver trauma-informed care, and make sound medical decisions. Under this law, ultrasounds are mandatory, no matter the individual circumstance or recommendation of the clinician. We support House Bill 1673 because it clarifies the ultrasound requirement in relation to the newly enacted abortion ban, rather than prior to all abortion care, which is the current New Hampshire law. This bill is one of 3 active bills that would address the ultrasound requirement. The others being Senate Bill 399, which this committee amended to be identical to the language in front of you, and House Bill 1609, which just passed out of the House last week in a 231 to 114 vote, and you'll hear next week, and which also uses this exact same language. But in terms of this bill, we'd ask that you vote ought to pass on House Bill 1673, and I thank you for your time.
Thank you very much for your testimony. Sorry, I had to step out.
Okay, I have some written testimony too. I'll pass around.
Yes, that would be terrific. Are there any questions from the committee? Seeing none, thank you very much.
Thank you.
Okay, next, we're going to call Frank Knack. Good morning again, Mr. Knack.
Good morning, Madam Chair, members of the committee. My name is Frank Knack, Policy Director with the ACLU of New Hampshire. We support this bill for all the reasons my colleague from Planned Parenthood just elaborated. Don't want to take up any additional time of the committee and appreciate your hopeful support for this bill.
Okay, thank you very much for your testimony.
Thank you.
Any questions? Seeing none. Next, we will go to Chloe Ezzo.
Hello, good morning. Thank you for the opportunity to testify. My name is Chloe Ezzo, and I am an undergraduate student at Dartmouth College, and I am in charge of our pro-life group.
Thank you.
Planned Parenthood is lying to young women. They are saying that abortion is healthcare. This is not true at all. I can tell you that it's very simple. Healthcare should not kill. But when a woman has an abortion, every single time it ends with the life of an unborn child being taken. It is a very simple truth that life starts at conception. A fetus is not a thing. It's not an it. It is a human being and should therefore be extended human rights. 24 weeks is a modest protection. It is the bare minimum we can do to protect the preborn. I can tell you that having a child is not life-ending the way that Planned Parenthood would have us believe. When I was 20 years old, I worked as an au pair, and I took care of an 8-month-old child. Being an au pair involves living with a family and taking care of their children. And so this child was very, very small. And it was, for me, a wake-up call. I realized that it was actually very empowering to take care of a small child, and I was perfectly capable of doing it, even at a very young age. Women do not need abortions to have successful careers and fulfilling lives. And I really hope that we can understand at some point that women deserve better than abortion. They deserve better than something that is going to leave them with trauma that will follow them for the rest of their lives. Thank you. Any questions?
Thank you very much for your testimony. Are there any questions? Seeing none, thank you very much for your time. The chair will call Ian Hewitt.
Good morning, Madam Chair and
Good
members
morning.
of the committee. It is still good morning. I think I'm the
Yeah,
last
you got a
person that
few
gets to wish you all good morning. Ian Hewitt on behalf of Cornerstone in support of House Bill 1673. As previously indicated, this language is very familiar to you all because it is identical to the great work that this committee and the Senate did on Senate Bill 399, which we endorsed. In fact, verbatim, word for word, identical. And I just want to draw the committee's attention to two implications of that. One is that it's kind of an accident of procedure that we are even here. Typically, when both chambers pass verbatim identical language, that language goes to the governor. In this case, the language just happened to appear in two different bills. We think the fact that both chambers have already spoken in favor of this particular language cuts in favor of passing this bill in its current form and giving the bill the chance to be signed by the governor, as Representative Welper indicated. The other thing I would point out is that this isn't simply a compromise or something we can live with. This is language that we endorse. And to the best of my knowledge, the pro-life community in New Hampshire, which does not agree amongst itself on everything, is unanimous in explicitly endorsing this language. That's because from our perspective, it forecloses the ability to cite 44.1 out of context in a way that misrepresents the scope of the ultrasound requirement. Now, on the other hand, as you just heard about, this, after it was amended, passed the House with a voice vote. So we think this is a rare instance where this committee and the Senate can essentially please everyone without giving up anything, including without giving up the opportunity to consider substantive modifications to the Fetal Life Protection Act, which it will certainly have when it hears House Bill 1609, which contains a substantive modification and is on its way to the Senate. Thank you.
Thank you very much for your testimony, Mr. Hewitt. Are there any questions from the committee? Seeing none, thank you very much.
Thank you.
Seeing that everyone who has signed up to speak has had an opportunity. You're representing her?
She is representing.
You did not sign up that you wanted to speak, so, but that's okay, come forward. Yeah,
That was one I meant to sign up on.
okay.
Okay, thank you very much. Good morning, well, now, good afternoon. My name is Amanda Elizabeth Toll, and I represent the city of Keene at large, and I'm here today in support of HB 1673, of which I am a co-sponsor, to end New Hampshire's mandate that all people seeking abortion care at every stage of pregnancy first have an ultrasound. I, along with the vast majority of my constituents, oppose New Hampshire's abortion ban and mandatory ultrasound requirement. New Hampshire residents are some of the most supportive of reproductive freedom in the country. Polling shows that the abortion ban and ultrasound requirement is deeply unpopular with Granite Staters. The anti-abortion movement has explicitly pushed ultrasound mandates with the goal of shaming and inconveniencing pregnant people out of terminating pregnancies. It is an affront to Granite Staters who value freedom, gender justice, the sanctity of the patient-provider relationship, healthcare access, and our civil liberties for government to force constituents to undergo a medically unnecessary procedure explicitly intended to shame pregnant people. Let's be clear. It's absolutely inappropriate, outrageous, and harmful for the government to enact policy aimed to shame people out of getting the health care that they need.
Representative, just to interrupt you for a second, you do realize that this bill repeals that?
Yes, I said I support it.
Okay. Because
I'm a co-sponsor.
Okay.
And that was my first paragraph.
You know that this bill is repealing this, not.
I am supportive of the bill. Okay. That was my first statement, is that I am here today in support of it. So, politicians are not healthcare professionals, and we've heard an outcry from healthcare professionals and patients across the state in opposition to both New Hampshire's abortion ban and this ultrasound requirement. This harmful law negatively impacts the physical and mental health of pregnant people by putting ideology over evidence-based practices and high-quality patient-centered care. I hope the Senate Judiciary Committee does the right thing and stands by providers and patients and passes HB 1673. Thank you so much for hearing my testimony, and I'm going to defer any questions to the primary sponsor and the reproductive rights advocacy groups here today. Thank you very much.
Thank you for your testimony. Are there any other members of the public that would like to speak to House Bill 1673? Representative?
Sorry, I didn't want to speak, but
you are?
Walter Stapleton, Claremont Ward 3, Sullivan County, District 5, House Rep.
Yes, please, go on.
Thank you, Madam Chair. Members of the committee, I'm going to say not but a few words here. After you saw both parties sit at this table to affirm the agreement they reached after long and arduous work in committees and sessions. That is the testimony that this is a good bill, and we really should pass it and put the difficulties and the differences behind that have been resolved by both sides. So I'd ask you to support this bill. Thank you.
Thank you very much for your testimony. Are there any questions? Seeing none, we're going to go ahead and close the public hearing on House Bill 1673. Did I see somebody's hand go up that wanted to speak? Okay, no, we're going to go ahead and close House Bill 1673. The committee will be in recess until 1 o'clock. Yeah, it wasn't off too much. Jenny, oh, let me,
Thank you. This bill is to establish a commission to study the New Hampshire family court system. And we were asked not to start any more commissions, so I changed it to a committee, and the Children Family Law changed it back to a commission and added their edits. So I apologize if that seems excessive, but it certainly is going to be helpful to have more public eyes on the things that need to be corrected in the family court system. It is not meant to be an indictment of all family courts, but in several courts, rights that people would have if they were being criminally charged in a criminal court, they don't have in family court. So that's just, we will hear from other people who really desperately need some changes in family court and make it a public forum, just lasting no more than a year, so that many different issues can be addressed publicly and by the people who are affected by court. I understand that the court is doing its own review, in fact, already has done a month-long review. And so that's good that the court's looking at itself. But to be a complete study, you really need to have input from people whose lives are dramatically affected by the decisions made there. So that is my introduction, and I understand there are people here who want to tell you their personal experience.
Thank you very much, Representative. Are there any questions for the representative? Senator Gannon.
I'll just be really quick. So I used to, like, back in the old days, 30 years ago, I was in family court for a year or two a lot. And it seemed so well run everywhere. They were so bending over backwards. They didn't follow, they were very loose on procedures. If you didn't have a lawyer, they were bending over backwards to make sure you were accommodated and treated fairly. And is it just anecdotal evidence? Is it just a few people have come to you, or have you heard an overwhelming outcry that the family division is not being?
I have been contacted by scores of people.
Scores, okay.
Yes. So
Okay,
I
thank
think
you.
they'll tell their stories more effectively than I can.
Thank you.
Thank you.
Thank you very much, Representative. The chair will call Representative Stapleton.
Thank you, Madam Chair, members of the committee. I am Walt Stapleton, Claremont Ward 3, Sullivan County District 5, House Rep. I have submitted to the clerk a article from New Hampshire Bulletin back in December of 2021 entitled "Victims of Domestic Abuse Find No Haven in Family Courts" by Joan Mayer. I'm not going to talk on that because it's pretty self-explanatory, pointing out that the parental alienation syndrome by a psychiatrist, Richard Gardner, back in the 1980s, set the stage for opinion by both courts and the public that parents alienate one another, specifically women against husbands, and that has resulted in a lot of bias in court decisions ever since. Now, that's been since debunked as an erroneous proposition, but it still seems to perpetuate in the minds of the public and maybe even in parts of the court. So it's important to recognize where some of the bias comes from, and that's why I submitted the article. But to my testimony today, you know, media articles over time relative to malfeasance cases in the court system, coupled with hearsay of skewed and even harmful family court decisions, means it's time for an earnest look inside. As we have an ever-increasing plethora of marriage, broken marriages, family youth problems, and even abuse of children, we need to find out if family court is working or not. It's time. As background for this bill, a prime sponsor interviewed a number of people who have experienced some difficulties and adverse results in the system. Most do not want to testify due to pending cases or fear of jeopardizing the outcome of their cases. That is why subpart Roman 4 on page 2 of the bill is so very important. Monthly hearings to an official commission or committee may very well enable such testimonies to come forward that have been hidden or suppressed for some time. You know, the old expression, where there's smoke, there's fire. We need to take a look at the family court system so that we don't have a blind eye and abuse resulting, not unlike perhaps in the YDC case that was brought to you this morning. So failing to look at something is asking for trouble, is asking for something to go wrong, if that might be a tenet of Murphy's Law. So I would ask that you pass HB 1346, and let's work to straighten up the family court, or at least find out if they're doing the job or not. Thank you.
Thank you, Representative. Are there any questions? Okay, seeing none, thank you. The chair will call Representative Belanger.
Morning, Madam Chair, fellow senators. For the record, my name is Representative Cody Belanger. I represent Rockingham District 9, again, the center of the universe. So when this bill came forward in the House, one of the discrepancies that I had with it was not having an end date. We hear a lot from people, both in the House and I'm not sure in the Senate, but we hear from people across the state who have been impacted by judges, guardian ad litems, and you'll hear from bills today that hopefully address those concerns. But establishing a commission without these changes, I think would kind of, in my opinion, not be prudent. I think if we were to do this, I would like to see an end date in sight. That is my personal opinion, and I hope that you take that into consideration when formulating your executive session. With that, I'll be happy to take any questions.
Thank you very much for your testimony. Are there any questions?
Just a quick question.
Senator
Thanks for
Gannon.
taking my question. Did Representative Gay, does she like your amendment? Has she seen it? You do? Okay. She's nodding, she does. She was the author of the original bill, I didn't know.
Right.
She's nodding, she likes it, so double thumbs up. You're all set.
Thank you. I would just like to point out the bill as amended by the House on page 2, beginning on line 18, there is a repeal, and it shall take effect November 1st, 2024. So if this gets passed, they're going to do the study, issue a report, and then it's repealed in November of 2024.
Correct.
So is that good? Because that's the end date.
So, I guess I wasn't clear, and thank you for the question, Senator. So I helped work on the amendment, and so that was one of my caveats, was that there wasn't, and that's why we put it in. I'm sorry, I wasn't aware that, I'm sorry, I did not apologize. Apologies for not being clear, but that was what I was getting to, and I apologize.
I can't, you know.
That answers 2 questions. That's great.
Okay. Thank you very much for your testimony.
Thank you, Senator.
The chair will call Richard Head. Good afternoon.
Good afternoon, Madam Chair, members of the committee. My name is Richard Head. I'm the Government Affairs Coordinator for the Judicial Branch. We do have significant concerns with regard to this bill, not that we don't want the legislative body to have a committee to look into how family division works, but to take a quick step back, as I had mentioned in previous testimony, Circuit Court is made up of 3 divisions: District Division, Probate Division, and Family Division. Same judges are hearing cases in all of those divisions, and where you're hearing the quote unquote complaints are family division. And you think about sort of what is family division? Why is that creating more concern than you see in district division, where, for example, people are being put in jail, people are being, imprisoned. It's sort of interesting. And if you look at it from the perspective of, what are these divisions doing? And you look nationwide, family court is a source of legislative complaints. And a lot of it comes down to sort of what is being decided at these things. In a criminal case, in a civil case, it's deciding right and wrong. Who has done something wrong? Who has harmed somebody else? Who has committed a crime? And the court is taking those facts and deciding this person did something wrong and they deserve to be punished financially, imprisonment, whatever it may be. Family division, nobody has done anything wrong. It is a family that is no longer able to sustain itself as a family. It's not a right or wrong. It's not that somebody needs to be punished. It is, we now, by no fault of the court, no fault of the parties per se, fault in the sense of doing something wrong. I'm taking aside those that are based upon bad behavior, wrong behavior, but people get divorced. And we're now dividing a single household into two households. We're not putting new money into that situation. We're taking the same resources and splitting it and doubling and putting it into two. And the courts are being put in a position where one of the things that has to be decided is parenting. It is an incredibly difficult thing because you cannot have a child go with two parents 100% of the time when they're not living together. And nobody did anything wrong. Nobody deserves this. The child doesn't, certainly the child did nothing wrong. The parents did nothing wrong. They just need to break up this relationship. And the court is not deciding right or wrong. It is deciding how do we now distribute what used to be a single household into multiple. And the other aspect of it is the vast majority of cases are going to resolve by the parties. They're going to resolve in mediation. They're going to resolve outside of mediation, but the parties can resolve it on their own and they come in with an agreement. Those are not the cases you're hearing about. It's those cases where parties cannot agree and they're asking the court to do what they cannot do. And the court now has to make a decision, and it is going to make a decision that somebody is not going to agree with. By its nature, it is a contested case, and they are not going to give relief to both parties who are asking for different relief. It just is not possible. And what we're talking about is children, and we're talking about a parent's relationship with children. It is incredibly difficult, incredibly personal, and it is not a decision of right and wrong. It's a decision of what do we do now that we're faced with this situation. So I think it is, and then from a person who is not receiving the relief they want from the court, very naturally looking, how else can I get what I want out of the termination of this relationship? You are the next stop in terms of where you go to try to get relief, because I understand they want to get what they asked for. And I am incredibly sympathetic to that, but I'm also very sympathetic to the role a judge has to play in what is before them. And what they have to do is take the information and only the evidence that is before them, not anything that's not before them that's relevant to what they are deciding, and have to make a decision. It's contested, so somebody is not going to get what they asked for. And then as to the bill itself, so one, it is a commission, so it's not just a committee. It involves outside parties. I'm not sure those outside parties have been, truthfully, I just don't know the answer to this, if they've been consulted and weighed in on the role and the tasks that the commission would be undertaking. But if we go through it, paragraph Roman 3, beginning on page 1, line 21, shall study parenting cases and decisions by the courts.
this is a very bad time to be pulling resources out of the courts, because what that sentence means is we are going to relitigate cases in front of this commission. We're going to have staff, and these are paper files. Staff is going to have to do something to study parenting cases and decisions by the court within the judicial branch family division. So it is a great deal of resources that are going to be directed towards a 2-year commission that meets monthly, that has as one of its tasks what appears to be potentially relitigating cases that have been that are in this family division. And we're at a time in post-COVID where the courts are stressed. We, as everybody else in the nation is experiencing, cannot fill all staff vacancies. We have, we're trying to catch up on cases that were delayed in the pandemic. We have a public defender shortage, so criminal cases are we're trying to pull those in. It is a stressed environment that we're asking to say, we're going to pull resources out, and I'm not sure how this commission is going to direct us, but would be asking us to do something on files and sort of present them. And what we're talking about can be large files, like multiple bankers' boxes worth of files. So it is a potential high stress for the circuit court and for staff in the circuit court at a time when it is already in a stressed environment. The line 23, frequency of equally shared custody decisions. There is legislation that is already in this session dealing with equally shared custody decisions. And custody is a term that by statute we're not even using anymore. But the shared parenting, you've already got some legislation this session. It may be, let's down the road see how that is filtering out. But the House bill, there's a House and a Senate bill on both of those. The lines 24 and 25, the effect of delay enforcement of the financial support of children has on children meant to be supported by the order. I think it's a directed question, which is you're going to find that delayed enforcement causes an impact on children. Do you need a 2-year study commission? The question is, how do we, maybe a better question would have been, how do we enforce, and are there tools that we need to put into the system? I think you can do that through talking with DHHS about, where are we lacking resources. Line 26 is similar to line 29, and you're going to hear another bill dealing with waiver of court rules. And as Senator Gannon mentioned, this is an environment where we have a lot of unrepresented parties. Rules do get waived. In fact, rules sometimes don't get waived at the request of parties. You have both. But it is, and there's a quote out of the Supreme Court that says why this is and why this exists. And what the Supreme Court has said is the purpose of the rule which allows for waiver is we have emphasized justice over procedural technicalities. And the Supreme Court decisions are in line with that. You need to be able to provide flexibility, because if you don't, and a rigid enforcement of rules, so for example, there's a case in the Supreme Court, and last night, I'm not saying I captured 100% of the cases that deal with waived rules, but I only found 7 or 8, and there are lots more. It's a very tiny percentage of issues before the Supreme Court about improper waiver of rules. But the Supreme Court has been very consistent. For example, we have the waiver of rules is not done to come to a solution. It's to ensure that the cases are able to move. So, for example, if you don't waive a rule, the remedy is not, well, I'm sorry, you didn't file something, you're not going to have any parenting rights. It's going to be, we have to delay this proceeding. When, in fact, a waiver of the rule
promotes justice. The parties are able to, manage it, and it's just not something you can sort of easily study. And yes, there are circumstances where rules are waived, and one of the parties feels like the court should be punishing the party who is seeking the waiver of rules, and that's not the role of the court. The role of the court is to ensure that all the information is available. And it promotes justice. And I'm not sure, studying these two things, the effect on opposing parties and the effect on the number of appeals, especially where there's only about 7 or 8 appeals over that I could even find.
Mr. Head, would it be fair to say that you believe that the duties of the commission need to be refined?
I think 2 things. One is if this is going to go forward, the duties of the commission need to be refined. And I'm happy to work with the committee in terms of goals that would give an opportunity for parties to come and express themselves, but also provide useful outputs for the legislative branch, for the court system, and for DHHS. I do not think that these goals here do it. I think it could be a study committee made up of legislators. And I do worry about sort of the page 2, line 6 and 7, that this becomes a redress of grievance committee as opposed to a study committee that is targeted to come up with solutions. But yes, I think that is a fair statement, and I'm happy to work with the committee to come up with a list. Thank you.
Thank you very much for your testimony. Are there any questions from the committee?
Really quick.
Senator Gannon.
Thank you. Representative Gabe said she had scores of people who have come with these extreme cases of judicial misconduct or being a bad actor or whatever. We do have a judicial conduct review board, correct?
Okay.
Have you weeded out in the last decade any judges who were overreaching maybe, or needed to be removed or set straight on how they were running their courtroom?
So it doesn't happen a lot. So Judge Intricasso is a recent example. She was brought before the Judicial Conduct Committee. She resolved it, settled it before by withdrawing her judicial post. She's ultimately lost the license to practice. There are a number of people who are upset about the process there, but ultimately she has been removed. Master Delpra made comments that were captured on audio, and Master Delpra has resigned. There have been some instances, and I don't remember all the names.
Quick follow-up?
Yes, follow-up?
Small number. I don't know how many.
Do you think the court's taking care of its own problems, the judicial route?
I think we try to where we hear about them. I think it is we can't weigh in on case-specific issues. If there is a process issue or there is a training issue, yes, we do manage that. We do not, on the administrative side, I think, weigh in on case decisions.
Thank you.
Any further questions? Seeing none, thank you, Mr. Head.
Thank you.
The chair will call Dan Itzy.
Thank you, Madam Chair. For the record, I'm Dan Itza. I am now residing in Manchester, and I do fully support this legislation. As you know, I was a member of the General Court for 18 years. 16 of those years I sat on the Children and Family Law Committee. And one of my chief interests was reforming the family court. And I have to understand, until 2005, the family court was a pilot program. It ran in 2 counties until I think about 2001, and then was expanded to the whole state in 2005. It was expanded to 2 more counties in 2001 or 2. Since 2005, the family court has become much more problematic. I know personally of 2 instances, for instance, in which sealed envelopes were used as evidence and substantially changed the outcome of hearings. No one ever saw what was inside the envelope. One of those instances was witnessed in person by then Representative Ingerson, We went back and checked the files. There was no record of the envelope was not there. There was nothing in the file that identified it as contents of the envelope. So who knows what it was? You were led to believe that what the family court deals with is divorce, and that is probably the majority of its cases. But it also deals with, I believe, chins, and I know it deals with DCYF cases. I know of a recently concluded case in which, in the preliminary hearing, the respondent was not allowed to present any evidence. That ended up putting the family through about 3 months of hell, only to, in the end, the master in the case did the right thing. He found that there had been no abuse, but it could have all been settled at the outset if evidence had been omitted. And it cost the family $50,000. That's a pretty big nut to swallow. There are issues of process in the family court, consistent issues of process. When we did have a redress of grievance committee back in 11 and 12, 29 of the 31, I think, petitions regarded the family court. And the good thing about doing that was we were in fact able to see patterns, and between the two bodies, we did resolve one of those issues. There are some other outstanding issues that have never been resolved. I think it deserves a good look-see. It's the one court that we do have complaints about consistently. And it's not just because it deals with family issues, and that is a significant component of it, but it is also the only court that deals almost exclusively by court rules which can be waived. And it's important for you, the legislature, to understand where the system is breaking down when it breaks down and to take corrective action. And this is one example of how you can find that information out. I'd be happy to take any questions.
Thank you very much. Are there any questions from the committee? Senator Khan.
Thank you. Thank you, Madam Chair. I hope I haven't missed this, but there's a list of what is included in the study commission here. And I don't even know the answer to this, and how a judge is removed from family court. Meaning there's a laundry list of things being suggested here. That just seems like another possible suggestion. Is that something that you'd agree to see?
Constitutionally, the way that a judge can, there are two ways that a judge can be removed from the family court by the legislature. One is by bill of address for actions not in their office, and the other is for impeachment for actions in their office. So the only thing that would apply in this situation would be impeachment. And that's a long and arduous process. Other than that, I mean, though it obviously can result in a resignation, the Judicial Conduct Committee can't remove a judge. The Supreme Court can't remove a judge. Only the legislature can remove a judge, or they have to resign.
My question is, would it be an appropriate item to add to the list of what the committee is going to look at?
Sure, I think that would be a very viable thing to look at.
One of those interesting.
Yeah.
Thank you very much.
Are there any further questions? Seeing none, thank you very much for your testimony. The chair will call Gail Drobet.
Good morning, Madam Chair, members of the committee. Thank you for the opportunity to testify before you today in support of HB 1592. As our elected policymakers, you have the greatest ability to reform outdated statutes to better protect the citizens of New Hampshire, most importantly, children. You have the ability to ensure that legislation being passed is compliant with constitutional protections. I testify before each of you and ask for your support in passing this important bill to better protect New Hampshire children. We see time and time again in local and national news that New Hampshire children are not being protected. The best interest standards are not being met. By way of example, Harmony Montgomery, Elijah Lewis, these are recent children that have not been protected by the systems of New Hampshire. I would ask you all to remember Josh Savion, who was failed by this state. I did not know Josh or his family personally, but I do want to remember him. I want to remember him because my daughter will be graduating this year, the class of 2022. My husband and I will proudly watch our daughter walk the stage and accept her diploma. Josh's mother will not do that. There will be an empty chair in that stadium where Josh Savion should be sitting with my daughter and all of their classmates waiting to accept his diploma. The systems that are currently in place seem to be failing the very innocent children they claim to be protecting. I've had the opportunity to listen to testimony over the past several months and to include testimony from yesterday's judiciary hearing. We heard testimony about constitutional protections of parents. New Hampshire Constitution provides those same protections. Supreme Court rulings provide those protections to parents, as well as state statute laws to guide, educate, and raise their children as they see fit. The state may interfere only with a compelling state interest, i.e., finding with clear and convincing evidence of abuse or neglect. I think we can all agree, or at least we should, that the family court is the most important court as it is supposed to protect children. The adversarial nature created in the family court, pitting one parent against the other, constitutionally protected parental rights being trampled, state statute laws that are not being followed, to name a few. In the executive session hearing yesterday, House Bill 1592, one of you stated, I'm not sure which one, couldn't a complaint be made to the Judicial Conduct Committee? In reality, that should be an avenue that could be taken. This appears to be peer-on-peer review, and most often complaints are unfounded. In speaking to that, complaints to the Attorney General, Attorney Discipline Office, Guardian Ad Litem Board, and the Mental Health Board go unfounded, unfounded, unfounded. You are not going to get a peer-on-peer review board that will often acknowledge wrongdoing. We continue to hear ad nauseum of family litigation being dragged out for years, court-ordered therapists, guardian ad litems, you name it, it's ordered until every financial resource of a parent has been exhausted. The abuse of judicial power is real. The trauma perpetrated on children and families is devastating. By way of example, one dad had not seen his children in approximately 6 years. That dad had stopped fighting. After several false DCYF reports, threats of losing his driver's license and professional license, it is impossible for a parent to live and support themselves, pay ridiculous child support orders, New Hampshire being one of the highest support ordered states, attorney fees, guardian ad litem fees, counseling fees, and so on. A mom that was a custodial parent and primary caregiver since birth became an every other weekend parent in a 20-minute status hearing on a recommendation made by a guardian ad litem, which I point out the word recommendations was removed from RSA 461A16 statute in January of 2019. Guardian ad litems are fact finders. They are to render reports and not make recommendations. Another dad, his children were moved out of state over 3,000 miles away. Another parent has nearly 400 pleadings. Every pleading he has filed to protect the minor child falls on deaf ears. Requests for evidentiary hearings denied. Requests for the minor child to be in counseling ignored or denied. What the court will address is monetary gain for the guardian ad litem that did not follow her order on appointment. Attorney fees for opposing counsel claiming the other party is filing repetitive frivolous pleadings. Those so-called frivolous pleadings are requests to protect the minor child, and for documentation, the court ordered the minor child's therapist to provide. To date, the therapist is still in contempt of the court's September 2020 order. I will also give you a small glimpse of the state of the minor child that has been willfully withheld from one parent for 4 years. The minor child has in excess of 135 behavioral referrals, has been suspended at least 3 times. He has been investigated for bullying, and his actions did rise to the level of bullying. He has he has reported behaviors of harassing girls, behaviors that could be perceived as sexual harassment. He's defiant, disrespectful, argumentative. He kicks shoes at teachers, shoots rubber bands at teachers, blocks doorways so the teachers cannot leave the room. He has crushed breath mints in class and referencing cocaine. Most recently, he has made a referral. He's had a referral for physical aggression. This is merely a fraction of the referrals made for this child. The assistant principal reached out to the district social worker that did not respond for this child. And the concerning behaviors, the district social worker did not respond. The parent has begged the school to report for the child. And as mandated reporters, it is unclear why that is not happening. I encourage each of you to sit in on a few family court hearings, and I pray you pass this bill. I would like to see an amendment that it is the study done by an outside source, similar to the 2016 study into DCYF that Governor Hassan implemented.
Thank you very much for your testimony. Are there any questions? Seeing none, thank you.
Thank you.
Okay, are there any other members of the public that would like to speak to House Bill 1346? No. Okay. Seeing none, I'm going to close the public hearing. What?
I think I put a cursive on it.
Are you all set, Jen? Going to go ahead and open the public hearing on House Bill 1325 and recognize the prime sponsor, Representative Schmidt. Is Representative Schmidt available? Okay, seeing none. Representative Belanger, you've signed up to speak. Would you? Okay. Is there? Okay, we don't have anybody to introduce the bill. Is there a representative who would like to introduce the bill? Because we can ITL it right now.
If I may, Madam Chair.
Yes, please.
So for the record, my name is Representative Cody Belanger. Thank you for hearing me today. I believe I signed up to oppose the bill.
Yes, you did.
Okay. So I will introduce the bill, but I just want to add, we're already doing this. So this kind of seems
Why
redundant.
don't we do this procedurally? Why don't you introduce the bill?
Sure.
And then I will re-recognize you to testify.
Sure. So as the bill sits, it says what it says. The intent is to allow for access for confidential records. There's a section in here, Section C, which has been added. It says the guardian shall provide medical, financial, other records to the ward upon the ward's request, so that the ward may prepare and pursue a guardianship termination motion or request.
Okay, thank you, Representative. And I will recognize Representative Cody Belanger. You had not signed up to speak, but would you like to add anything?
Sure. Thank you, Senator, and thank you for recognizing me to speak today. Just being familiar with the, and fellow senators, just for being familiar with the guardianship process, this is just currently already being done. And I don't recall seeing this in our committee, as I don't think it came to us, but I would ask that you ITL this bill.
Thank you very much, Representative. Are there any questions? It went through Judiciary. Okay, next, we're gonna call, Mr. Itzy. Okay, that's fine. Karen Rosenberg.
Good afternoon. Thank you for taking your time for me. So I'm Karen Rosenberg. I am the policy director at the Disability Rights Center, and I'm here to testify in support of House Bill 1325. And what this bill would do is it would make sure that individuals who have been determined incompetent, who have appointed guardians, but whose situations may change, or maybe they want to pursue supported decision-making as an alternative to guardianship, something that you all passed last year, would be able to get those records that they may require to establish their ability to manage their own affairs or benefit from an alternative that's less restrictive than guardianship. So that's what this bill does. It actually does include a safeguard so that if someone is under guardianship and they're seeking confidential medical records, for example, that are particularly sensitive, but the guardian has particular concerns about that, the guardian would have the ability to bring that issue before the court so that it could be determined whether or not the ward should have access to those records. But it really dovetails nicely with the supported decision-making bill that you passed last year that's now codified at RSA 464D1 as an alternative. And it also recognizes that people's situations can change and they may not always need to be under guardianship, but do need access to those records to establish that fact. I'm happy to answer any questions you may have.
Thank you very much for your testimony. Senator Whitley has a question.
Thank you, Madam Chair. Thanks for taking my question. So has it been is this a problem that people aren't getting access to their records?
Well, there is right now a court when a judge determines that you're incompetent, and there could be a decision made at that juncture that you're not entitled to have access to those records, but someone's situation could change. And so as the law currently exists, there's not really anything in place if a person's situation changes to enable them to gain access to those records.
Follow up?
Follow up.
Thank you. So are you aware of, I don't know if DRC does guardianship cases. No. So you might not be able to answer this question, but are you aware of those situations where, someone may get a guardianship over their entire life, but perhaps, maybe there's some supports that they've received or there's a maturity that happens. Are you aware of those cases, maybe that someone, would seek a smaller guardianship rather than a broader guardianship?
Well, one of the things we do hear about situations where people's situations change and they may regain competency, for example, that's a change. And also we have this new law in effect that wasn't in place prior to, I guess this summer really. So there are definitely situations where people didn't have the opportunity to a less restrictive alternative to guardianship. So that's why this would be very important for them.
Are you all set?
Yeah, thank you.
Okay.
Any
Are there
other
any
questions?
further questions? Seeing none, thank you very much.
Thank you so much.
Are there any other members of the public that would like to speak to House Bill 1325? Okay, seeing none, we'll close the public hearing. Thank you. Are you all set? Going to go ahead and open the public hearing on House Bill 1515 and recognize the prime sponsor, Representative Gay.
Thank you very much. My original bill was amended with a very good amendment, which is the bill as active right now, and it added that the guardian ad litem's report should be factual only and not propose recommendations. I think that's a very good amendment. I have passed out to you another amendment that restores what was in the original bill because I think it offers a lot more protections for the parents. The 3A was an addition. The guardian ad litems, unfortunately, in several occasions that I'm aware of, have been representing the parent who is paying them. I didn't put it in the future. I think we ought to change it so that the court pays them and the parents pay the court so that they don't have a preference for the parent paying the most. So this says that the guardian ad litem should give equal time to the parents. Of course, they should be giving time to the children. Unfortunately, they often give more time to the paying parent than even to the children. Down on 4A, the court shall establish an hourly rate and a maximum fee, but it's not in writing. So I think it ought to be put in writing. On line 22, when appointing a guardian ad litem to be paid directly to parties, the hourly rate in writing, again, should be there. And then on line 24, both parties should agree if suddenly the court is asked to order them to pay more. So that if it's already been set, I think that's kind of unfair to change it, raise it. Of course, they don't lessen it. Then on lines 27 and 28, sometimes people get sticker shock because the guardian ad litem hasn't billed them until all at once. They're not aware that any rates changed, and now suddenly they get a really whopping bill that's not even itemized, and there will be another bill for that that's obviously really needs to be passed. Then the final amendment, part of the amendment, is on line 6 on the last page. The parties shall have the right to approve, refuse, or report to the appropriate licensing board any illegal behavior of an appointed guardian ad litem or other appointed counselor. Unfortunately, I've also heard many stories about really questionable behavior on the part of the guardian ad litem or the appointed counselor. And of course, the parents have no choice in who those people are. And they have tried to report it to the direct supervisor of the guardian ad litem and got nothing but no findings. So this would give them an appeal, a method of appeal. So if you find any or all of those helpful, I would appreciate them being incorporated.
Thank you very much for your testimony, Representative. Are there any questions from the committee? Right, seeing none, thank you very much.
Thank you.
The chair will call Representative Stapleton.
Madam Chair, my request has already been represented in a lot of questions.
Thank you very much. The chair will call Representative Belanger.
Thank you again, Madam Chair, fellow members of the committee. I'll try to keep this as brief as possible. This bill, as amended by the House, I submitted the amendment. The reason why we decided to put forward this bill as amended was while the previous speaker did bring up a lot of points and issues with guardian ad litems. Excuse me, sorry. This was specific because we continuously hear in the Children and Family Law Committee from families that were impacted by guardian ad litems who presented their opinion and their belief and potentially their personal biases into a case which really needs to be fact-finding. If a kiddo has been removed from care and this guardian ad litem has a personal belief or personal biases that all kids belong with their parents, it might not be in the best interest of the child. And so they're presenting their biasy and personal belief in that instance. So what's this? So what does this bill do? Well, it keeps it brief, right? Government doesn't move very fast. We all know that. We do the best we can. But it keeps it short, keeps it brief, and only says that the report shall include only factual information and shall not propose any recommendations. That's all we're asking guardian ad litem to do. That's all guardian ad litem should be doing. There's another bill, also short and brief, which I will be presenting afterwards. That fixes another issue. And I'd be happy to take any questions.
Thank you very much for your testimony, Representative. Are there any questions from the committee? Senator French.
Thank you for the question, Senator. And yes, I believe what she said was that it refills in the bill from what it used to be. Yes, Senator, thank you again for the question. As stated, I was the one who proposed this amendment as you see it here today. And no disrespect to the previous representative, but I think we're trying to fix too many problems at once, and it can just get convoluted and lost in translation. So again, short, sweet, and to the point. I think this fixes all of her concerns outside of the payment, which is addressed in another bill.
Are there any further questions? Senator Khan.
Thank you, Madam Chair. Representative, I'm wondering, did CASA have any input into this conversation in the House hearing?
Running notes.
Thank you for the question, Senator. So CASA is a child advocate agency, which is separate from a guardian ad litem. They may not be the same thing.
I'll check that statute. Thank you.
Representative, did you get any testimony in the House from the guardian ad litem board?
Thank you for the question, Senator. No, we heard from nobody.
The reason I ask is because we received a letter, and it's dated April 6th from the board. And they state that they reviewed 1515 at our last regular meeting. And they asked that this individual please write to let you know that the reports filed by GALs have been addressed in New Hampshire Supreme Court case law, and that each report is evidence in the case. GAL's report is not given any more value than any other evidence presented during the course of a case. The GAL's responsibility is to represent the best interest of the child. The actions needed are laid out in the appointment order issued by the judge who instructs the GAL as to how he or she is to investigate and find facts on behalf of the court. The board deeply appreciates the angst experienced by every family in these cases when a GAL is inserted into their lives. However, we are also concerned that the ability of the court to access the GAL's independent eyes and ears on behalf of the court not be restrained to the point of serving no real purpose. That's the response to this legislation from the GAL board. So I'm surprised that no one came in and testified in children and family law.
Thank you, Senator, as am I. I think it's important to recognize that, give you a brief example. Everybody knows that I have adopted my son.
You what?
Everybody knows that I've adopted my son. We had a GAL that was appointed in that case who said that she, in her personal belief, felt that my son should have contact with his mother. He has told the GAL numerous times that he wanted nothing to do with her, but she still instilled in her report that she felt like he needs that communication. He felt like at 6 years old, that was his decision to make, and we allowed him to make that decision. Now, I don't talk badly about my sister in front of my son now. That's just one example of a GAL providing their personal belief into a case and providing that in a case. And so we have heard this, and actually the bill that was presented in the House, we heard from numerous parents, and it's unfortunate that they're not all here, but that a one specific guardian ad litem was instilling her personal belief and biases into her court reports. While I respect the work that GALs do, their reports should be fact-finding only and should provide no recommendation which could be considered opinion.
Okay, thank you.
Thank you,
Are
Senator.
there any further questions? Seeing none, thank you very much, Representative. The chair will call Richard Head.
Good afternoon, Madam Chair, members of the committee. My name is Richard Head. I'm the Government Affairs Coordinator for the Judicial Branch. We do have concerns about the bill as presented. Essentially, I think our comments are similar to what you read from the Guardian Ad Litem Board, which is they do act as the eyes and ears of the court, and it is simply one part of the evidence, the total package of evidence that the judge has to take into account. But we are concerned that if we remove another tool available to a judge, it just creates the potential for a lack of information for the court to be able to access in order to ultimately reach a decision that is in the best interest of the child. The court does not have to adopt a recommendation of the GAL, but certainly can take that into account with regard to all the facts that are also provided with the GAL report. The GAL report is evidence, as is the testimony of all the parties and anyone else who may present. So we do have concern that this would be a legislative restriction on what is a tool that is accessible to judges. Looking back in the other bill, maybe in one of the items that I may recommend in terms of the study committee would be to look at the role of GALs, but I don't think that necessarily this bill is the right way to do it. Maybe it should be a part of the study committee that if that goes forward. But we do have concerns about essentially taking away a tool that is currently available if requested by the judge. With that, I conclude my remarks, but happy to answer any questions.
Thank you very much for your testimony. Are there any questions for Mr. Head? Senator Khan.
Thank you, Madam Chair. So this is adjusting chapter law 461.
Correct.
The CASA appointed guardian ad litems for the child. That's under section or chapter 169.
I think that's right. That sounds right.
Child welfare.
I'll take, yeah.
Right. So how does this affect, I mean, I think I agree with what your testimony just now and what the chair read from the board, that these are items that are helpful to the court, not guiding to the court, but for the court to be able to consider. And so I wanted to do two things here. One, I wanted to just establish CASA is probably the most important guardian ad litem source that we have for the welfare of a child in the state. Whether you agree or...
I think they're all incredibly important, but they all have a distinct role.
Yes.
CASA certainly is an essential function, though, in terms of input.
They do provide this information that's referenced in...
Yes.
Or
That's my
deleted
understanding.
from 461. So I'm surprised that they have not had more input into this discussion.
And I've not reached out to them myself.
Thank you.
Any further questions? Seeing none, thank you very much, Mr. Head.
Thank you.
The chair will call Attorney Marilyn Mahoney.
Good afternoon. My name is Marilyn Mahoney. I'm an attorney, semi-retired from Manchester. And for many years, I practiced law in the area of family law. For several decades, I worked as a guardian ad litem, though not most recently. I'm here on behalf of the Children's Lobby with Waypoint. I'm the chair of the Children's Lobby and work with Keith Koenig, our lobbyist. And because of my background, he wanted me to address this bill. I oppose this bill. I want to clarify one question, if I may, that you asked Senator Khan, which related to CASA. CASA guardians ad litem are exclusively addressing cases under 169C, abuse and neglect cases. So this bill doesn't pertain to them. It really only addresses cases under 461A, which are parental rights and responsibilities in marital cases or unmarried custody or parenting disputes. So that's why I'm sure CASA has decided not to come, because this doesn't really pertain to them.
Thank you.
With regard, I don't mean to state the obvious, but when you have parenting disputes that the court must decide, and there's a guardian ad litem, 50% of the parents in those cases are going to be unhappy. Yes, there are dissatisfied people, and they're in this bill targeting the guardian ad litem, who I would submit is the most important participant in a custody dispute before a court, because the children have to have a voice. When the guardian ad litem concept was introduced back around 1980 in New Hampshire, it was revolutionary, because for the first time, there was a court recognition of the importance of the perspective of a child. Since that time, there has been effort after effort made to try to, for want of a better word, castrate the guardian ad litem in some way, to prevent them from being able to do what they need to do, which is to provide a voice for those children who are before, whose futures, whose lives are before the court. Mom can speak to her interests, dad can speak to his interests. They both can try to speak to what they understand the interests of the children are. But an independent person looking at that is essential. And that doesn't mean just being an investigator and reporter, which is what this bill would reduce a guardian ad litem to. The guardian ad litem has to be able to, for example, submit a proposed order, which I guess would be forbidden, because a proposed order would be tantamount to a recommendation. The guardian ad litem would be unable to file or respond to pleadings, other than to simply talk about what is factual. And that means that the guardian ad litem becomes very hamstrung in being able to carry out what their responsibilities are. As you know, the guardians ad litem are trained, certified. There are all kinds of measures in place. If somebody doesn't do a good job, if they've done something ethical, there's a method and a system for reporting that. And does that happen? Yeah, I'm sure it does. But that doesn't mean that we completely take away from every guardian ad litem, no matter how great they are, the ability to recommend certain things to the court. So I'd urge you to not approve this bill.
Thank you very much for your testimony. Are there any questions from the committee? Seeing none, thank you.
Thank you.
The chair will call Dan Itza.
Thank you, Madam Chair, members of the committee. I am former Representative Dan Itza, and I am residing in Manchester. As I mentioned previously, I sat 16 years on Children and Family Law Committee. And this bill, both as introduced and as you see it before you now, attempt to address issues that we saw consistently over my tenure on the committee. believe it was ever the intention when we created GALs to have them make recommendations unless it was absolutely necessary. When talking to judges, they refer to GALs as their fact finders. And yes, this will change the role of GALs in divorce cases, not CASA. That is a separate issue. And in fact, CASA is very well run and very effective, and you don't find these complaints in CASA. I had the privilege of sitting as vice chair on an audit of the GAL system. And the one thing we found was the state's GALs are problematic, CASA GALs are not. And it has to do with the way they're run. CASA GALs are volunteers, and their supervision is paid, and the state's GALs are paid, and their supervision is volunteer. And it creates an imbalance that results in poor supervision. Either of these bills, either the proposed amendment, which is the bill is introduced, or the bill as you see will be helpful. The bill as introduced was designed to solve a problem of overcharging. There are certain cases in which the GAL's bills run into the tens of thousands of dollars for something that's supposed to be limited to about $4,000 or $5,000 or $6,000, and that's a problem. Anything you can see fit to do to control that would, I think, be very beneficial to the stressed families that are in these situations, because in the best interest of the child, it does no good to spend their college tuition on GALs. I'd be happy to take any questions.
Thank you very much, Representative Mr. Hitson, for your testimony. Are there any questions from the committee? Okay, seeing none. Thank you very much. Seeing that all individuals who have signed up to speak have spoken, we are going to go ahead and close the public hearing on House Bill 1515. Bill, I have to leave at 20 after. Good. I don't think this one will take too long. Okay. Or let's wait for Jenny. You all set? We're going to go ahead and open the public hearing on House Bill 1520 and recognize the prime sponsor, Representative Belanger.
Thank you, Senator, and fellow members of the committee. I promise this will be the last time you hear from me today. My name is Representative Cody Belanger, and I represent Epping. So this was one of the things that we sought. As you see, is significant bipartisan support, both from both chambers. Speaking from personal experience, I asked for numerous times for a bill from my guardian ad litem and was never provided one. So I sought to correct that because, of course, I was not the only one who was impacted by this, I'm sure. This bill adds to the guardian ad litem statute that the guardian ad litem shall provide an itemized bill to the paying party, and all parties shall have the right to request the itemized bill for review. Basically saying that if another party wanted to see how much money I spent on a guardian ad litem, they could. Why they would, I don't know, but gives them the opportunity to see it. One of my fellow colleagues from Children and Family Law, Representative Long, said that this was something that we desperately needed. And was an oversight as to something that hasn't been done in the past. This is just seeking to correct and allow for transparency with families. With that, I'd be happy to take any questions. I will add that this, if somebody does ask for it, they are not required to give it to them. If a guardian ad litem does, that's great. But in many instances, a guardian ad litem is not required to provide a bill. And if you're paying for something, you should be allowed to see a bill.
Thank you very much for your testimony. Are there any questions from the committee? Senator French.
Thank you. How often do these bills come out? How often do you get billed by a guardian ad litem? Once at the end or monthly?
Thank you for the question. So it would depend on the guardian ad litem how they bill. For example, the statute does, I believe, they're not here, but I don't remember. It is capped at $1,700 and change, I believe, and they can ask for that whack all up front. Excuse me. Let me rephrase that more professionally. They can ask for that bill up front, but not provide you how they itemized it, meaning who they spoke with, how much they spent on that time, etc.
Follow up?
So the itemized accounting would come after payment in that case that you're asking for here?
Thank you, Senator, for the question. Yes, it would be similar to a lawyer. When you pay your lawyer an upfront, $2,500 retainer, they would provide you an itemized bill of what's being spent out of that $2,500 retainer.
Thank you.
Of course.
Are there any further questions? Just for information, I received a letter from the Guardian Ad Litem Board, and it says that the Guardian Ad Litem Board has reviewed House Bill 1520 and wanted to update you on our decision following the bill's introduction. The board will be updating our administrative rules to reflect that GALs are required to provide itemized bill to the paying party in private pay cases. This bill, the bill brings forward a legitimate concern that it had not been specifically addressed.
Thank you, Senator. May I add to that?
Yeah.
Okay. Thank you for pointing that out. It's, again, unfortunate that they did not present to the Children and Family Law Committee, because this wouldn't have been heard before you if it did. But I think it's a necessary step to bring it forward, just to kind of protect that. If they're going to do it, that's great, but I think it should be statute as well.
Okay, thank you very much.
Thank you, Senator.
Any questions? Okay, seeing none, thank you very much, Representative. The chair will call the Dan Itza.
Thank you, Madam Chair. Canada, I will support the. Okay, good. I'm Dan Itza, and I reside in Manchester. I do fully support the bill as presented. It is an element of what was in the what you see as an amendment to HB 1515. If there was one thing, or I was going to add, if you look at the amendment to 1515 rather, and you see line 21 and paragraph B. Back in 2014, I wrote what is now in that paragraph. And I think it would be prudent, because of the way that we see runaway guardian ad litem assignments. It says it, it's supposed to be not exceed 23 hours, and yet we see them that last years. And I would suggest that the amendment on line 24, both parties agree otherwise, should be added. And the amendment in line 25, the court shall not later increase the rate, ought to be added. And I think those would fit well within the scope of what you see before you in 1520. It'd be a germane amendment.
I'm looking for Representative Rice. Say that again? Okay.
She cannot. Suffering from the back injury.
Okay. He didn't want to speak unless. Rep Long? Oh, Wong. You know, the eyes are going, the hearing's going, especially with the flu. Oh, well, thank you. Judiciary's back in session. House Bill 254. Go ahead, Representative.
Thank you. And thank you, members of the Senate Judiciary Committee. As you know, Representative Rice could not be here today. And I will just introduce the bill really briefly. There are plenty of people behind me who can answer all your technical questions. House Bill 254 will continue the state's efforts to provide care for children in the least restrictive environments. The bill limits the criteria for secure detention at the Sununu Youth Services Center, allowing only for those circumstances in which the safety of the child or the community would require such confinement. On page 2 of the bill, lines 12 to 18, is the list of the offenses that would require secure detention at the Sununu Center. Research tells us that placement of children in corrections facilities can cause lifelong harm. The Families First Act and New Hampshire's system of care prioritizes community-based treatment for children. This bill is another step in accomplishing our goal of providing care for children in the least restrictive environment. Thank you.
Thank you. Any questions? Go ahead, Senator Khan.
Thank you, Mr. Chairman. And Representative, I hope this is within your support of this legislation. On page 2, the specificity that's being added relative to Class A felonies. This seems like it captures most, maybe many. I don't think it captures all. And so I was wondering why not specify any Class A felony?
I do think there's someone who might testify later that would add something that they have to add to that.
Thank
you.
Thank you very much.
Thank you.
Representative Bob Lynn. Welcome, Representative. Good to see you today.
Thank you very much. Senator, I wonder if I might pass out.
Someone's going to do that for you.
Oh, okay,
Right
great. I have
right to
written testimony and proposed amendment, and I believe I sent it to all of you a couple of days ago by email, but my technical abilities aren't great, so I'm not sure that it actually got through to you. I hope it did.
Truthfully, the 500 or 600 emails I got in the last day or two, who knows?
Thank you. Thank you for permitting me to testify. Reluctantly, I come here to oppose House Bill 254, and I have to acknowledge at the outset that I was a member of the House Finance Committee that voted, I believe it was either 21-1 or 21-0 in favor of this bill. And I have to say, honestly, I was one of the people that voted in favor of it because on finance, we're supposed to be concerned with the money aspects of something. And the money aspect wasn't really the thing that bothered me very much. But on the merits, I think this bill is a very bad, would amount to very, very bad public policy. And let me try to explain why. First of all, I think it's important to understand exactly what this bill does. Under present law, a juvenile cannot be committed to a juvenile detention facility for any theft crime, any false statement or false swearing crime, any breach of the peace type of crime, if such crime would be a misdemeanor if it was committed by an adult. But there is, under present law, a so-called three strikes exception, which allows a minor to be committed for these types of offenses if he or she has been found delinquent on three separate occasions in the past. HB 254 significantly expands the crimes for which a minor can never be committed to include essentially all nonviolent crimes, even if they are felonies. Of particular concern in light of what has been happening around the country, this bill prohibits commitment of minors for property offenses, no matter how much property is stolen or damaged, unless the minor is armed with a weapon, there is a threat of actual infliction, there is a threat of or actual infliction of bodily injury, or the minor otherwise poses a danger of causing serious bodily injury. So let me give you this example. Under this bill, if you and your spouse go away for the weekend and return to find out that while you were gone, your house was broken into by a minor and you were cleaned out of thousands of dollars of property, the minor doesn't have to worry about spending even one day in a committed juvenile facility. And let me emphasize, it's a juvenile facility that we're talking about. Minors cannot be committed, and I completely agree, they shouldn't be committed to adult facilities. This bill sends the message that property rights are not important, and that if all you do is steal someone's property, it's really no big deal. This is exactly the kind of message I submit that the George Soros-supported woke district attorneys have been sending in places like Los Angeles, San Francisco, and Philadelphia. And we have all seen the consequences of their policies. I urge you, please do not allow this to happen in New Hampshire. And I hope that some of the other people who will testify subsequent to me, and I hope you will ask them, or at least they will tell us, has any state in the country gone this far? Has any state said that for property crimes where it's a property crime only, no matter how serious the crime is, there is never any circumstance on which a juvenile can be committed? I would be maybe there are. I have to say honestly, I haven't researched the law in all the states, but I would be very surprised if that's the case. In the House, the Amendment 2162 made this bill even worse because it eliminated the three strikes provision. So that under this bill now before you, in the example I just gave of someone cleaning out your house over the weekend while you're gone, so that there's no violence, you're not there, there's no violence, but they clean out your house. Under the bill as amended, the person would not have to worry, the minor would not have to worry about spending a single day in juvenile commitment, even if they had done the exact same thing and been adjudicated delinquent for doing the exact same thing 3 times before. I want to emphasize here that I am not someone who advocates a lock them up and throw away the key kind of for anyone, but particularly for juveniles. I completely support the idea that treatment is very important and that committing someone, particularly a juvenile, should be the very last resort, and that in the overwhelming majority of cases, it's not appropriate to commit a juvenile for a property-only offense. But because it's usually not appropriate doesn't mean that it's never appropriate. And yet that's what this bill does. Remember, under current law, just as the law is now, the courts are not allowed to impose a committed disposition unless it is the only alternative. That's the statute as it now exists has a list of, from the sort of least harsh disposition to the most, and commitment is the last one. So a court, even under existing law, cannot commit a juvenile unless the court finds that it's the that it's the only thing that is a proper disposition. The last, just a couple of other points if I could. Property crimes are not the only serious crimes that if this bill is enacted will never be allowed, a juvenile could never be committed. And another example would be perjury. Suppose a juvenile is called as a witness at trial and testifies falsely, and as a result, someone is unjustly acquitted, or even worse, unjustly convicted of a crime that the person didn't commit. Under this bill, no matter how egregious the circumstances, the juvenile could not receive a committed sentence. Two final points that I would make. If you remove the possibility of commitment as a potential sentence, that reduces the incentive for minors to become invested in other dispositional options. And this is simply a reflection of the sort of the carrot and stick phenomena. There are some minors who are resistant to or don't think that they need treatment or rehabilitation programs. And unless they understand that if they don't comply with a less onerous form of disposition, such as treatment or counseling, etc., the judge can use the stick of commitment, the incentive to successfully complete treatment programs won't be there for some juveniles. And that it seems to me that's just a bad public policy. And I guess the last point that I would make is I know that one of the big purposes behind this bill was to reduce the population at the Sununu Center in the hopes that it's going to be closed and we're going to develop another juvenile secure juvenile facility. And I'm completely in favor of that. I absolutely think it's the right thing to do, and I'm very happy. I think reducing the population at the Sununu Center is a very good thing. But this is not going to accomplish that goal. The Sununu Center population has already been reduced over the last several years, way down. As the last time I checked, which was earlier in this year, I think there were 14 people there, 7 in pretrial detention and 7 serving a committed sentence. And I would be amazed. I don't know this because I haven't checked this, but when I talked to Judge King, he didn't really know. But I would be amazed if any of those people that are serving a committed sentence are there only for a property offense. Because as I said before, that's a really rare situation where somebody gets committed for only a property offense. But as I said before, the problem with this bill is it says never. Never can that happen. That just seems to me goes too far. So for all those reasons, I urge you, I think that this bill is a solution in search of a problem. The current law operates just fine, and there's no reason to go as far as this bill goes. I hope I've persuaded you on that, but if I haven't, then my fallback position is I've offered an amendment, which I hope you'll consider as some other people may testify about. The bill added the proposed legislation as a new subsection M to RSA 169-19. And the subsection M, as it currently is drafted, I think the intent was that the drafters of the bill recognize how far this bill went and tried to sort of use section M as kind of a savior sort of provision. The problem is it is limited right now the way it's drafted. It's limited again to situations where the minor poses a risk of some serious bodily injury. If the minor is if it's simply a property crime kind of situation, then there's no alternative. My proposed amendment tries to change that by saying that if there are other serious risks like a threat to property interests, or it's simply the crime is so serious that it requires a commitment, then the judge can, as a last resort, impose the commitment. The very last point I'll make, and then I'll shut up because I know I've gone on too long, is this. One of the things I think you have to think about in this is if you create this sort of, for lack of a better term, immunity from ever facing commitment for property crimes, what will be the effect of that? And I've tried to point out several of them, but one of the things I remember my colleague, Representative Sodi, who used to be a probation officer in New Jersey, mentioned that one of the things that has to be seriously considered here, because apparently it does happen with some frequency there, and maybe it would here, is if juveniles have, for lack of a better term, a sort of get out of jail free, or you can never be committed to it. You can never be committed to a committed sentence in a juvenile facility. Will that encourage adult thieves, adult property, offenders to decide let's see if we let's use juveniles because because they will face less consequences, especially under this bill. So I'm not saying, that's the only reason to do this, but it is another factor that I hope you'd consider. So for all those reasons, I hope you will vote this bill ITL, and if you decide not to do that, at least consider my amendment. Thank you, and I'll be happy to take any questions.
Thank you. I'll say one thing. You're very clear today. You were the best one doing an IRAC method. The issue, the rule, the analysis, and conclusion. Whether or not we disagree with you, you were very clear.
Thank you.
Thank you.
Thank you.
Paul Heverson.
Could I ask a question?
Oh, I'm sorry. I didn't see any hands.
Well, you didn't ask.
I'm sorry. I gotta be.
Okay.
I always look to my right because that's where the questions usually are, but go ahead.
Thank you,
Simon.
Mr. Chair. Representative, thank you. So to get this straight, you'd prefer an ITL on the bill, or if we were gonna pass it with your amendment?
Right, exactly. That would be my fallback position would be if if you decide you're going to pass it, then substitute my subsection M for the one that's in the bill.
Gotcha. Thank you.
Thank you very much.
Thank you very much for your testimony. Paul, sorry about that. I'm gonna look to my left and my right.
There you go. Thank you. Good afternoon. I'm Paul Halverson. I'm the Merrimack County Attorney. By way of background, I've been a prosecutor for right at about 20 years. I've been doing criminal law since 2000. I was a defense attorney for several years, and I've done hundreds and hundreds and hundreds of juvenile cases, both as a defense attorney and as a prosecutor. And you'll notice on my the sign-in sheet today, I indicated that I support in part and I oppose the current wording. I want to make a couple things clear from the outset. I firmly support revamping the juvenile justice system. I really do. I'm not an SYSC proponent. The news indicates to me that there's a lot of problems there. I don't have firsthand information, so I'll leave it just at that. I agree with the goals of revamping the juvenile justice system. No problem. I will gladly help anyone who wants to work towards those ends. My reasons for talking about this bill is that when it's all said and done and everything is enacted, there are a lot of internal inconsistencies that several of us in my office, as we were reading this, found. When we look at the individual paragraphs that are brought out, one paragraph B, the one that starts out when a petition does not allege a violation of 262 and all those other enumerated crimes, which would be a misdemeanor if committed by an adult. We read that to mean that any felony can be a detention and basically subsumes all of the prior change to the RSA. Under paragraph B, since it does not contain any of the enumerated list as misdemeanors, you could order secure detention in any felony case. Under paragraph B, it looks like you could order any secure detention in any misdemeanor case unless it's one of the enumerated ones. Now, and I'll tell you why that's important. The universal charge table used by the courts has about 3,600 potential offenses. Out of those, a little over 1,000 are misdemeanors, a little over 800 are felonies. Many of those are not contained within the criminal statutes. Most of the analysis here seems to be items that fall within the criminal statutes. Many, many, many items seem to have been omitted from the analysis. I think, and the other attorney who read this through this, think that could be problematic when in front of a court trying to figure out what the actual application is. The enumerated offenses that are contained in that paragraph B, I'll give you some examples from within those sections. Paragraph B talks about some thefts. Granted, according to this paragraph, it's a misdemeanor. Misdemeanor theft, you couldn't hold somebody, but there's an argument to be made that any felony theft you could. It goes on to talk about possession of a controlled drug without intent to sell. Well, there's no possession of controlled drug without intent to sell within the statutes. It's either straight possession or it's possession with intent to sell. The difficulty there is that possession of all controlled drugs, with the exception of marijuana and hashish, generally speaking, is a felony. So you could detain on that, which seems to be contraindicated by what the legislature is trying to accomplish here. Destruction of property, it includes arson, criminal mischief, unauthorized use of a vehicle, but there are felony and misdemeanor variants of all of those. Once again, any of the felony ones you could detain a juvenile on. Falsification issues, there are both misdemeanor and felony levels within that, such as witness tampering, falsifying evidence, which are felonies. Unsworn falsification and false reports are misdemeanors, almost parallel charges where you could hold on one and not on the other. Breaches of the peace under 644, there are many, many variants of that. There's a criminal street gang solicitation or non-consensual dissemination of private sexual images, which may be misdemeanors. They could be felonies. So you could hold on some, but not on others. There are also misdemeanors that could be concerning from a policy standpoint, but that don't appear to be part of the enumerated list where you could hold a juvenile. Cruelty to animals, where the animal is not killed. Bestiality, violation of probation. I may sound like I'm being hyperbolic on those, but I have seen those. And those are issues where the underlying issue is concerning enough that there needs to be some consideration as to whether or not a placement is warranted, either at arraignment or post adjudication. And using some of those examples, you could order a detention for bestiality. You could not order detention for bestiality or cruelty, but you could order it for issuing a bad check. You could not order secure detention for false report to law enforcement officers, but you could do it for a false report to 911, which is a non-enumerated misdemeanor under RSA 106H. You could not order secure detention for misdemeanor arson, but you could order secure detention for a person who kindles a wildfire, which is in a separate statute. I believe it's in the 227 series. So those are the internal difficulties that are within that part of the statute. Going down to the last paragraph, the new subparagraph talks about the dispositional hearings. That's sort of a catch-all override for judges. It talks about may commit the minor to custody of HHS if found true on a felony, and the court finds no placement or set of supervision or treatment services will protect the public from substantial risk. The next sentence is very interesting. A court's finding pursuant to this paragraph is only sufficient to support secure confinement if it is made by clear and convincing evidence following either a stipulation by the parties or an evidentiary hearing at which the rules of evidence apply. Interesting enough, when you look at the rules of evidence, if you apply the rules of evidence and look at the applicability statute under Rule 1101, that applicability statute says that these rules apply to the proceedings in district and probate division of the circuit courts. It specifically exempts family division, the very division that has exclusive jurisdiction in a juvenile proceeding. Now, assuming for argument's sake that the rules of evidence do apply, and you apply the rules of evidence under the same Rule 1101, the applicability of the rules of evidence are exempt during the issues of sentencing or placing an individual on probation, which in the juvenile code, it's disposition and conditional release. So while I certainly understand the goals of the legislature and wanting to revamp the system, I think the end result, when all of this is in place and none of it winds up have a drop dead date as it rolls in over the course of about a year, I think you wind up with a very difficult statute to execute at the circuit court, at the family division. So I'll gladly entertain any questions that anyone may have concerning my concerns on the wording. And like I said, if anyone ever has a question regarding revamping the juvenile system, I am certainly willing to assist in that matter. And frankly, if I can backtrack for a second, earlier before I came into the office here to testify, you had heard testimony in a bill that addresses the family court system. And it might be a good idea to amend that bill 1346 to include an analysis of the family court system as related to juvenile delinquency issues, in the hope that maybe they would consider a bifurcated juvenile justice system that allows a civil proceeding outside of 169C and 169D. And I'm taking a copy of 1346 with me. And if that is passed into law, I will be contacting whatever committee is established by that to give them my thoughts, should the legislature add an evaluation on the juvenile justice system under that bill.
Thank you. Any questions? Thank you very much.
Very good. Thank you.
John Dejo. John, yep, there you are. I'm sorry. I saw you earlier. Didn't see you now.
I'm sorry you have to see me again, Mr. Chair.
No, glad to see you.
Mr. Chairman, members of the committee, for the record, John DeJoy. It's a pleasure to be here again today. I'm sorry to burden you with more testimony. So what I'm going to try to do, there are a lot of questions that many of which are misunderstandings of the language. I want to apologize up front. This is probably the most complex bill unnecessarily that I've worked on. But I want to try to give you some context, a little bit of history. And I'm going to walk through what the bill does to try to make it clear, section by section. The other thing I'll put up front is that there was an error in Representative Lynn's statements, is that the only thing this bill does is takes commitment to SYSC off the table. If you think of the disposition statute, which is 169B19J, it goes up, B19, it goes up from A to J. Those are all dispositions that the judges can choose. This removes J from the selection of dispositions for certain offenses. All the other dispositions are still, including the entire system of care, as appropriate, are still on the table. So let me start with that. For nearly a decade, I've worked with numerous colleagues as we worked with the legislature to change a number of pieces of the juvenile justice system. We refer to ourselves as the Juvenile Reform Project, and we've been operating about a decade. I'm no longer part of the Juvenile Reform Project at this point, but I'm speaking historically. So we worked to raise the age of criminal majority to 18. We improved access to counsel for juveniles. We were involved with Senator Carson in creating the Office of the Child Advocate to oversee the juvenile justice system, and particularly secure confinement. At every step along the way during that decade, we heard similar arguments to what you're hearing today. The system's not ready. Dangerous kids are going to be out, and the public's going to be in jeopardy. This is unworkable and not good for kids. And in retrospect, which is the only time we can truly tell if we're right or anyone is right or not, in retrospect, at every step, kids have become more successful. It has not compromised public safety, and it in fact has been less expensive for the state throughout each step. But throughout all of that, there was still 60 or 70 kids at the Sununu Youth Services Center. In 2017 was the first time recently that you folks made significant changes to the conditions of confinement. Basically, what you did is only permitted felonies to be confined at Sununu. There were certain exceptions, and the big exception was simple assaults. That was a matter of significant discussion, and it was a political compromise at the end that simple assault was a reason for commitment. Okay, but I'm not going to tell you all of the misdemeanors are off the table, but I believe, if not all, the vast majority of other misdemeanors are off the table under current law today since 2017. The outcome of that was the census dropped from 65 to, as you heard Representative Lynn point out, today it's, 8, 10, 12, 14, it's low. Now, I'm not going to pretend that change accounted for all of it, but that was a catalyst for what we've seen happen over the last 4 years. That legislation and this legislation before you is both bipartisan and bicameral. In 2017, some of the key sponsors were Representative Wallner, Representative Kirk, Senator Bradley, and Senator Reagan. This bill as well the prime is Representative Rice, but as you can see in front of you, Senator Carson is a co-sponsor, Senator Hennessy, Senator Rosenwald. It has broad support across both parties and both bodies in the legislature. What we know from DCYF data is a few things. And this has been repeated publicly by the director on a number of occasions. What we know is that 75%, roughly, 75% of the children at Sununu at any point in time are dealing with behavioral health issues. They may have committed a crime, but they're dealing with behavioral health issues. And we also know of all the kids at Sununu that are discharged, nearly 2/3 of them return. So what we know is that kids need behavioral health treatment that they may or may not be getting. Some are, I'm sure. But we also know that the treatment is not having the desired effect because 2/3 of the kids are coming back. If you look even deeper at the data, and a colleague of mine who actually wrote Section M, not trying to blame him, just trying to give him credit, has testified before this legislature multiple times, and he said each time, New Hampshire has a long history of over-incarcerating low-level offenders, meaning we put lots of kids for misdemeanors in jail, is his assertion. And the data that DCYF has provided to various folks indicates that. 2019 and 2020, looking at all the kids who were committed or detained to Sununu in that time period, between 50 and 60% of all the committed kids, by DCYF data, their highest level charge was a misdemeanor. Now I ask you, we don't send adults to jail for misdemeanors, by and large. Why do we send kids to jail for misdemeanors? Especially in light of the testimony you heard this morning of what's gone on at the facility. We really ought to be going for the least restrictive alternative, because if we don't expose kids, then kids can't become victims. This is an important bill, and what makes this bill more doable today than even in 2017 is what you folks have all done relative to the system of care. The system of care is intended to provide a variety of services, and I'm not going to try to expound on that because the senator from Concord knows far more about this than I do. And I don't want to embarrass myself, but it is intended to provide a range of services to treat kids in the least restrictive alternative, ideally in the community with their own family, which is when kids always do best. When they're with their own families, when they can be, when they're in their own communities, because they have their natural supports. By my reading of the budget, you folks appropriated $30 million in the biennium, roughly, for the system of care. Many services have been vended. Some haven't. But we have some key services like multi-systemic therapy, which has been put out. We have a more robust network of mobile crisis, which is essential for many of these kids, and that's what makes all of this much more palatable. So I promised you that I would respond to a couple of things, and I'll walk you through piece by piece what this bill does. I have spoken with Representative Lynn. We had a very nice conversation. I don't think either one of us, either one of our minds were changed from the conversation, but it was still a very good conversation. And I'm prepared at the end of this to offer a way to address Representative Lynn's concerns that I don't know if it will be palatable. It may be palatable to you folks. So when you look at the bill, I have the right bill. The current law says that kids can only be detained, held pretrial, if their offenses would permit them otherwise to be committed post-adjudication. That's what the law says today. What this bill intends to do is to focus on serious violent offenses. So all of the comments about the misdemeanors and lower nonviolent felonies that aren't covered in this, that was by design. That was the intention. And we're always happy to talk to anybody about making changes, but that was the design. So that's why it's focused on the criminal code, and that's why it's focused on the serious violent offenses. So in paragraph 4, which starts on the very first page of text, line 23, that tells you what all the offenses are that would be committable to the Sununu Youth Services Center. And that would take effect under this bill on September 1st of 2022. Okay? Now that creates a problem. The problem it creates is that when you change the standard of commitment under current law, you're also changing the standard of detention. Whenever we have put these bills together, we believe there is a need for a transition, that we don't just drop everything at once. So the goal in this is to change the detention standards January 1st of 2023. So that is the entire purpose of paragraph 2, beginning on line 10. I'm still on the same page, where it starts, delinquent children released of detention pending a judiciary hearing. What that is intended to do is say, even though we're changing the standards of commitment, we want to keep the standards of detention the same for a little bit longer. That's all 2 does. That's why 3 right below it just repeats what the current law is today. It says you can't be committed if you can't be detained if you couldn't be committed. Paragraph 3 would take effect January 1st of 2023, and then commitment and detention would be identical. I will acknowledge in 2, and I wrote that language, so I'll take full credit or blame for it, it is worded in a negative, which is incredibly difficult, but we really struggled with how to say it's going to be the same as it is today. That's what we struggled with. And that's why it's so cumbersome in the wording. The other piece that was reflected was on page 2, line 27, what we refer to as the judicial override. The reason, and we always, so that we put the 3 strikes in the current law, that was what we refer to as a circuit breaker. Judicial override, sub M, is also a circuit breaker. We don't believe it's necessary. However, in the realm of politics, some people are more cautious than others. And so we put the judicial override in for legislators who are more cautious to say, if a judge thinks a kid who's committed a felony needs to be in Sununu, this is a process to make that happen. I will tell you, if it happens a lot, then we have to revisit this to see if we got it wrong or if something else is going on. But at least in the interim, it doesn't jeopardize public safety and doesn't leave a judge feeling as though they don't have any choice. That's the purpose of it. It's not intended to save the bill. It's simply intended to recognize that everyone has a different level of risk tolerance. This is trying to satisfy folks who have a very low level of risk tolerance. And that's okay. We're very comfortable with it. The applicability, which is on page 3, beginning on line 13, and I hope I'm not a lawyer. I don't play one on TV. I hope I'm not stating the obvious. If I am, please just tell me to stop. But in 2017, when the law went into effect, changing the conditions of confinement, there were some kids in the process, obviously. There were some kids who were in the process of trials, some who had been convicted or found true, hadn't been had disposition yet. It became very unclear which law should be applied to which kids when. That is the only purpose of the applicability, to say to the courts, this is how we would suggest you implement the law based on where in the process the kid is. And then the effective dates. So I did say, Representative Lynn on our phone call spoke eloquently the way he did today about property crimes. I went back and reread the criminal statute, or read for the first time the entire criminal statute, and I read the part on property crimes. And there's really, if you look at it, there's two major pieces of property crimes. There's arson and there's criminal mischief. There's a third that I'm still trying to figure out. I'm trying to figure that out, but I haven't gotten there. But so arson is primarily included in here. Not entirely, but it's included if it's chargeable as a felony. Criminal mischief is not. So when you look at the criminal mischief statute, whether or not it's charged as a felony seems to be tied to two key factors. One is the value of the property lost. Two, whether a firearm is discharged. I'm prepared to accept a friendly amendment that would include criminal mischief in this bill for any offense that's chargeable as a felony. Consistent with the rest of it. But as I said, this is your bill. You folks will make your own decisions. To the extent that you folks want to add offenses, you know, the key piece of this is it removes misdemeanors. We do believe that serious violent offenders are the ones that need for public safety to be in a secure treatment. We believe the system of care permits all or the vast majority of other folks to be treated in the community. And that's what this bill hopes to accomplish, and we hope you'll see it that way and support the legislation.
I got a quick question. We'll wake the other ones up then after. Do you like movies?
I do like movies.
Did you ever see Home Alone?
I saw pieces of it.
Okay. So you know who the Wet Bandits are?
I do.
Okay, so if I had a young, we'll say 15-year-old break into my house and after they were done stealing.
Yep.
And they watched that movie recently and they flood and destroy my home.
Yep.
They're certainly not arson. So you're going to not put them away? So hundreds of thousands of huge damage to my house.
Exactly. And I think the amendment I just offered would take care of that. But what I would say is the argument that we're going to get kids or teenagers to commit crimes because they can't go to jail is an argument that was used back in 1995 during the Get Tough on Crime. It didn't hold water by and large, although we can all find incidents where it did occur. And that was what got us to where we are today, where we have a 144-bed juvenile prison. We didn't need it. It came out in 1995. So I think we can get there in half steps. I do agree with you. If someone commits, significant monetary damage, I think adding the criminal mischief, if it's chargeable as a felony, which it would be in that situation, I think is a reasonable approach. I think the other one that we just totally missed is 639A, I believe it is. 639A is methamphetamine statutes about building a lab and having a lab in different places. That's a felony charge. We missed that, and I think that would be reasonable to add as well.
Thank you. Senator Whitley.
Thank you, Mr. Chair. Thanks for taking my question, John. So, you mentioned the system of care. Of course, that's what I'm most familiar with. So now we currently have two care management entities, right, who are, providing and ensuring that kids with a whole high level of needs get what they need. So I'm wondering if, they've reviewed this, and it sounds like you drafted the bill?
Say that again?
It sounds like you drafted the bill, correct?
I drafted the bill with a number of other folks that I've worked with for the past decade. This bill was originally submitted to, obviously, to the House last year. It was retained. And so at that point, this was drafted by the Juvenile Reform Project.
And were the care management entities at the table for that drafting?
The care management entities are not part of our part of that group. I believe we initially used the boilerplate language that I had spoken with the care management folks a year or two before. We ultimately did talk to them, and I believe we made some minor revisions, although I can't, without going to my notes, tell you what they were. They didn't draft it, but they were apprised of it. Yes.
Okay. And who are you representing today?
I'm representing the children in New Hampshire.
Okay, thanks.
Just to broaden that, not to sound flip, which I'm not intending to, I began this project on a paid contract. We had a policy difference of opinion, and I ended that contract. So now I do not have a client that I'm representing today, and that's why I say I'm representing the children in New Hampshire. I think, I can't, what I know and what I've gone through over the past decade in reforming the system, going through the Booton Commission on child abuse, listening to the testimony this morning, I can't in good conscience walk away from this, which is why I didn't, and that's why I'm still involved.
Thank you. Great. Awesome.
Thank you.
Thank you. Speaking, not speaking. Anyone else wish to speak on this bill? Come on down. Former Representative Itza, my old seat buddy.
Yes, indeed. Thank you, Mr. Chairman, members of the committee. I would like to correct one statement that was just made, and that was how we ended up with the Sununu Center. I was sitting on the committee at the time. It was my freshman year, as a matter of fact. And we have the Sununu Center, and I have to say I was, for good or for ill, I was one of the prime architects of the bill. The reason we have the Sununu Center is that we had a facility with a capacity of 96 individuals. We had a consistent population for about a decade of 112 to 116, and the facility was over 100 years old. And we found that we had a federal grant to revitalize our juvenile detention facility that was running out in 2 years, and that was it.
Is this going to be relevant to the bill?
It was a statement made as to how we got the Sununu Center, and it was a misstatement.
Okay, thank you. Rebecca Ellis, come on down. Rebecca? Ross, okay. Again, my ears are all plugged up. It's just not a good day. But it's cheering now that you're here. Nice smile, face. Good to see you.
Good afternoon. For the record, I'm Rebecca Ross. I'm the director of the Bureau for Children's Behavioral Health at the Department of Health and Human Services. Prior to this role, I was general counsel and legislative liaison for the Division for Children, Youth, and Families. And I'm not sure if Senator Willie had questions for me or if you saw my hand, so I would defer to the
She sat down and looked right at me. So good to see you, Rebecca. Yeah, so of course, my interest is always in making sure anything we do with kiddos is directly connected with the system of care, right? We want to make sure that children are getting services, the right time, right place, all of that, and that anything that we do is, very connected to as John mentioned, the significant investment that the legislature has made in the system of care and building that out. So I just wanted you to speak to your involvement in this bill and how you see it connecting with the system of care. I know, we've heard in other committees about, the closure of Sununu Center, and the most recent version of that bill that passed the Senate had deep connections to the system of care because it was written with Director Ribsome. And so I just want to make sure that, anything that we do impacting this population is deeply connected to the system of care. So if you can speak to that, that would be helpful.
So absolutely. I think Children's Behavioral Health and the Division for Children, Youth, and Families work very closely together with all of the implementation and system changes in juvenile justice transformation even from getting into the door with the diversion that is happening before a petition is even filed from Senate Bill 94 of last year. But to take a step back, I think it was Representative Lynn who said, this is a solution without a problem. I think this bill is looking to decrease the census, which has already occurred. And so we're not taking a position, for the record. I want to be clear. The department is just here to provide information. But there are some substantial concerns about the way this is drafted, both as County Attorney Halverson said, with the implementation and the confusion for the courts and the parties who are involved, but also with, is it really where we're trying to solve a problem? Because we're taking out things like domestic violence and simple assault and trafficking. And unfortunately and fortunately, I've had the benefit of living in that system with access to those confidential records, not just data sets, to understand that where you heard that there are so many youth of the 12 to 14 that are there on lesser offenses, the reality of the system is if a prosecutor and a defense attorney know that a youth can get the treatment that they need in the place they need to be, it is much easier to plead to a simple assault when it's really a domestic violence sexual assault scenario in a very complicated crisis in family in crisis. So although we may be seeing it as a simple assault on a chart, when our clinicians and our staff are looking at those cases, it is a very, very different picture. And I think that anything that we do to reduce the ability of those youth at such a high level of crisis to get into a safe and secure setting to have the assessments that they need, including the brand new comprehensive assessment for treatment that started as of October 1st, that will identify the appropriate level of care, to then identify the next best setting for them to be in, would be doing a disservice to those youth and the other youth being served throughout that system. So if we are taking kids, a 17-year-old who is trafficking their 12-year-old neighbor, which we've seen, or the 17-year-old who their counterparts in Massachusetts are using them to traffic drugs through New Hampshire to Vermont, which is a number of the Vermont youth that we have seen, because they know there will be no penalties for that 17-year-old. I think we may be creating situations we don't want to create that are going to put barriers in place to serving those kids in the right way at the right time and the right place. When we're averaging 12 for the last couple years, we've already overcome that barrier of having too many kids there for the wrong reasons for those lesser offenses. And the other unintended consequence may be pushing some of those kids into the adult systems, because if the juvenile community or the criminal prosecutors and the justice community doesn't feel like they will be served in the community, will be protected through the juvenile system, they will be pushed further into the deep end of the adult system, which, as the director of children's behavioral health, I don't want to see. I want to see them served in the children's system and move safely back to the community as fast as possible, not being detained for a pending certification to the adult process for far longer than it would take to actually treat and transition back to the community. So I think those would be our concerns, that it might be causing obstructions to being served as intended through the system of care that is rolling out already.
Oh. Senator, the boss is back. I'm off. Remember the Sorcerer's Apprentice? No, I'm all set. I'll let it go. Thank you.
Okay. Thank you.
Okay, are there any other members of the public that would like to speak to House Bill 254? Nope. Seeing none, I'm going to close the public hearing. You are the troublemaker. Yes, folks, are you set, Jenny? Yeah. We're going to go ahead and open the public hearing on House Bill 1265 and recognize the prime sponsor, Representative Gay.
Thank you. The end of the day. 1265 is relative to a judge's discretion to set aside rules in family court proceedings. And you have I'm sorry, my brain is mush right now. So, okay, I passed out an amendment with the original content of this bill. It was super simple and probably too simple, but after seeing really bad use of rules, which meant a lot of times the rules weren't followed at all. And they were written into the rules that that was okay. So you would go into court as a plaintiff or defendant, and you really didn't know what the rules were, unlike going into a criminal court where the rules and the rights are much better defined. So my original bill was simply make all the rules be followed. If it's not a good rule, get rid of it. And since there are obviously a lot of rules that the judges are refusing to use, seems like weeding out would be a good idea. But the Children and Family Law thought they would refine it and actually keep a database, create a database, which is the written bill that you have, make a database so that you would record variations, waivers of the rules. So you put them in the court record, like on line 5. You would create a family division waiver database on line 9. It defines who could access that. So in section 2B and then 3, they talk about all the people who could access this waiver. And then the Chief Justice would be responsible for a quarterly report. So if all that's done, that would be great. Of course, my fear is that they'll sort of get lost in the weeds and not get done. So, but that's your choice. So we do have a serious problem with these rules being so wishy-washy. You've heard it said in this room today that nobody's done anything wrong. All these issues being discussed in family court, nobody's done anything wrong. Well, I can tell you some hair-raising stories where a lot of things were done wrong. And so we hope that we can improve family court so that those issues are honestly addressed and action is taken to protect the people who are victims of what was done wrong. These bills are not to settle the inevitable parental disagreements. That was also said, people are always going to be unhappy with family court. We're here because there are things that absolutely laws are not being followed, and the people who are being victims have no recourse. There's no handy-dandy place to say, this is what happened to me. We appeal to make it legal to make recordings because that's your only proof that something happened. And right now, we need some proof to show that things were said and ordered that weren't in the record. We have issues because some GALs do not represent the children, they represent whoever's paying them. Children deserve to be heard. They're really dependent on the GAL, so when you have one that's not so motivated, the child really suffers. Right now, judges can do things like ordering months, even years of very expensive counseling and say, oh, I trust this counselor, I've used him for years, and then not permit that counselor to even come testify. That's happened. locked them out of the courtroom, said, this is my court, my rules. So what I'm saying is the issues here are really serious. And it may be just kind of a simple, well, they take care of it, they've got rules, everything goes around, is being done properly. It isn't. Not in all cases. I don't want to be painting all courts with this brush. But the issues are serious with some of the judges, some of the courts, and of course we have to address with rules for all. We can't just say, oh, we're going to name certain judges that we want you to work on. So that's why I'm appealing to you to pass all of the bills that can help the victims of family court so that it goes back to being what it was intended, a place where protection is offered, where people are being hurt and people are fairly listened to and mediated. So with that, I'll take questions.
Thank you very much, Representative. Are there any questions? Senator Gannon.
I'll be really quick and I'll try to make it a question. So I know you don't like wishy-washy rules. I picked that up on the whole day. That's the theme of the day. But let me tell you where wishy-washy may be a good thing. So I remember a young lawyer about 30 years ago. It was his first trial. He was a solo practitioner. And he was doing the best. He wanted the truth and he wanted everything out. And I probably didn't offer, I was introducing a diary. And did I do it correctly? Did I offer it as evidence good? Would I have, in a real superior court, have done it good, or whatever? I got picked apart. Probably I had never offered something, and was the stuff inside really? Maybe I didn't do it right because I didn't know what was going on. And the judge was working with me, and he knew I was a young attorney. And the other side was pro se, so the whole room was very, very loose. But it got at the truth because that was what was there. And they were looking for the best interest of the child. We probably didn't follow the rules of a superior court very well. It probably, had I been against Counselor Lehman, I probably would have not got this introduced. But it found out the truth that someone had been making payments where the other party said they didn't. And I had someone who verified that. And did I evidentially do it right? No, I'm sure I did not. But it got the truth and it got the best interests of the child represented. So sometimes having things a little looser may do things that you're not seeing that are good. And I trust in the judges overall.
So what I gather that you think it's better just to talk about, capture records of
No, it's just
waivers
making an observation
and
too,
not-
that sometimes
not
a looser
fix.
record, but I'll let,
Yeah, not
yeah, I'm
fixed.
not arguing with you.
No.
Okay.
Oh, I didn't think you were arguing. I thought you were informing.
Okay.
So do I interpret that to mean that you like the bill as it is, where you would just capture data rather than say, okay, these are the rules, do them?
I'm good. I'm all set. Long day. Thank you.
Thank you very much.
Thank
Are there any further questions? Seeing none, thank you. The chair will call Representative Gordon. Good afternoon, Representative.
Good afternoon, Madam Chair, members of the committee. For the record, my name is Ned Gordon. I do represent Grafton County District 9. And I also come as a former judge and just wanted to comment on my thoughts with regard to the bill. I certainly think the bill is well intended and don't have any concern with regard to that. No, Representative Gay is well intended in the bill, but I just have concerns about the bill and wanted to express them. Originally, I intended to talk about the original portion of the bill, which was regard to database and keeping records of waivers of rules. And but I see that there is an amendment, and I'm going to just address the amendment that she's proposed here today, which would basically prohibit any waiver of the rules except regarding fees. And I'll just, when you go to law, and I think Senator Gannon sort of hit on it, when I went to law school, you learn that there are two great values in the law. One is predictability, and the other one is fairness. And the reason that we have statutes, laws, regulations, and court rules is for predictability, so people know how they're supposed to act and what they're supposed to do. But unfortunately, if you strictly administer those statutes, rules, laws, sometimes it creates unfairness. And the example that's always used is the Zoning Board of Adjustment. We create these rules as to what we should do with our properties and our communities, but we know if we strictly apply them, it's just not fair. So you have to have variances and you have to have special exceptions because that's what creates the fairness in the system. And so that is what happens with court rules. And I know Representative Gay was talking about things that judges do, but court rules just apply to procedure. And I'm going to tell you that the very first time I was ever appealed as a new judge to the Supreme Court, I was appealed because I required a litigant to comply with a court rule. And it was a litigant. One of the court rules is that you are required to file an appearance in a case, and you need to do that within a certain period of time if you want to contest the case. And this litigant refused to do it. And the litigant was not a litigant uncommon to the court. And so we contacted the litigant and said, hey, you haven't filed your appearance. You need to file the appearance. And the litigant said, no, I'm not filing any appearance. So I said, okay. So I dismissed the case with a judgment against him. And that litigant, who was a pro se litigant, appealed it to the Supreme Court. And the Supreme Court heard the appeal, and in the appeal came back and said, Judge Gordon, for crying out loud, it's a pro se litigant. What's really the concern here? Is the concern filing the appearance, or is it doing justice? And so the Supreme Court said, let them have their case in court. And so it was a good lesson for me, and a good lesson for any judge, I think, and that is what you're really concerned about is justice in the courts. And that's why there is the second rule in the circuit court rules is that court rules can be waived in the interest of justice. And that's when judges do waive the rules. And it's important because that's what the ultimate objective is. It's an objective, it's fairness. And so to say that you cannot waive rules would be unjust. And that's something that I don't think your committee wants to do. And frankly, if there's any time you probably shouldn't waive rules, it's regard to fees. But that's another whole issue that we won't necessarily get into today. Anyway, that's my testimony. Be happy to answer any questions.
Thank you very much for your testimony, Representative. Are there any questions? Seeing none, thank you very much.
Thank you.
The chair will call Representative Lynn.
Thank you, Madam Chair. Bob Lynn, I'm a state representative from Wyndham, Rockingham, District 7. And I just want to testify very briefly. To echo what Representative Gordon had said, I think this would really be a very bad idea. I mean, as Senator, I think you gave really just an example of the kind of things that happens all the time in the courts where judges are doing justice by making some exceptions. I mean, to strict compliance with the rules based upon the circumstances. And, I think particularly at this time, when I first became a judge, started out, the rule was basically, if a party appeared pro se, that party got treated exactly, you didn't know the rules, that's too bad. You were supposed to know the rules, you didn't know the rules, too bad. But and in many cases, that really could result in injustice. We've come to learn that, and over time, it's now the case that judges very frequently, particularly with pro se litigants, and in an effort to ensure that justice is done, will cut the pro se litigants some slack. I mean, a perfect example of that is leading questions. Well, there's a rule of evidence that says you're not supposed to ask leading questions except on cross-examination. Well, there are a lot of pro se litigants that haven't the foggiest idea what the difference is between a leading question and a non-leading question. And the judge could spend, I mean, we could literally the judge could either handle the case and try to ensure that justice is done, or conduct a seminar on the law of evidence. And so most of the time, most judges will decide it makes much more sense to let the litigant ask, the pro se litigant ask a leading question. It obviously, to the extent that the judge has unsustainably exercised his or her discretion, there is a record. The court proceedings are recorded, and if somebody thinks that that there's really been a miscarriage of justice, there's an opportunity to appeal the decision. So I really do think that this, I think that the extent to which judges waive rules in the interest of justice, particularly with pro se litigants, but sometimes in other cases too, it happens. It really sort of happens all the time, and I'm not aware of I don't want to say that judges never make mistakes. Of course they do. I mean, that's why you have appellate courts. But the idea that there's sort of a wave of judges really waiving rules inappropriately, or sort of unsustainably exercising their discretion to do that, I'm not aware of it, and I don't think that you've heard any evidence to, other than sort of anecdotal story, but I don't think you've really heard any evidence to suggest that that kind of thing happens in any kind of sustained way. And so I just think it would be a very bad idea to enact this legislation. And I'm happy to take any questions.
Thank you very much, Representative, for your testimony. Are there any questions from the committee? Seeing none, thank you.
Thank
you. Okay, the chair will call Richard Head.
Good afternoon, Madam Chair, members of the committee. My name is Richard Head. I'm the Government Affairs Coordinator for the Judicial Branch. I'll first talk about the bill that's actually in front of you, which is has crossed over, which would create a family division rules waiver database. This amendment, this bill as it's presented to you, as you've heard, is not the bill as was presented. The original bill was to prohibit all waiver of any family division rule. I'll also remind you that family division is not just parenting. It's domestic violence. There's about a dozen different areas that we're talking about when we're talking about family division. We're talking about termination of parental rights. We're talking about surrender, abuse and neglect, children in need of services, juvenile delinquency, adoptions. So the rules that we're talking about are not just parenting, but it's everything that is covered in family division. Family division, and this bill as it's being presented to you was first disclosed, the first I heard about it was in the executive session. So it was presented as an amendment to the original bill in the executive session. I think I attended every committee hearing. I answered questions. I was participating actively in that committee throughout the first part of the session. I never heard about this bill. Nobody ever asked the judicial branch, could you even create a database that tracks a waiver of every rule? And I would have said, probably not, because, again, to put this into context, what we're talking about is one division of circuit court. So we have district division, probate division, and family division. Circuit court generally hears about 150,000 hearings a year. Within family division, we're talking a little over 40,000 hearings every year. We have 25,000 new or reopened cases just in family division every year. We have a huge volume of cases. What this bill would require is that a judge enter into the court record. The court record we're talking about, the record is the recording. enter into the record. So presumably say, I'm waiving, judge's got to figure out what rule he's waiving. He's actually, he or she is waiving a rule, put it into the record. And then this bill would provide that the clerk has to go through the record, identify all the waived rules, and enter it into this new database that we do not currently have. So in theory, the clerk or clerk's designee has to listen to 7.5 hours of hearing testimony, figure out what rule was waived, and put it into the database. I've now taken somebody in staff out for an entire day so they can listen to 7.5 hours of testimony. Rules are not only waived in a hearing. Rules can be waived in paper. So there's added on top of the 40,000 hearings, some of which can be days and days. We're talking about 25,000 cases which have motions, things like that, that have maybe a attestation that is not completed. A waiver may occur on paper, so then a clerk has to figure out what may have been waived on paper and enter it into this database that does not exist. Huge, huge amount of work we're asking for on data that we do not currently collect. And then you get into what are you going to learn from this? Because what is supposed to be entered is the rule number waived, the reason for which it was waived, who the waiver favored by identifying if it was the plaintiff or the defendant. Some of these cases have more than a plaintiff and a defendant, by the way. They have other parties, so I'm not sure what we're talking entirely about. We also, in a marital case, I'll stick with a marital case, it's filed not as plaintiff versus defendant, but in re John and Jane Smith. The first one becomes the petitioner, not a plaintiff. The second one becomes the defendant. It's basically the order of who's named on the pleading becomes the plaintiff and defendant. So you're going to learn that somebody who is identified as the plaintiff had a rule waived, the rule being waived that they weren't required to stand when addressing the court. So that's a rule. So they waived that rule. Somebody's got to put it into this database. You'll learn that the plaintiff was allowed to stand. You all know who the plaintiff is. You all know anything about the plaintiff. The other thing that's also interesting is if you look at the very few cases out of family division that Rule 1.2 is involved, as you heard from Judge Gordon, some of those involved the failure to waive a rule. So should we also have a database for every rule that we did not waive? Because some parties and those also get overturned on appeal. So it is, one is, it is work we don't currently do. It is incredibly labor-intensive work. It is not going to reveal anything, and it has to go into a database we do not currently have. I did check with our IT people as to whether or not what we have, which is a case management system called Odyssey. The case management system is designed to manage caseload, to keep the trains running on time, to make sure everything's happening the way it's supposed to. It is not a policy database. What we could do in that is there are a couple blank fields. We could probably figure out a way to put in a plaintiff defendant's already in there. What rule was waived? The reason would just be a free-floating form because we don't have a Dropbox of reasons why rules are waived. So you're going to get sort of this thing that says a rule number was waived and a plaintiff or defendant it was in favor of, and a text about why it was waived. I'm not sure you're going to learn anything from that, but if you want an actual database, it's going to be a brand new purchase where it has to be licensed statewide, whatever that may be. And as the rule says, it has to be accessible by Senate President, chairperson of the various committees. It is a huge undertaking which is being asked here for information that is not going to reveal anything about court process. I say all of that with the caveat that I really understand and appreciate that as the legislative body, as policymakers, would love to have information that probably flows through the court system. I think it would be very useful to have a discussion, not an imposed bill, with the judicial branch and the legislative branch and the relevant policy committees as to what do you need as policymakers that flows through the court system? Is it something we capture currently? Generally, the answer is probably not. And then is it worth adding a resource to the judicial branch to be able to provide you with policy-related data that you can then use to develop policy? I suggest that as a cooperative venture that could occur between the two branches of government. I think this particular bill is, one, not going to accomplish what the sponsor is predicting it would accomplish. I think it would be confusing, and the resources we're talking about is essentially putting a court monitor in every courtroom. We're talking about $2 million to do that. We are talking about purchasing a new database that would somehow capture this, and it would send out information that is not going to in any way provide you with information that will help you as policymakers. As to the proposed amendment to bring back essentially the original bill, it is, I won't repeat what the two judges have said, it just is not functionally, it doesn't function that way, and it's not the way the courts can function. I raise again, we have a rule that would say, please stand when you're addressing the court or questioning a witness. If we can't waive it, what does that mean? And it says you can't waive any rule. I did talk to a couple of the representatives about, is there a rule that you actually care about so that we can maybe address a specific rule? And at least one representative said to me, I couldn't get past the fact you can waive rules. I didn't read any of the rules. The problem with that is, just as a matter of sort of legal principle, if you're going to be allowed to waive rules, you got to have a rule that says you can waive rules. So, for example, there's a statute that applies to the executive branch, 541A. There's a line in there in A22 that says, if you want to waive a rule, you have to have a rule that waives it. That's what we have. Our mistake was probably to put it at the front instead of the back. But you see waiver of rules through executive branch rules, and ours do it too. It does have, as you heard from the judges, a role relative to achieving justice when necessary, as opposed to strict compliance with the rules. With that, I'll conclude my remarks. Be happy to answer any questions.
Thank you very much for your testimony this afternoon. Are there any questions from the committee? Senator French.
Thank you, Madam Chair. Thank you, Mr. Head. So just to get this straight in my mind, you're in opposition to this?
I think that's a fair. Thank you for the question. Yes. If I didn't make that clear, I should have started with that, which is a failure of mine.
Are you concluded with your testimony?
Well, I've been handed a note that suggests I was not completely, well, I'm actually not sure what it says, so I won't try to.
Representative, just for future reference, we don't do that here, okay? Okay, thank you very much, Mr. Head, for your testimony. The chair will call Dan Itza.
Thank you, Madam Chair, members of the committee. I do rise in support of this legislation. I was at the hearing in which the original bill was introduced, and one of the things that I was astounded by was that there are more than 250 family court rules. And the idea of just simply saying none of them can be waived, when I'm sure that nobody in the room knew all the rules, knew what the implications of saying you could not waive any rules. During my years on the committee, one of the things that one saw in what we now call complex cases is at least the allegation, and sometimes it was very obvious, that the rules are waived in favor of one party or the other, very consistently, and it created an uneven playing field in the courtroom. And that is a problem, because one of the things you're supposed to have in the courtroom is an even playing field. The statement was made that you learn nothing, and I disagree with that. You would be able to see patterns. Is there a rule that is consistently waived? If there's a rule that's waived 90% of the time, it's probably oughtn't be there because it's a problem. If there is a court or a judge that seems to consistently waive rules more than the others, or a particular judge that waives rules in favor of only one party in a particular case, that's a problem. It would capture that pattern. And it's the patterns that are important to see. The other thing that it would do is when people are making a filing for a reconsideration or an appeal, and part of their appeal is that the rules were waived unfairly, if there's no record of why the rule was waived, they have nothing to stand on. And so by requiring that parcel of information, you would give people who have a complaint something to stand on, whether it's before the Judicial Conduct Committee or in a reconsideration or an appeal. And I think that's extremely important. Even if you don't go so far as to create the database, which I think would be very useful to you and the other chamber, at least requiring that the cause for the waiver be recorded in the proceedings ought to be done. I'd be happy to take any questions.
Thank you very much for your testimony. Are there any questions from the committee? Seeing none, thank you very much. Are there any other members of the public that would like to speak to House Bill 1265? Okay, seeing none, we're going to close the public hearing. The committee will be in recess until 4:15. Yeah, we'll be in my room, in my office. Yeah. Yep. Yep. Turn them off? Oh, okay. Okay. Jenny. The committee will come out of recess. Can I get a motion to go into executive session? So moved. Moved by Senator Whitley, seconded by Senator French. Okay.
We got a team going here.
Yes, we've got the team going. Okay, the first bill that I would like to take up is House Bill 1673 FN. And I will make the motion of ought to pass.
Second.
Seconded by Senator Gannon. Is there any discussion on the ought to pass motion?
I appreciate that. I think it's the right thing to do.
Okay. We have an ought to pass motion. All in favor say aye.
Aye.
Aye. Any opposed? Okay.
Move consent.
Okay, Senator French moves consent calendar. Is there a second?
Sure.
Seconded by Senator Gannon. Is there any discussion on the consent calendar motion? Seeing none, all in favor say aye.
Aye.
Any opposed? Okay, I'm going to do what I did on Tuesday. Any bill that goes on the consent calendar, I will be responsible for the blurb, because it's just easier for Jenny to deal with one person instead of chasing everyone down, especially today. Yes, okay. Next, we have, and I'm going numerically, House Bill 1607 FN. I would like to move ITL on this bill. 1067.
1067, yeah.
1067. Is there a second?
Second.
Seconded by Senator Gannon. We have absolutely no testimony whatsoever on this bill.
Yeah.
So just for that reason only, the bill should be ITL. And I'm going to ask Jenny to, when you write the blurb, please write that we had no testimony whatsoever on this bill. Okay, so we have a motion of ITL on House Bill 1067. All in favor say aye.
Aye.
Any opposed? Okay. Is there a motion for consent?
Move consent.
Second.
Senator French moves moves consent. Senator Whitley second. Okay. Is there any discussion on the consent calendar motion? Seeing none, all in favor say aye.
Aye.
Aye. Any opposed? Okay. Okay. Next, we have House Bill 1265.
1265.
This is, we heard this relative to the waiver of rules.
Motion to ITL.
Okay, we have a motion to ITL. Is there a second?
Second.
Seconded by Senator French. Is there any discussion on the ITL motion? I think the testimony we heard, it really would constrain judges. They need to have flexibility with these rules. And the discussion about creating a database, I think, is fairly expensive. And we had testimony that it's not going to accomplish what people would like to have happen. I just don't think that this is the way to get to what people would like.
Yeah, and I think the flexibility really is necessary, particularly for our pro se litigants, and there are a lot of them in the family division. So I think, for that reason.
Okay. So we have a motion of ITL. Is there any further discussion on the ITL motion? Okay, seeing none, all in favor say aye.
Aye.
Aye. Any opposed? Okay, is there a motion for consent?
Move
So moved.
consent.
Moved by Senator Whitley, seconded by Senator
No,
French.
I move that be a second. No.
I'd be glad to second
Senator,
that.
it's late in the day, please.
Yes, seconded, please.
Okay. So is there any discussion on the consent calendar motion? Seeing none, all in favor say aye.
Aye.
Aye. Any opposed? Okay, and I'm doing this one as well. Next, we have House Bill 1325, dealing with the release of confidential records.
I'd like to move interim study on that.
Okay, so Senator French moves interim study. Senator Gannon seconds.
Yeah, so I just want to, I certainly see the need to sort of evaluate this issue in the context of the supported guardianship, but I feel like we need to look at that a little further.
That's why we think interim study is an appropriate motion. I think that the idea has merit, but it needs more work. Okay. So we have a motion of interim study. Is there any further discussion on the interim study motion? Seeing none, all in favor say aye.
Aye.
Any opposed? Okay. Is there a motion for the consent calendar?
Moved.
Moved by Senator Whitley, seconded by
Seconded
Senator
by-
French.
Yep. You know your place.
Is there any discussion on the consent calendar motion? Seeing none, all in favor say aye.
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 Any opposed? Okay. Next, we have House Bill 1346, an act establishing a commission to study the New Hampshire family court system.
So once again, I think this is important, but I don't think it's ready, and I'd like to move interim study.
I'll second that.
Okay. Moved by Senator French, seconded by Senator Whitley. I would agree. One thing I found kind of disturbing was the fact that this commission was going to get access to court records, individual court records. This is family court, you're dealing with juveniles, and there are laws protecting privacy. So I just think this bill is not ready to come forward at this particular time. It needs more work.
I'm sorry I missed that testimony, but Senator Whitley brought me up to speed on it.
Good, okay. So we have a motion of interim study. Is there any further discussion on the interim study motion? Seeing none, all in favor say aye.
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 Any opposed? Okay. Is there a motion for the consent calendar?
So moved.
Moved by Senator Whitley,
Seconded.
seconded by Senator French. Is there any discussion on the interim study motion? Seeing none, all in favor say aye.
Aye.
Any opposed? Okay. All right, there we go. Next, we have House Bill 1515, an act relative to the Guardian Ad Litem report requirements.
Motion for ITL.
Senator Gannon moves ITL.
Second.
Senator French seconds. Is there any discussion?
Yeah, I think I've practiced in this area, and I think that the GALs really do act as the eyes and ears of the court. They do have their own unique perspective. I think limiting their ability to provide that additional perspective, I think that's really problematic. We don't want to take tools away from our incredibly busy courts that are trying to do the best thing for families. I know it's a really difficult area, but I think the role of the GAL has to be preserved.
I obviously I was trying to draw a parallel in my mind between a CASA guardian ad litem. It was helpful to hear what people were trying to draw as the difference, the greater training that the volunteers receive versus the lesser training that the paid GALs have. But taking those roles away from a GAL, that just doesn't, it's counterintuitive to what the definition of the role is. And so I would support the motion as suggested.
Okay, thank you. Any other comments? I agree. And what I think is interesting is, we're dealing with family court, which tends to be very emotional. And someone is always going to feel that the judge didn't listen to me, or this happened, or that happened. And the GALs are trained. And I think that that's the operative word here. They're just not people that are just pulled in off the street and doing this work. They're people that are trained and they have experience. And are they perfect? Do they make mistakes? Of course they do. But they're always out for what's in the best interest of the child. And usually that means sometimes it pits one parent against the other. And this is where the judge comes in. So I think we have a system. I think our system works well. I just don't think, again, this bill is just ready to move forward at this time. So, okay, so we have a motion, I believe, of interim study.
ITL.
Oh, ITL, okay, ITL, just want to make sure here. Okay, so is there any further discussion on the motion of ITL? Seeing none, all in favor say aye.
Aye.
Any opposed? Okay, is there a motion for consent?
So moved.
Moved by Senator Whitley, seconded by Senator French. Any discussion?
Well, quickly, with me.
Seeing none, all in favor say aye.
Aye.
Any opposed? Okay, all right, Jen. Okay. Next, we have House Bill 1520, an act relative to procedures for guardian ad litems.
So I would like to make a motion of this of interim study. It's great that they are doing this, or they thought that this would be a good practice, and they're instituting it in their rules, and to make sure they're going to institute in their rules, we'll interim study this, and we won't have to codify it. That's my opinion.
Second.
Okay, so seconded by Senator Gannon. Senator Whitley?
Yeah, I think, it's a pretty specific procedure, and I think it's more appropriate for rules rather than the statute.
I agree completely. The letter that I received from the board chair said that they will be updating their administrative rules to reflect that the GLs are required to provide itemized bills. So let them go through that rulemaking process, and the folks that put this bill forward, hopefully they'll be following it. And if there's an issue, that I'm sure we'll see this issue again. So we have a motion of interim study on House Bill 1520. Is there any further discussion on the motion? Senator Khan?
Among those that we're ITLing or interim studying, this is the most likely to be on the cusp for me. I think they made a good point.
I would agree with you, and if I hadn't gotten the letter, I'm sure you have gotten the letter.
I didn't see it in advance, but that's just me. It's okay.
I was going to say, I have it here, that they are going to, they're going to be going through administrative rules to deal with this. So, and I happen to know who the board chair is.
Or it's already in their policy, right? Didn't they say they're making a policy change?
Yes.
They're not even going through JACR, they're doing it.
So they're going to do it. Let's give them the opportunity to do that. Because I think, again, it's about the flexibility that they might need flexibility in order to do this, rather than us having the statute, but we've given them no direction on how to do it. We're just saying you have to do it, but what does that mean? What does that look like? So I'd rather give them the opportunity to do what they're going to do. We will hear about it, and if it doesn't meet a standard or someone's not happy with it, another bill can be filed. So let's give them the opportunity to follow through. Okay, so we have interim study. Is there any further discussion? Okay, seeing none, all in favor say aye.
Aye.
Aye. Any opposed? Okay, is there a motion for the consent calendar?
So move.
Whoa. Oh, second. That took me back.
Oh, game is
I'm retiring. I'm retiring.
Our chair was so convincing.
That was like slapjack.
Yeah. It was really.
Oh my goodness.
War. There was war.
Senator Khan moves consent, seconded by Senator Gannon. Is there any further discussion on the consent calendar motion? Seeing none, all in favor say aye.
Aye.
Any opposed? Okay. Next, we have House Bill 1612, an act relative to the confidentiality of reports made to the Division of Children, Youth, and Families. Is there a motion?
Okay, let me.
Interim study.
Okay, Senator Gannon moves interim study. Is there a second?
I'll second.
Okay, seconded by Senator Whitley. Discussion.
I'd like to find it here.
I know that there is concern about false reporting, but we have a system, and that system depends on the anonymity of someone being able to make a report, and without fear of retaliation. That if there is a family member that's abusing their child, or there's something going on, that they feel comfortable enough they can pick up the phone and make that complaint without having to worry about some sort of retaliation. And I think we all know that people do file reports. Sometimes people think that abuse is going on and they'd rather err on the side of caution. And that's okay too, because we're talking about the health and safety and welfare of a child. And I think we should err on the side of caution for those children. Senator Whitley?
Yeah, I think there has been a lot of work, that has happened to try to get people to know that they're mandated reporters. I think we still actually have a lot of work to do in that area. If our priority is really protecting children, we need to be encouraging those mandatory reporters. And I am a little worried that, adding penalties will undo some of that work when our priority really should be, getting those reports and, making sure that children are protected. So that's why I think an interim study, I think we need to really think about undoing that work to, we need to be encouraging people to make those reports
Right, rather than putting a barrier for them. And what's to say that someone who's calling in is going to give their real name? How do you verify that they are who they say they are?
Yeah, the other thing is that, we have a emerging prevention system in DCYF. We have this new system where there doesn't have to be a finding to get services. And so, but we still have to know about the family so that, we don't want to prevent families getting in to get prevention services to prevent abuse and neglect.
Yeah.
So, yeah, go ahead.
Well, the access to voluntary services is really important. And if this is a key to that contact with the family, then amen.
Yeah.
I was disturbed with the statement that 83% of the claims are falsely reported.
I don't know where that number came from.
It came during the testimony.
Yeah.
And
That may be the number that are not founded.
Right. That right, and that makes
And
sense.
they're unfounded, meaning that a complaint was made, an investigation was done, and it was unfounded. So I think that might be a little.
There's a difference between not enough evidence.
Yes.
Right, and those unfounded reports, those are the ones that are going to voluntary services.
Right, where they might be something, but it doesn't rise to the level of intervention, but they realize that the family might be struggling or they might need some help, and that's why they're offered voluntary services. And that's exactly what it is, it's voluntary.
Yeah, yeah.
They can choose to take whatever advice they're being given and avail themselves of the services, or they can say, we don't want it. There's no requirement that you have to do that.
so it's just an impression that, and maybe because you see these folks in health, human services, to pass along that maybe they need more granular reporting than just allowing this kind of claim to maybe have some basis of definition for the person that brought it forward, that they need more granular reporting that would be helpful for the legislature to understand.
We didn't have DCYF here on that, so.
No, we didn't. That was
Yeah,
disappointing.
and that's the other thing. I think there are missing pieces here, but I think the idea that everyone's used to the idea that if I see something, I can make a phone call
Absolutely.
and it's anonymous. But it's like everything else. This is a family issue, and it tends to be emotional. And people will use the legal system against the other person to punish them. And unfortunately, I think that happens way too often. But how do you just ignore those types of complaints and then something happened to a child? I mean, I don't think we want to put ourselves in that position either. So I do think this bill needs some more work, and they need to flesh it out a little bit more.
So what's the motion?
You'll,
Interim study.
was interim study.
Interim study, okay.
Okay, so we have a motion of interim study on House Bill 1612. Is there any further discussion on the interim study motion? Okay, seeing none, all in favor say aye.
Aye.
Aye. Any opposed? Okay, is there a motion for the consent calendar?
So moved.
Moved by Senator Whitley, seconded by Senator French. Is there any further discussion on the consent calendar motion? Seeing none, all in favor say aye.
Aye.
Any opposed? Okay,
Sharon, why don't you take that one out?
I'm going to. And the last one we will take up
We have one more.
is House Bill 1614, an act requiring the recording and storing of digital video in all state-funded juvenile detention facilities.
Move on to pass. Second.
Okay, moved by Senator French, seconded by Senator Gannon. Is there any discussion on the ought to pass motion?
I think this is important. I think, we're moving into more of accountability space with these kiddos, and I think this is important.
I think it's, the only concern I had was the storage.
Right.
But technology continues to improve as time goes on.
Yep.
So I'm sure that they will find appropriate measures for saving the video. So we have a motion of ought to pass on House Bill 1614. Is there any further discussion? Okay, seeing none, all in favor say aye.
Aye.
Aye. Any opposed? Okay, is there a motion for the consent calendar motion?
So moved.
Moved by Senator Whitley, seconded by Senator French. Is there any discussion? Okay, seeing none, all in favor say aye.
Aye.
Aye. Any opposed? Okay, Jen, that's me. Okay, I don't believe there's anything else to come in front of the committee. I think we're done. Thank you all for being here this afternoon. We did a lot of work today. And we will meet again on Tuesday. You have an amendment, that's why we didn't, because we want to,
I'm glad to,
we're going to.
I just wanted to
I
call
wanna
to
make
your
sure we have
attention that I've distributed it. We can
Yep.
talk about it.
So I just figured it's one of those we're going to talk about, so. Okay, so is there a motion to come out of executive session?
So moved.
Moved by Senator French, seconded by Senator Whitley. All in favor say aye.
Aye.
Aye. Any opposed? Thank you all. Please turn the lights off. Okay.